I declare open this hearing of the Senate Economics Legislation Committee into the 22-23 supplementary budget estimates. I begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee has set 3 March 2023 as the date by which senators are to submit written questions on notice, and 31 March 2023 as the date for the return of answers to questions taken on notice. The committee's proceedings today will begin with the Australian Securities and Investments Commission. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The Senate has endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees, unless the Parliament has expressly provided otherwise. The Senate has resolved also that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Witnesses are reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. I incorporate the public immunity statement into the Hansard. I remind all senators that as we continue our work implementing the Set the Standard report, as chair, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. An officer called to answer a question for the first time should state their full name and the capacity in which they appear. I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome Senator the Honourable Katy Gallagher, Minister for Finance. Welcome, Minister. And the committee also welcomes the Australian Securities and Investments Commission and its representatives. Good morning, Chair Longo. Good morning, representatives. Chair, I thank you for your written opening statement, which the committee will table. And would you like to make your opening statement?
Yeah, thank you, Chair. Good morning to the whole committee, and thanks for this opportunity. I will read the statement. It's brief and it's in accordance with my usual practice. I'm pleased to appear before the committee today. I'm joined today by Deputy Chairs Karen Chester and Sarah Court, Commissioner Daniel Press, Chief Operating Officer Warren Day, Executive Director of Strategy Greg Kirk, and our General Counsel Chris Savundra. We value the opportunity, as always, to appear before this committee. You'll be aware that Sean Hughes has recently finished his term at ASIC, and I wanted to take a minute to acknowledge Sean's contribution. Sean has had a long career at ASIC and has served as Commissioner at ASIC since 2018. Sean has contributed to ASIC's work on a range of issues, including responsible lending and BNPL regulation, climate-related disclosure and sustainable finance, among others. We are grateful for the contribution Sean made to ASIC in his role as Commissioner and wish him well in the next stage of his career. I know you will have questions on a range of topics, which we welcome. I thought I'd just highlight a couple of important topics for this morning. As you would be aware, ASIC last week shared with staff the proposed top-level structure coming out of our organisational review. There will now be a consultation process on the proposal with senior executives and then with all levels of staff in March. We anticipate the agreed new structure will start to be implemented from 1 July 2023. We will, of course, advise everyone of our revised structure once it is finalised, and we'll publish it on the ASIC website. The focus of the new proposed structure is to support ASIC in achieving our strategic and operational ambitions. There were recurring themes during the review, which included stakeholder feedback from past reviews, including the Financial Regulatory and Assessment Authority's report last year. Some key themes included timeliness in decision-making, collaboration and coordination, a better alignment of strategic priorities and resource allocation, and risk appetite and risk management. The proposed structure brings a strong focus to 4 regulatory areas: intelligence gathering, transformation and technology, regulation and supervision, enforcement and compliance, and of course markets. The structure allows our intelligence about individual matters to flow more quickly to enforcement teams, which will allow us to pick up misconduct earlier and address potential breaches where we see them. We released our quarterly report yesterday. The report highlights actions taken during the last 3 months of 2022 and outlines the full list of enforcement priorities for the year ahead. The quarter saw ASIC commence a number of significant enforcement and regulatory actions to address misconduct and consumer harms in a range of sectors. This includes corporate governance and directors' duties, product design and distribution, and misleading statements involving sustainable finance practices. Importantly, this report includes ASIC's initial version of a regulatory developments timetable, which outlines proposed timeframes for the regulatory work ASIC is initiating. It aims to assist stakeholders with forward planning of their own work. It is one of the initiatives that ASIC's Regulatory Efficiency Unit identified through stakeholder feedback, and we are implementing it. You will have seen in the media the continuing interest in ASIC's enforcement work in relation to directors' duties. There is, of course, a limit to what I can say about ASIC's investigations and court matters, but I will say that we take these cases very seriously and look closely at whether we have sufficient evidence to bring an actionable case. I've spoken before about the challenge for regulators to make sound investigation and enforcement choices. In making these choices, we need to be strategic, and we need to balance the evidence, facts and the public interest in order to maximise our regulatory outcomes. Finally, I wanted to mention our Indigenous Financial Services Framework that we published on Tuesday this week. I'm very proud of this work. It's the culmination of years of collaborative work and a First Nations-led process that I believe is a first for ASIC. The framework outlines key learnings developed through extensive consultation about First Nations people's access to and engagement with the financial system. We are sharing the framework broadly so our stakeholders can consider and use the key learnings to support positive financial outcomes for First Nations peoples. We've appreciated being led by First Nations peoples in the development of the framework, and we see it as an opportunity to continue including this engagement in developing ASIC's priorities that affect First Nations people. I encourage you to take a look. We look forward to answering the committee's questions, and I thank the Chair for letting me read the statement. I think it's a good thing to do. Thank you.
Thank you very much, Mr Longo. We will now proceed to questions, and Senator McGrath.
Thank you.
Is that what you meant to? Sorry,
Oh, do
let
you
me
want to
just
go first?
clarify.
No, why don't you go first?
Okay.
I'll go second.
Senator McGrath.
What's your? Can you remind me what your budget is for this current financial year?
I think it's around 450 million. Mr Day, could you confirm the numbers?
If we don't include for the sake of Hansard, Warren Day, Chief Operating Officer at ASIC, Senator, if we don't include the enforcement special account, it's approximately $420 million.
And that comes from the government via taxpayers, via the government, or as part of that budget include some cost recovery?
No, so we're funded from an appropriation from government. We have some cost recovery through our industry funding model, and that's not the full amount of our appropriation. That's somewhere, I think, around about $250 million. Okay.
So basically, you're funded by the taxpayers?
I'll revert to what the answer I just gave, Senator.
So, Chair, not you, Chair, Chair there. I'm sure you're aware of the January 23 article in the Australian Financial Review that was entitled "Inefficiency and Gotcha Questions Are Wasting ASIC's Time." You aware of that article?
Yes, I am.
Okay. Is everybody at the table aware of that? I'm happy to table a copy.
I must have missed it, Senator McGrath. I'm an avid reader of the Financial Review.
I commend Ronald Liz, and
that
I'll
one.
table copies of that to assist the committee. And I realise, Chair, you're a very busy and important person, and the last thing you want to do is waste time dealing with politicians and their questions. But so Do you agree with the outgoing Commissioner, Sean Hughes, that oversight of ASIC is inefficient and resource intensive?
I'm aware of the article. What I said in the article was that I welcome accountability. It's a very important aspect of the work we do, and indeed we're no stranger to it, and I won't repeat what I've said at previous hearings about the accountability framework and our engagement with it. As for the remarks attributed to Mr Hughes, they're his views, and the views I have are the ones I've just expressed.
But do you think it's appropriate for Mr Hughes, who's moving on to employment with a $10.5 trillion investment giant, to make these public comments while an ASIC Commissioner?
That's a matter for him.
Well, were they approved by ASIC? Was there any formal process for the
They're his
Commissioner
views.
to make
They're
those
his
views? Sorry?
I'm sorry, Senator, they're his views.
They're his views. So they're not. So they're his views as a Commissioner of ASIC.
At the time he expressed those views, he was clearly a Commissioner of ASIC. That's true.
But was there a process for him to express those views? Because we've got a Commissioner of ASIC who clearly doesn't like that ASIC, which is funded by the taxpayers of Australia for hundreds of millions of dollars, coming before the Parliament of Australia and being held accountable. So I'm just trying to get it here that we've got a Commissioner of ASIC who doesn't like being held accountable.
We have a former Commissioner of ASIC who doesn't like
Well,
to be
he
held
said
accountable.
he said those comments while he was a Commissioner of ASIC.
Yeah. So,
So
Senator,
I am trying to ask questions as one of those painful
Senator,
politicians who will come here with respect,
Yes.
and I will raise issues
Yeah.
on behalf of my constituents, which you don't seem to like.
Senator, as I said in my opening, the Commission, me included, everyone here at the table wants to be helpful and answer the questions of the committee on the various topics that may be of concern. I acknowledge that the views held by former Commissioner Hughes, they're his views, they're not the Commission's views, and so I'm here today to be of help and to the committee, as indeed are all the commissioners.
But he gave those views while he was a Commissioner. So did he seek approval to conduct the interview? Did he seek approval to have the interview?
I was aware he was going to give an interview.
Did he tell you what he was going to say in the interview?
No.
Isn't it embarrassing for ASIC? Because it does reflect, my view, Chair, is it does reflect upon ASIC that you regard that the comments of, I'm going to say Commissioner Hughes, because he said them as a Commissioner, reflect upon your organisation and the good work that your organisation does do.
Yes.
That it reflects an attitude within ASIC that you don't like parliamentary oversight.
They were Commissioner Hughes' views. They do not reflect the views of the Commission or ASIC. We have always been very cooperative and engaged constructively with all the committees of the Parliament, and not just this committee, but the House of Representatives Economics Legislation Committee and the Parliamentary Joint Committee on Financial Services and Corporations. We also work closely, obviously, with the Financial Regulatory Assessment Authority and their other mechanisms. So I really want to reassure you that I can understand why those remarks would not be deemed to be appropriate by you, but they're not the views of ASIC or the Commission. We've always constructively engaged with all the committees. We try to answer all the questions on notice in a timely and substantive manner. So I'm not sure I can take it any further for this morning's purposes.
Can you, because the article writes of the significant impost that the estimates process places on ASIC staff. So I suppose on notice, I'd like to dig into that in terms of how many days or how many hours that you and commissioners and deputy commissioners and so forth have spent at estimates, but also how many hours have been spent in preparation for estimates. And the article goes on to complain that that Mr Hughes recalled that the whole ASIC Commission, the board of the Prudential Regulator, senior executives from both agencies and senior executives in Treasury were kept loitering in a Senate ante-room for 4 hours as a committee hearing dragged over time, which of course we do apologise. That estimates committees do sometimes run late, and the minister knows that. But accountability and transparency doesn't run like clockwork sometimes. But if you could particularise the costs of appearing before estimates, because it's clearly something that exercised your former commissioner, and I think it would assist us in terms of how we can better assist you in the performance of your duties. And the final thing I'd like to say is I was particularly concerned where he talked about the impact, the questions about some company in remote or rural Australia. Now, Wacker Williams, or Senator Williams, who would come in here on a regular basis and ask such questions. So I just hope that there was no thought process within ASIC that those in rural, regional, remote Australia are perceived to be treated differently from those who might live in urban Australia.
No, absolutely not.
So, Senator McGrath, did you ask that on notice ASIC put resources and time into providing answers on how much resources and time they put into preparing for Senate estimates? Because I'm not sure that is a good use of ASIC's resources and time, to be honest.
We've got an article here.
I saw it, and I do recall this actually, and I had a little.
And I
think we could all relate to the some of the inefficient side of Senate estimates at times, but it's about a former commissioner in an exit interview, which the chair has said did not reflect the views of ASIC. So I guess I'm trying to be reasonable, and I'm sure ASIC is very happy to assist, but honestly, is that where we're going?
Yeah, it is where we're going, Minister, because I often find that when people are giving exit interviews, that's when they actually do tell the truth.
Well, it may be his truth, but the chair said it doesn't reflect the views of ASIC.
But he gave the interview while he was a commissioner of
in an
ASIC.
Exit interview, it said here.
But and to me, for whatever reason, that concerns me as to what the attitude within the organisation with me may be. And I do, Chair, take your comments. So I do want those questions answered in terms of the chair also made comments about, I think, Chair, about I think there's a legitimate question about how much oversight is really necessary and productive, and Chair, that is a comment from you. Yeah. So I'd like to find out if it's such a burden attending at estimates, actually how much of a burden is it?
Yeah, on that last observation, I think on the last occasion, I think it was before this committee, I thought it was helpful to that committee, because I think we'd met for the first time, to describe the accountability framework. So absolutely accept that we are accountable to Parliament and to committees such as this, and we take it very seriously. I hope we're here, and I think we go to a lot of trouble, as we should, to answer questions properly. Having said that, I think it's also reasonable for there to be a contextualisation of that process. There's this committee, and as I've said, there's a House Economics Legislation Committee, and there's a committee actually that is specialised just for us under the ASIC Act since 1991, the Parliamentary Joint Committee on Financial Services and Corporations, which is our primary oversight committee, and that meets 4 times a year for a day. We also work with, and very constructively, as I think the first report demonstrated, with the Financial Regulatory Assessment Authority. and there are other inquiries going on at the moment and other mechanisms for ASIC to be transparent and accountable. So all I was getting at was that that's quite a comprehensive framework, and we're also accountable through the industry funding model that our Chief Operating Officer alluded to, and that's also quite an intensive process, and once a year we invoice industry and we're accountable for, it's a very prescriptive regime, but we're accountable for what we do and how we charge for it. So I think all I was saying, pardon me, all I was saying was if you step back, that's quite a comprehensive framework of accountability, and that's the only point I was making.
Well, just one final, you may wish to take this on notice to assist the smooth running of the committee. If you think there are better ways to improve the accountability of ASIC, I'm sure this committee or Parliament would welcome the contributions from ASIC, realising the separation of powers and the role that we have to play in terms of holding the executive to account.
Thank you, Senator McGrath. Before I move to Senator Bragg, the committee will table the article that you were referring to, and I advise senators that we'll move in 10-minute blocks. Senator Bragg.
Thanks very much, Chair. Good morning.
Morning.
Just picking up on Senator McGrath's line of questioning there was a statement in one of those financial review articles that said that the ASIC chairman gave an abject apology for an emotional outburst and that there was a Treasury inquiry into this matter. Is that accurate?
I certainly gave an apology following a meeting of the Enforcement Committee in connection with two matters. As to the process that followed, that was a confidential process, but I can ask Mr Day or Mr Savandra to speak to that process if the committee would like to know more about it.
Well, I guess just for efficiency, I mean, is it true that there was a Treasury inquiry into it?
The matters that you're referring to were an assurance review performed by the Treasury.
What and under what act?
I might just defer to Mr Savandra.
Probably a question you should have asked Markets Group yesterday.
Yeah.
Well, let's see where it goes.
Mr Savandra, could you move your nameplate? Thank you.
Thank you, Chair. For the Hansard, Chris Savandra, ASIC's General Counsel. Senator, the matter was handled in accordance with ASIC's policies and procedures relating to staff grievances.
Yeah.
Given the matter pertained to the head of the agency, we considered it appropriate to consult with Treasury on that process. To be clear, the process was conducted or run by ASIC, but in consultation with Treasury and with Treasury's assurance or oversight.
Okay, so was that conducted under the ASIC Act or under an ASIC policy?
It was conducted under an ASIC policy.
Okay, so it wasn't conducted under the PGPA Act?
No, Senator.
Okay. Have there been any investigations under the PGPA Act, Chair, into any of the commissioners
Not that I'm aware of.
in the past 2 years?
Not that I'm aware of.
There's been no inquiries that you're aware of into any ASIC commissioner in the last 2 years under the PGPA Act?
Not that I'm aware
Senator,
of. So, Chris, maybe you can help.
yeah, I'd prefer to take that question on notice just to check.
You don't know?
Not specifically the PGPA Act, and as you're aware, there was a independent process in relation to one of our former chairs. And I think that might have been within the last 2 years, unless time has flown by. So I think it would be just to make sure we respond accurately and precisely. I think it would be helpful to take that on notice, just to check under the PGPA Act, because I must say off the top of my head I'm not aware, unless you can assist me, Senator, what mechanism there is under the PGPA Act for grievance matters to be dealt with in relation to statutory appointees.
Okay, so just so I'm clear on what your answer is you're taking on notice whether or not there has been any PGPA investigations or inquiries into ASIC commissioners in the past 2 years.
It's your question, Senator.
The question is, have any of the ASIC commissioners had any PGPA Act investigations conducted into their conduct in the past 2 years?
Senator, my request is I'd like to take that on notice. If you could point to the section of the PGPA Act you're referring to, I'd need to look specifically at, and it's a big act, what matters there might be. So, it's a large act. I want to make sure I answer correctly.
I don't want to overtalk any witness, but I just want to be clear with you that you would know if there had been any such inquiry because the chair would have been notified about the outcome of any such inquiry. It's not something that you wouldn't know. You would know about it.
Well, officials can take it on notice, Senator Bragg. I think accuracy of information is important. It's not unreasonable over a 2-year period that you've asked for that officials would want to dot their I's and cross their T's. I think that's entirely reasonable.
Okay, well, as I say, it seems like a strange answer to me. Chair, maybe I'll try with you then. So, have you received any letters from the Secretary of the Treasury in relation to any investigations conducted into any of the ASIC commissioners in your tenure?
I'd like to take that on notice. Yeah.
You don't know?
I get a lot of correspondence, and so let me just step back from this. The PGPA, as far as I'm aware, and I think Chris Savunda has confirmed this, I'm not aware of any provisions of that Act that provide for investigations or inquiries into the conduct of statutory appointees. I mean, I'm happy to be corrected on that. And so I would just like to confirm that's the case before answering that question, which I think is what you're particularly interested in.
Let's not overcomplicate it. I guess the substance of the question is, have there been any investigations into any of the commissioners in your tenure, which is not all that long, where the Secretary of the Treasury has had to write you a letter about the outcome of that inquiry?
Well, that's a matter I'd like to take on notice.
And what is the basis for you taking that on notice?
Well, Chris, could you help? I think I know what I'd like to say, but Chris, could you help me with that?
Senator, I think we'd like to take it on notice to obtain some advice and consider really any claim for confidentiality. As in, I've mentioned one matter. Complaints are made about statutory appointees and ASIC staff all the time. They're dealt with by various people. They're dealt with in a confidential matter. The concern about answering it, is it could project, it could unfairly impact, a range of people. So I think we'd like to take that on notice and consider whether we wish to make any claim of confidentiality or public interest immunity.
Okay, well, I mean, I'll just say that as the corporate regulator, it's not a very good look for you to be looking as if you're covering up an inquiry into one of your commissioners. You've just said that you're you're aware that there's something there.
That was not the answer.
It's just not a very good
It
look.
was just given. Well, I think it is reasonable for officials and allowed under the standing orders and the way Senate estimates run, when questions are asked, for officials to take information, that question on notice and come back to the committee, which is what officials
but
have
they know the
undertaken
answer.
to do.
They know that there's
Well, and
something.
they have explained that they would like to take some further advice. Again, I think that is not uncontroversial. You know, it happens all the time.
And in addition to that, Senator Bragg, do you have a final question, because you're at the end of time?
Okay, so just so I'm clear on this particular point before I move on.
Yep.
So you are aware of letters received by the Chair, penned by the Secretary of the Treasury?
So I think we're taking that question on notice.
Yeah, on the basis that you don't know, or you want to
Yeah, well-
seek legal advice?
The question you've just asked, there are letters that we receive all the time
Yeah,
from the Secretary of the Treasury.
Yeah, about investigations into
That's not the
commissioners?
question you asked.
No, sorry.
We were saying we don't know, and we said we wanted to go away and look at it. As the Chair has said, you know, he's been in the role now for 2 years. He's received a number of pieces of correspondence. We want the opportunity to go and look at it
So what is the basis upon...
to make sure we give you a complete answer and that we don't misspeak.
So you think that there's so many letters the Chair has received about inquiries into the commissioners that you're not sure whether you've received it or
No,
not?
that's not what I said at all.
But that's what you're saying.
I think
No,
it's,
no, it's not what I'm
Senator
saying.
Bragg,
It's
clear that the
Senator Bragg, the
questions
question has been taken on notice.
Yeah. So I'm going to...
We'll have to seek some
The
advice on
reasons
that.
are for accuracy and taking advice.
Can someone
some advice.
give you that advice and you come back
So
with
you
the
don't have to
answer?
call Senator McGrath. So some
just seek some
questions have been
advice on that.
taken on notice, and I give Senator McKim the call. Senator McKim.
Thanks, Chair, and good morning, folks. I just wanted to ask a few questions about the Hindenburg report, which is a report by US short sellers into Adani that found that Adani had engaged in brazen accounting fraud, stock manipulation and money laundering. Can I just ask, has ASIC had a look at that report? Are you aware of that, and have you had a look at it?
Yeah, we're certainly aware of it, and we've had a very preliminary look at it, and I think Deputy Chair Court might be able to provide some assistance in answering that
Yeah,
question.
thank you. Thanks, Ms Court.
Sarah Court, Deputy Chair. Thanks for the question, Senator McKim. So yes, we are aware of that report from Hindenburg Research that was released in January of this year, and the report alleged, that, as you've indicated, that the Adani Group had engaged, I think the quote was, in brazen stock manipulation and accounting fraud scheme over the course of decades. So we have had a close look at that. Where we've got to so far is that only a small part of the allegations in the report related to the Adani Group's Australian operations. And you may also be aware, Senator, that the group did publish an extensive response to those allegations later in January.
Yeah.
We have not identified at this stage any harm to investors in Australia, which is what we would be primarily concerned in. And the other relevant factor that we've identified is that to the extent that there is misconduct alleged to have occurred in Australia, it is now quite aged, so it would have occurred between the 2013 and 2015 period. Given the age of that, even were ASIC to commence an investigation, we would be well out of time now for civil penalty proceedings to be commenced. And our other challenge, were we to look any further, Senator, are that given again the age of the conduct, we would have difficulty obtaining information and evidence in relation to the accounting treatment that has been alleged in that research report. So at this stage, we're aware of it, we've looked closely at it, we'll continue to monitor it, obviously, in the event that any more revelations are made in relation to conduct in Australia or conduct impacting Australian investors. But that's where it sits with us at the moment.
All right, thanks, Ms Court. So the report did allege that Adani's Carmichael Rail did acquire assets from the publicly listed Adani Enterprises without disclosure by the listed entity, with loans funded by Adani Enterprises without disclosure by the listed entity, and then almost immediately wrote down the value of those assets significantly in the same financial year, which enabled the listed entity of Adani Enterprises to potentially avoid a significant loss. Are you suggesting that you've had a look at that and that you can identify no harm to investors from that behaviour?
No, Senator. What I'm saying is, we've looked at the report itself and the nature of the allegations, as you have quite correctly outlined them, but in terms of the time frame for which that alleged misconduct, and obviously that's all it is at the moment, but alleged misconduct occurred, given the time frame that we have identified it occurred in, that we're not taking any active action immediately. We haven't opened a formal investigation, but we're going to continue to monitor. Well, in the event that there is more indications that indicate either that there has been harm that we can articulate to Australian investors or more recent conduct by the Adani Group, then of course we will look at it.
Okay, thanks. Would there be any tax implications from the behaviour alleged inside Australia in that report?
Well, Senator, I'm afraid I'm not a tax expert.
Fair enough.
I would like to be, but I can't answer that. That might be a question best for Mr Jordan.
All right. I've previously had some things to say about ASIC's guidance in relation to short sellers. I think it might have been in the last time ASIC was in, or perhaps the time before, particularly a guidance that short sellers shouldn't use emotive language. Would you agree that the Hindenburg report is actually an example of short sellers providing a public benefit?
I don't think I can answer that off the top of my head, I'm afraid, Senator McKim. I haven't looked at it through that prism.
All right. Ms Court, this might be one for you, but I'll just bowl it up and see who steps to the crease. This is about the investigation into ALS Coal,
yes.
Which was alleged to have altered nearly half of all its coal quality certificates that it had issued over 13 years. On the face of it, that appears to have been a case of widespread and systemic fraud, yet the AFR has reported that ASIC has chosen not to prosecute ALS. Is that right? And if so, what was the rationale for the decision not to prosecute in that case?
Yes, that is one for me, Senator McKim. So we are obviously aware of the concerns that have been aired in relation to ALS Limited, and we have confirmed publicly that we have had an investigation both into ALS and another company, Terracom Limited. ASIC's jurisdiction in relation to these issues relates only to whether or not there's been corporate governance breaches by these firms, and so we don't have jurisdiction in relation to the correctness or otherwise of the coal certificates. So we investigated.
Sorry to interrupt, Ms. Court. I do apologise, but can I just be clear though that the ALS's tampering of the coal quality certificates is proven, correct? Do you accept that that's been proven? And if that's the case, how could that not be an issue of governance concern?
So, as I understand it, Senator, and I'm speaking off the top of my head, so I'll give it my best shot, ALS has acknowledged the issues publicly, and I think, as you say, that they have acknowledged, I think, that somewhere in the order of 50% of those coal quality certificates had been tampered with, I think was your word. So what we have to look at in relation to this investigation is, has there been a breach of the directors' duties obligations under the Corporations Act? So when we look at that, what we have to gather evidence in relation to is whether or not the directors and or the officers of the company acted reasonably. Did they have knowledge of the practices that were going on? Did they endorse them and the like? We did do a thorough investigation into ALS. I'm very sympathetic, I should say, with your line of questioning. I do understand the public perception on this particular matter, but after that thorough investigation, where we concluded was we were not able to gather sufficient evidence to make out corporate governance breaches. And the question often is, and if I could talk hypothetically rather than about this particular investigation. What is the evidence that we can ascertain using our compulsory information gathering powers, interviews with witnesses, expert evidence?
Did you exercise those powers in this case?
Yes, we did.
And your view is that you can't, to a required level of satisfaction, prove that the directors did know about the tampering?
As I said, I don't want to be too definitive about this particular case, but if I could speak at a high level on this case, on the ALS Limited investigation, we formed the view after a thorough investigation, including using our compulsory powers, that we were unable to put evidence before a court to make out directors' duties contraventions. Okay. And that's the reason that we finalised that investigation. I should, though, if I could just finally add, though, Senator, that we are continuing our investigation into Terracom Limited. So that investigation remains active. It's the ALS Limited that we have
Thanks, Ms Court. So my last line of questioning, perhaps probably best directed at you, Mr Longo. The AFR has reported that you said that you think ASIC's enforcement staff are too cautious, risk-averse and bureaucratic. Is that right?
What I've said, and I took the staff over this last week, in fact it was in my opening remarks, the ASIC's been...
No, but you didn't say that in your opening remarks.
Yeah, I did. I know. I'm just saying, I'm just putting it back into my own words.
Okay. Yep.
I think the ASIC's remit is very complex, it's very broad, and expectations of us have grown over the years. We keep getting a broader jurisdiction. And and how we enforce, how quickly we enforce, that's a really difficult work. And we have very, very good people at ASIC. And the point or the objective of the reorganisation was to talk to all the staff and say, well, how can we do better? And so I think the culture that I'm working towards is a confident and ambitious regulator. And I think the ASIC's work in this area has been cautious and considered. And what we need to think about is, are we taking on enough risk? I mean, are we taking on the right... I think I kept using the word choices. And so when you really start thinking about these issues deeply, the question is, we have all these matters we could run or could investigate. How do we go about choosing the ones we are going to run? And I suppose what I'm trying to say, and I think if all the staff were in this room, I'm sure they would say the same thing, is that we would like to be faster. We would like to be more decisive, be able to run matters more quickly. And so I think that's where I'm coming from.
Okay.
Yeah.
So
Senator,
just last question.
Time. Thank you.
Thanks, Chair. So the Royal Commission into the banking sector, in my view, excoriated regulators. This before your time, Mr Longo, but post that Royal Commission, and again before your time, ASIC adopted the motto of why not litigate. When you took the reins at ASIC, it seemed from the outside that mantra was actually dropped. So I want to give you a chance to respond to that. And if that's the case, isn't it true that the why not litigate mantra or culture that existed before you got there, which was all about taking a chance and perhaps having a higher appetite for risk in prosecutions, isn't that what you're actually talking about here, and potentially being more open to taking risk in prosecutions? And in fact, if that's the case, you're going to re-adopt the why not litigate mantra.
I'm going to turn to Deputy Chair Sarah Corr, because she chairs the Enforcement Committee.
Why not litigate?
I'll have one go at that, if you don't mind.
Sure.
The work we do in enforcement is very sophisticated. There's a whole range of responses. The why not litigate mantra was simply something that came out of the Royal Commission, and we're now adopting. I think we're litigating as much as we ever have. As I like to remind people, we're in court somewhere in the country every day of the week, and in Superior Court. So we're very, very active litigator. But I'll hand over to Sarah, because I know she too has given this a lot of thought.
Thanks, Ms Corr.
Senator, I know we've discussed this at the committee on previous occasions, and I guess I just want to assure you and the committee that the move away from what I describe as a catchphrase, why not litigate, doesn't signal any lessening of a strong enforcement response from ASIC. And I know the committee chair would like to move on, but if I can just very quickly, I thought about this because I thought this issue might come up, but as the chair referred to in his opening remarks, we did release a quarterly report earlier this week about the enforcement work that we've done just in the last quarter of 2022. So just to reassure you, in that quarter, in relation to the big banks, ANZ was penalised $25 million for misleading customers. CommSec and AussieX were ordered to pay over $27 million for systemic compliance failures. The court found that the NAB engaged in unconscionable conduct in relation to account keeping fees. In relation to the new design and distribution obligations, we filed the first matters in the Federal Court against Amex and against FirstMac, which one of those is an issuer of products, one is a distributor. In the difficult crypto area that we have made as a priority, we filed separate proceedings against BPS Financial for its coin token, against Blockearner and against Finder Wallet. In the greenwashing area, we took the first enforcement actions on 4 different occasions, issuing a series of infringement notices, and we are continuing our efforts on greenwashing this year. In the insurance area, I can go on and on. I guess my point, Senator...
We might table... We've asked for a copy of the quarterly report and we'll table it.
Indeed. I guess my point, Senator, and again, I do feel reasonably passionately about this, ASIC has not stepped away from enforcement in any way. Indeed, I would argue the contrary. I think we are prioritising trying to move our matters through the organisation more quickly. We're on a campaign to increase penalties against significant financial institutions, and I hope this committee gives an opportunity to talk about some of that work.
Thank you, Ms Court. Senator Smith.
Thank you very much. Thank you, Chair, and welcome to officials from ASIC this morning. I was hoping you just want to refer, just going back to your comment about active litigation, I was hoping to get an update in regards to the matter of the Aboriginal Community Benefit Fund, which I understand is in, or has been in the Federal Court since October 2020.
Would you like to take that, Sarah?
Yes, well, I can give you... good morning, Senator. I can give you an update on the current Federal Court proceedings. In essence, Senator, that we have 2 separate proceedings on foot at the moment. So the first matter we commenced back in October 2020, and we are alleging various misleading and deceptive statements made by the Eupla Group and its subsidiary ACBF Funeral Plans in relating to offering, promoting and selling a funeral expenses facility. That
it was marketing itself as an Aboriginal business.
Indeed.
That's right.
Yep. Yeah, indeed, Senator. Mm-hmm. So the allegations there, as you have quite rightly observed, are that the ACBF plans were making misleading representations that the plans were owned or managed by Aboriginal persons that had Aboriginal community approval, and that the plan would be more beneficial to Aboriginal persons than other comparable products. Now, the entities against which those proceedings have been filed have since gone into liquidation, and ASIC sought the leave of the court to nevertheless continue with our proceedings, because we think it is very important to ensure that we get a finding that there has been a contravention of the law, despite the fact that these companies are in liquidation. We have had the hearing on liability and penalty in November of 2022, and that judgment is reserved. So we are waiting for the court's findings. We have a second limb of our work where we are looking at the conduct of former directors of the ACBF group. We are continuing that investigation, Senator, and we have also, in the course of that proceeding, commenced injunctive proceedings in the Federal Court to preserve property that is part owned by one of those former directors that is subject to our investigation, and we did obtain from the court interim orders preserving those assets in December. And the purpose of that second action was to protect the interests of people that may be aggrieved by the conduct of those UPLA Group entities and to preserve the asset for their benefit. So that's the current status of the second, and we have a continuing investigation, as I say, in relation to directors of those entities.
So just in regards to, let's call it the October 2020 Federal Court matter, when do you expect to have that
Judgment.
finding? Yeah, that decision.
Without wanting to be too informal, I'm afraid, Senator, that your guess is as good as mine in the sense that it is sitting with the Federal Court at the moment. It was heard 3 months ago. In my experience, the Federal Court will usually take between 6 and 12 months to hand down a matter of this kind. I'm not aware that this matter is going to be expedited in any particular way, but it may be, but by the next time we appear at the committee, we'll have that Federal Court decision.
Right. Is there any pressure that ASIC can put on the Federal Court, given that it announced last week its Indigenous Financial Services Framework Initiative? The answer might just be a simple no, but
Yes.
I thought I'd ask it. Yeah.
It wouldn't be appropriate for ASIC to pressure the Federal Court, to use your terminology, Senator, but certainly if a matter has been with the Federal Court for a period of time, we do have a practice to communicate with the court to inquire as to when judgment may be delivered. And in a case like this one, where there is a significant public interest in the outcome, we may well do that earlier than we otherwise would.
Okay, that's correct. Communicating with the court is much better terminology than pressuring the court. So, so communicating with the court is an option that's available to ASIC.
Yes, it is.
You may utilise it in this particular. You may utilise that option or opportunity in this matter, but have not done so yet.
No, we have not. As I say, Senator, it's only been 3 months since the hearing, with, of course, the Christmas and January break in the meantime.
Of course. When would be an appropriate elapse of time to then communicate with the court? Would that be 4 months, 6 months, 12 months?
Our general practice, Senator, is 6 months that we will communicate with the court. And as I say, I haven't discuss this with my colleagues, but we may form a view that it would be appropriate to inquire of the court as to likely timing earlier than that time, given the public interest in this issue.
Yeah. Given the interest of the Senate Economics Committee in this matter, would that help?
Maybe it would, Senator. I'd have to take advice on that.
Thanks very much. If we just then turn to the second matter, which is the investigation into the directors.
Yes.
Now that investigation has started and is ongoing. Are you able to give us a sense of what are the elements or the components of that investigation? How long you expect it to take? First question. Second question is, given ASIC's commitment to an announcement of its Indigenous Financial Services Framework, am I correct to suggest there might be some additional resources put to this particular matter?
Yes, let me deal with the latter part of your question first. We have very much directed and focused resources in relation to the ACBF and UPLA Group investigations for some considerable time now. We have a team working intensively on that, and it is well resourced. The Director Conduct current investigation commenced in April of 2022. We are investigating potential contraventions of the Director's duties provisions in the period July 2015 to March 2022. There are a number of potential persons of interest that have been directors of the various UPLA groups across that period. I do need, though, Senator, to make the point that the investigation does present us with a number of challenges due both to the age of some of the conduct and in particular jurisdictional challenges, and some of the former directors are no longer living in the Australian jurisdiction, but we are nevertheless persevering with that investigation despite those challenges, and we are in the process of reviewing significant volumes of information. In terms of timing, it is hard to be prescriptive as to that, but again, I would hope that we will have some kind of indication of where that investigation will end up, probably within the next 3 to 4 months, Senator, if I had to use my... But I'm guessing there a little, but given that by April we will have been looking at that for 12 months, I think that would be reasonable.
When we think of the impact of this, am I right to assume... So when we think about who has been impacted, what's the geographical composition of the impacted community? Am I right to assume... Are you able to quantify how many people have been adversely impacted? And then are you able to quantify what is the geographic distribution of that?
I think we do have that information here, Senator Smith. Karen, are you able to... Do you...
Sorry, I was just absent for a moment.
Oh.
We're talking about the number of and the geographic dispersion of First Australians affected by the ACBF Eupla collapse. I think it's around 15 to 20,000, isn't it? Could you sort of speak to that?
Yes, I can. Sorry, Senator, for the Hansard, Karen Chester, Deputy Chair ASIC. Unfortunately, ACBF were not very good at keeping the data on their policyholders, Senator. So we've got some estimates ranging from around 12,000 through to 18,000. Our ASIC Indigenous Outreach Program team that did all the heavy lifting on the framework that we've just released actually did a lot of data analysis that we managed to receive from the liquidator to do a geographic mapping for consumer groups and First Nations consumer groups to help reach out and get communications plans out in light of the collapse of ACBF. We'd be happy to share that geographic dispersion with the committee. I don't have that data or that geographic representation with me. We've been working very closely with the Save Sorry Business Coalition
Yes.
and the representative groups and stakeholders throughout remote and regional Australia. So I think it's fair to say, Senator, that there's not any state or territory in Australia that's been left untouched by the harm of this entity and its misconduct and its collapse. We continue to work both with government, Treasury with the government's resolution, New South Wales Fair Trading, given that they're also a co-regulator of these entities and are working with us on the liquidation process in a timely way. But also, and most importantly, with the First Nations consumer representative groups and the other consumer representative groups that are really rolling up the sleeves and getting out to community and to people impacted to make sure that they have a full understanding of what's occurred.
Thank you, Ms Chester. Senator Smith, we are at time. Did you have just a final question, and then I'll share the call?
It is an important issue. Perhaps two more questions?
If it's on the same topic, yes.
Yeah,
Thank
great.
you,
Thank you
Senator
very
Smith.
much. Thank you very much, Chair. What is the interrelationship between ASIC and the, excuse my pronunciation if it's incorrect, the Eupla Group Financial Funeral Benefits Program run by Treasury?
Sorry, Senator, I didn't quite catch the question.
The Eupla, Y-O-U-P-L-A Group Funeral Benefits Program, which is the Treasury program that's been established to support people that have been caught up in this affair. I'm just curious to know what is the interaction between ASIC and that benefits program?
Yes. So we've been working closely behind the scenes with our colleagues in Treasury, leading up to and as the collapse occurred, Senator, chiefly to make sure that the government could consider some important transitional arrangements. So once the policies fell away with the collapse of the entity, the government then moved very quickly to consider what could be put in place. So there has been put in place, as you're aware, a program to make sure that for at least the first 18 months, no one who was and I don't have the exact wording in front of me, that was a policyholder at the time, if they were to experience the loss of a relative, that if they had eligibility under the insurance program, the policy, that they would have then been entitled for that to be paid. So the government's got that in place. In terms of our role there, because we've been involved historically in supervision and the enforcement actions that Deputy Chair Court referred to, we had a lot of insight and information and also the data through the liquidation process to help Treasury to get together the information to inform that policy in a very timely way so it could be announced by government and up and running as quickly as possible.
How important has the Save Sorry Business Coalition been to the work of ASIC?
Out of all the meetings I had last year, Senator, it was probably one of the most important ones that I had when I met with the Save Sorry Business Coalition members here in Canberra when they were here, when a new parliament had been formed, to speak to members of parliament about the issues as they've seen them.
Final question. Just curious to know, Minister, whether or not Minister Stephen Jones has met with the Save Sorry Business Coalition thus far?
Well, I'll check, but I know he's been very involved in this from the earliest opportunity. I think this is one of the first things we considered was how to ensure that people could have their loved ones buried. There was some urgent action that needed to be taken there, and then what further steps need to be taken to deal with this terrible set of circumstances, frankly. The Minister has been involved from the get-go, I can tell you, because I've had a number of meetings.
Great,
And
thank you very much, and thank you to officials.
He has met.
Great. I just seen some media. I saw some media comment that he hadn't responded to. I was just checking that, but I wouldn't have expected anything other than that, given the seriousness of the matter. So thank you very much for that.
Thank you, Senator Smith. So I'll just note that we've just gone past 10 o'clock when we're scheduled to release ASIC and invite our next witness. Senators do have a few more questions, so I'll proceed now in 5-minute blocks and call Senator Stewart.
I'll try to keep my questions brief for you then. First, I just want to say thank you for your work on the Indigenous Financial Services framework and the work that you've done to increase the visibility and voice of First Nations people in your work. Just wondering what some of the challenges or observations that you made that led to the development of the framework. What was the factor behind that led to the development?
I think Commissioner Danielle Press has been most engaged in that process, and so I'll invite her to comment on that.
Thank you, Chair Longo. Danielle Press, Commissioner of ASIC, and thank you, Senator Stewart, for the question. We have worked very closely with First Nations people and tried to put and ensure that there's a primacy of that voice has come through in the work that we've done. I think the challenge is around, the challenges are many actually that First Nations people face when facing into our financial services sector, and often quite different depending on what part of the sector they're facing into. Superannuation, which is one that is a favourite of mine, around identification and working with industry on how do we and how do they enable different forms and different ways of engagement. Within insurance, you know, the challenges are great. Within banking, there's a lot of predatory lending and predatory activity that's occurring, and we're looking very closely at that. So to give you a full briefing, I'd be delighted to get our people who actually did the work on this and our Indigenous Outreach Program, who have been working extensively on ensuring that we are hearing the right voices and we are hearing and prioritising the challenges that are being faced. So I must admit I'd prefer to take a really more detailed briefing with that group, so that you can hear exactly from them the stories that they were hearing, because the stories are extraordinarily powerful.
Yeah, and I might even ask you to put some of those stories on notice, if that's okay, for the benefit of this committee. And just going to the financial services framework, can you just talk through some of the things that are in the financial services framework and how they respond to some of the challenges and observations that you've heard?
Certainly. As I said, it is a new framework that we've been put through. Certainly the main things are around hearing the learnings, involving the people, ensuring that we are getting to community when we're looking at the issues that we're seeing. I think framing the harm differently is important as well, and ensuring that we are in fact seeing the harm. So it is very much about looking at this collectively and
What
holistically.
does that mean when you say framing the harm differently and seeing it differently?
So I think, framing the harm differently is probably clumsy. Ensuring we're seeing the harm.
Yeah.
I think ensuring that we're looking at, for example, you can't get to a computer in many of the remote communities, so if it's online, it's a problem. We talked a little bit earlier about the identification. It's a problem. So it's a different way of thinking about the harm that is not in mainstream financial services, because in mainstream, it sort of works. But when you're thinking about the Indigenous interaction, it's more difficult, and First Nations interaction is more difficult. Does that probably doesn't actually answer the question, and probably doesn't
I interrupted you. You were chatting. You were telling us about the
and
framework,
I think
and I interrupted.
doesn't give the framework its the credit that it deserves. I think it will do a lot of heavy lifting in, again, the way we're thinking about prioritising the harms. I also think it feeds well into our RAP and the RAP that we've just released for ASIC itself about trying to measure outcomes rather than just activity, and trying to make sure we're thinking about, are we improving the outcomes and are we improving the interaction with the financial services sector rather than just the activity that we do, which is relatively easy to measure. I think the outcomes is, again, something we're thinking very hard about. How do we make sure we measure those outcomes? And each action will have a different outcome.
So you haven't done the measurement before, like measurement of outcomes before in this type of way?
So it's very difficult to measure the outcome. So I think we've focused more on activity. And we're now thinking about, well, let's make sure that the outcome is right. And so it is, again, a shift in the way we are measuring our responsiveness and our effectiveness by thinking about the harder things to measure rather than the stuff that's relatively easy to measure, which is, how many engagements have you had, how many times have you gone, what is the outcome, right? And the outcomes are hard to measure sometimes because it's not just our influence, it can be all sorts of things. But again, framing what the outcome is that we need at the beginning and making sure that we're actually achieving that outcome, I think, is part of the framework.
Yep, and one final question, Chair, if that's okay. Just wondering what difference it made to your work having First Nations people at the table?
It makes a huge difference to have First Nations people at the table. I think it ensures that we are hearing the actual lived experience of people. I think it makes a difference in the way we think about communicating the changes as well, in that I think, we do have to frame our communications to ensure that we are talking to the people we need to talk to about the things they need to be spoken to about, rather than talking to ourselves about ourselves, which financial services have a really good habit of doing. I think the example that Deputy Chair Chester gave earlier around the Save Sorry business and our interaction there is just highlighting what we need to do more of, and making sure that we're actually hearing those voices and ensuring that we can really articulate the problem.
Thank you. And so then you would say that having First Nations people at the table would lead to better outcomes for First Nations people?
I firmly believe that's true, yes.
Thank you very much.
One question there. What sort of payment regimes are in place for people who have the cultural knowledge to speak into those communities? It's great that there's consultation, it's great that there's action, but what is happening in terms of the pricing and the valuing and the practical response in terms of a dollar allocation for the cultural knowledge that people are bringing to this equation, and then in delivering it?
Yeah, I would need to take on notice, Senator O'Neill, the actual payment process and programs. We do our Indigenous outreach program is predominantly staffed by First Nations people, and we seek to engage with First Nations people across our institution. We do have employment targets across the institution to ensure that we're getting the knowledge in-house.
Yeah.
Where we're hiring in, I would need to take away how much and what costing of that we've done, because I think matter by matter it differs.
Yeah, and I guess it's where leadership is required, that somebody is not just a target at a lower level, that they
Correct.
actually get the leader. Thank you very much, Chair.
Thank you,
Thank you.
Senator O'Neill. Mr Longo, did you have a comment on this?
I'd like to go back to an earlier question raised by Senator Bragg, or a series of questions.
Senator
I
Bragg
think I
was
can
about
briefly,
to get the call as well, so
I can briefly
Mr.
deal
Longo.
with that. With your leave, I've made inquiries. I did get a letter from the Treasury Secretary, but not in connection with any inquiry or investigation under the PGPA Act. That matter was in connection with Deputy Chair Karen Chester, and I will now hand over to Deputy Chair Chester to deal with the matter today.
Okay, Ms.
Thank you, Chair Longo.
Ms. Chester.
And thank you, Chair. Indeed, you could tell we were having a few discussions behind the scenes here. I take the role of this committee and our transparency and accountability very highly. And given the nature of Senator Bragg's questions, albeit not directed to myself, I thought it was important I did share with the committee today that I am aware that in early 2021 some allegations have been made about myself. Those allegations referred to the Treasury. Treasury undertook and oversaw a very comprehensive investigation, and there were no adverse findings.
Okay, thank you, Ms. Chester. Senator Bragg, you have the call.
So who am I asking questions about the investigation to? Chair? You, Deputy Chair?
I think for today's purposes, Senator, again, I'll be guided by the Chair. That investigation was conducted by Treasury. It was not an ASIC matter. So I think that's if I might suggest, a matter for Treasury. But we're sort of running out of time.
Yeah.
It's a matter for the Chair how we want to go this morning.
Well, Mr Longo, your General Counsel had sought to take these questions on notice to consider what information could be provided to the committee, what information may be confidential. You've both chosen then to provide some more information to the committee, which it is now appropriate for Senator Bragg to ask questions about. If you feel that, if it's your assessment, if it's the General Counsel's advice, that further matters should be taken on notice, that is in your court to make that call. But I know you've just made some statements, and I'm sure Senator Bragg wants to interrogate those statements now. Senator Bragg.
Thanks, Chair. I appreciate that. I think it's good that you've tidied that up, because I think it's important that ASIC is presenting itself as a transparent organisation. I don't think that taking things on notice when you know some of the information is a good approach. So I appreciate your gesture there, Chair. So there was a letter from the Treasury Secretary to you, is that right?
Yes, I got a letter.
Okay. And what did the letter say?
Very short letter. I'd have to go back to it. I haven't got it in front of me. I hadn't anticipated this would be raised today. It was a very short letter, basically confirming, essentially, it was a very, very short letter. I have to go back to it. I hope Senator and the committee can appreciate it's a sensitive matter. I really don't want to try to summarise a letter that I got quite a while ago on the run. I can confirm I got a letter. It was a very short letter. And it aligns with what Deputy Chair Chester has said to this committee. I'd have to take on notice anything more about that letter.
I understand it's a sensitive matter, but obviously you're the corporate regulator, so it's important that you set a high standard. And if there's nothing to hide, there's nothing to hide. So will you take that on notice to supply that letter, please?
Yes, I'll take that on notice. I'll take that question on notice.
Thank you. And so was there a report that was the basis of this letter from the Secretary?
That's Treasury got a report.
They had a report done by who?
Senator, these are really questions.
For Markets Group.
You don't know who did the report, whether it was an internal report or whether it was
Treasury
external
review.
legal?
It sounds like it was a Treasury process.
Do you know, Deputy Chair?
It's a Treasury process, Senator.
Okay, so no one knows whether it was an internal review or an external review?
That does sound like a Treasury question, Senator Bragg, who we had yesterday.
Senator, this is Treasury's information, as in we really need to consult with Treasury before responding, as in they may have objections they wish to raise. You know, we had the opportunity briefly to consult during the course of this hearing, and hence we're in a position to respond as we have.
Okay.
We haven't had the opportunity to consult with Treasury, and really that it was a Treasury process. We think that it's best answered by Treasury.
That's fine. So but I don't want to take any more of your time on this issue, but I think it's important just to summarise the position. So there is a letter you've received. You'll take that on notice to supply that to the committee, and there's separately a report that's somewhere in Treasury.
Well, based on what Ms Chester's evidence is, there was a review done and no adverse findings were made. So I think you've got a lot of the information there that should satisfy the committee, and further questions would have to go to Markets Group, which appeared yesterday, or to the Treasury Secretary.
I understand that, Minister. I'm just confirming with the Chair that the letter will be supplied on notice.
No, he's taken that on notice.
Thank you for that. I've just been reminded by my General Counsel to be very, very clear. We're taking on notice the Senator's request for a copy of the letter to be provided to the committee. Whether or not we provide it, we're going to take some advice about and consider the position.
Well, I know that ASIC likes to file public interest immunity claims, but I just caution you that in relation to governance and probity matters of the regulator itself, I'd urge you to consider your position carefully.
Well, again, I'm sure ASIC will abide by the processes of this committee, which are well established.
Okay, well, we look forward to seeing that. Thank you. I just have one final question, which just relates to the LinkedIn message from former Commissioner Hughes, where he said, "I would have loved to send a final message of gratitude to my colleagues and stakeholders at ASIC today, but he was not able to do so." Was he asked not to do that?
No, I think the key points there, are this: when he announced he was leaving ASIC, he was essentially on garden leave. And that, I'm sure Senator Bragg appreciates the significance of that, and that is good practice. We went through that in a measured way because he, obviously there was some work he did with remaining commissioners to hand over matters, but he was essentially on garden leave. I say essentially, and then towards the end of his, and as the situation unfolded, of course, his access to systems was restricted significantly. I think the final point I want to make is that the Commissioners hosted a morning tea for Commissioner Hughes on the day before he left ASIC. And I gave a speech on his behalf where I elaborated on the sentiments that I briefly shared with this committee at the beginning of my opening statement. I went to some length to record and acknowledge his contributions at ASIC. And then he had the fullest opportunity to give his own remarks. And he did. He took that opportunity and spoke very well about his career at ASIC and his appreciation for the staff and their contributions. And it was well received, and the whole of ASIC was there. Those of us in Melbourne were there in person. The rest of us were there virtually. So he had, with all due respect to former Commissioner Hughes, had the fullest opportunity to speak to the staff. It was consequently inappropriate for an email to go out on the last day. So I know he felt the way he did, but I think to speak plainly, if I may, that's what happened.
Okay, thank you, Mr. Longo. I understand there are two quick... one follow-up question. Thank you. Senator McGrath.
Was the former Commissioner on gardening leave when he gave the now infamous interview to the Australian Financial Review?
That's a...
You can take that on notice.
Yeah, well, that's why I said essentially on garden leave. When I say garden leave, I mean access to confidential information of the regulator, his access to and engagement with regulated entities. So the garden leave I'm talking about is he stopped going to meetings with regulated entities.
But he could speak on behalf of ASIC to the country's premier financial newspaper.
I think there was just a timing question that was being asked that if it needs
Senator,
to be taken on notice.
Take it on notice.
So I really do appreciate what you're saying. Can I just say again, they were his views. He chose to express those views, and I hope that our appearance today really demonstrates our full cooperation and engagement with this committee. I do appreciate the concerns you raised earlier. The Commission and ASIC are very committed to working with this committee and, of course, other parliamentary.
Appreciate that, Chair.
Thank you,
all the
Mr.
work that you
Longo.
and your
I
organisation do.
understand that
Thank you.
Ms. Lister has a further answer to provide.
No, Chair, I just wanted to thank the committee, but also just to let the committee know that it was at my behest that we shared that additional information with the committee today, because I do think the regulator does need to be very transparent, but a very comprehensive and robust process was gone through, and I did want to emphasise, and I hope that Senator Bragg will also appreciate that there were no adverse findings. Thank you, Chair.
Thank you very much. I thank the representatives of ASIC. Thank you, Mr. Longo. We appreciate you answering our questions today, and we release you with our thanks. We'll suspend for a short moment while we welcome our next witnesses from the Australian Reinsurance Pool. Are we all ready to go, committee? The committee will resume with the Australian Reinsurance Pool Corporation. We welcome you. Dr. Wallace. Did you wish to make an opening statement?
Thank you, Chair. Just for expedience of time, I will table my opening statement.
We appreciate that. Thank you very much. Has it been provided to the Secretariat? It has. We'll table it shortly when we receive it. Thank you, Dr. Wallace. We'll proceed straight to questions. Senator Bragg, are there any questions for this witness? No. In that case,
appearance ever.
if the opposition has no questions for this
Who called the
witness,
Well, I don't think
on the pink sheet there, Tegan. Yes.
she didn't say she had any this morning.
That's okay.
Senator McDonald.
Yes, it was Senator McDonald.
Well, can I suggest that you read your opening statement, and we will. Which normally don't like, but and we'll just check.
I will actually accept Senator McGrath's chairing advice
Sorry.
on this occasion
From the cheap
and suggest that it would be useful to the committee while we locate the senator who has questions for you. Dr. Wallace, if you could deliver your opening statement, that would be appreciated.
Thank you, Chair. Well, thank you, Chair and committee members, for the invitation to appear today. I wish to make brief remarks since my last appearance on the 9th of November. As you know, ARPC administers the Terrorism Reinsurance Pool and also the new Cyclone Reinsurance Pool. I'm pleased to inform the committee that Allianz Australia Insurance has joined the Cyclone Reinsurance Pool for their home insurance portfolio, and Shaw Underwriting Agency have joined for their home insurance and strata insurance portfolio, with both of those insurers commencing from the 1st of January 2023. Now, ARPC now has 19% of home insurance sums insured in Northern Australia covered by the Cyclone Pool, covering 468,000 policies in Queensland, the Northern Territory and Western Australia. So consumers can now access the Cyclone Reinsurance Pool through those participating insurers. We are in discussions with other insurers to transition to the Cyclone Pool and expect, and I am very hopeful, that we will have two major insurers commencing cover from the 1st of July 2023. Now, that's not yet confirmed, but I'm very hopeful that we will achieve that. And the remaining 6 must join the reinsurance pool by the 31st of December 2023. ARPC is ready to commence paying cyclone-related claims, and we continue to work with insurers to make the pool an automated, efficient and effective scheme. I'm pleased to take committee members' questions.
Thank you very much, Dr Wallace. And Senator McDonald, do you have the call?
Thank you. Good morning, Dr Wallace, and really pleased to hear from you today. You've answered some of my questions with your opening statement, and so now the two brands that have joined the pool are Allianz and Shaw, I take from your comments that given that they haven't committed to joining, you don't want to name the other two major insurers just yet.
That's we haven't yet finalised agreements with them. But I actually am very hopeful that we'll have two major insurers joining from the 30th of June or the 1st of July.
Yes.
And we're in advanced discussions on that.
Right, and so it is still mandatory for general insurers to transfer their cyclone insurance to the reinsurance pool by the 31st of December 2024.
2023 for large insurers, and then small insurers have a further year until 31st of December 2024. A number of small insurers are already starting their processes to consider transitioning to the pool as well.
Senator, the distinction between a larger insurer and a smaller insurer is based on the GWP that they write. So the cut-off point is $300 million, and at or above that figure, they are considered to be a large insurer, and below that figure, they're a smaller insurer and they have an extra year to transition.
Would you just spell out GWP, please?
Sorry, gross written premium.
Gross?
Written premium.
Thank you.
Sorry, what was the trigger number there?
$300 million.
Last year you presented to the Joint Select Committee on Northern Australia on the inquiry for the cyclone reinsurance pool. Is there any other updates that you would want to make on the activities of the pool, staffing numbers,
Sure. I'm happy to provide just a general update.
Yep.
We currently have 55 employees. We've grown the organisation from 25 employees. We're currently recruiting an additional 11 employees. It is a complex undertaking, and we're adding additional skills for claims and actuarial in particular. Our systems are well developed, well advanced, and we're still refining them. And we are still in the process of fully implementing all of our policies and procedures, but we're well advanced on all of those. At this point in time, we are able to receive policies and pay claims, and we're working with insurers to do that very thing.
Terrific.
We've had a very small number of potential claims coming out of Tropical Cyclone Gabrielle, but it's very small,
Yes.
and our internal modelling of that exposure is perhaps less than $271,000 in claims. But at this stage, insurers only notified us a handful. So,
what a nice, small-scaled start to the operation of the pool.
Well, I was glad that no one was hurt in Norfolk Island. I'm very sorry for the losses in New Zealand, which have been devastating as a consequence of that cyclone consuming further south.
All right. And well, what is it that we can expect differently from the way the pool operates to previously when a claimant would have gone through their fund?
There should be no difference from a consumer perspective in the way that their policy is sold to them or the way their claim is paid to them. Insurance companies will continue to sell policies and pay claims, and we will be reimbursing insurance companies for their claims handling expenses. So there should be no impact upon the consumer experience. What the consumer should expect, though, is that our goal is to stabilise premiums and to reduce them, and the legislation requires us to make sure that we're not charging a profit and to set premiums to cover costs in the long term. So I would hope that our costs will be more stable than what we're seeing in the international reinsurance markets at the moment. Senators, committee members should be aware that the global reinsurance market is very heavily distorted at the moment by the invasion of Ukraine, global inflation, the Australian floods last year and international disasters that are unfolding. And so it's very disrupted, and there are very significant cost increases coming through to the insurance industry. So our part of the insurance industry, we hope to be stable, and it's really focused on cyclone and cyclone-related flooding.
So the claims that you've had, the 271,000, is from Cyclone Gabrielle. What about Cyclone Ellie? Have you received any claims from
Just
that
to clarify, Senator, our internal catastrophe modelling estimates were a maximum of $271,000. It's an estimate. We haven't yet received claims, but we've been notified there's a very small number that we may receive soon.
Yeah, thank you for clarifying.
And the numbers are actually very small,
yes.
Thankfully for everyone.
Yes.
The other two cyclones that we have declared, Ellie and Darian, happened before Allianz Insure joined the scheme, so there was no exposure in the pool for those losses at that time. Darian went off into the Indian Ocean, and Ellie created some flooding losses when it became a low, and when it came across the land as a low system.
So this will be a case in point of the 48 hours post-named event flooding related, the time frame that you're able to make claims related to the cyclone. This will be a good test of that, do you think? Or no, you said that because Allianz hadn't joined the fund at that point, you won't have exposure.
Allianz Insure hadn't joined the scheme at that point, so there wouldn't have been any claims. Ellie was actually a short cyclone. It lasted only 15 hours. So we would have provided cover for the 15 hours of the cyclone plus a further 2 days.
Yes, but the flooding from the tropical low has extended quite a long way through the interior.
Yes, the scheme is designed to maximise savings to medium and high risk areas exposed to cyclone.
Yeah, thank you. We did go through that the other day. So by that, are you saying that Allianz is the only insurer in that part of the world?
No, I'm not saying that. They are, at the moment we have two insurers that are participating in the scheme, and Allianz have other brands. So they have the Territory Insurance Office, which is TIO, and as a consequence of that brand, they have a very large share of the Northern Territory market. They also have brands for, I think, Westpac General Insurance, and so that's covered in our scheme now. And sure, underwriting agencies have quite a presence in Northern Australia as well, and have been growing over the last 2 years.
Senator McDonald, I'm advised other senators do have questions.
Oh, okay, sorry.
That's okay.
Settling in.
Right. Well, I hear that that has an ominous tone for me. Would you be able to finish in a few minutes, or shall I reallocate the call and come back to you?
Please reallocate and come back to me.
Senator O'Neill.
Thank you very much, and I just want to take the opportunity. I'm sure all Australians who are looking across the ditch to see what's happening with Cyclone Gabrielle in New Zealand are very distressed by the images that are there, and I saw the remarkable speech by the new PM, Mr Hipkins. This is a problem that has to be dealt with. Critical to getting the right solution is going to be the modelling. So my first question really is, what does the most recent modelling reveal about the cyclone reinsurance pool capacity to deliver premium reductions for Northern Australians?
Thank you, Senator. Just a moment. So we have released our most recent modelling. So that was published, I believe, on the 31st of October. And that modelling shows that consumers in Northern Australia zones will receive, on average, a 13% reduction in their premiums. And consumers that are, and I'm talking here about home insurance, and consumers in high-risk areas, and that's a small group of consumers, but those in very high-risk areas will receive 32% average saving on their home insurance policies.
Okay, so just to be clear, the 13% reduction in home insurance is for what group?
Home insurance in Northern Australia.
Across the entire north? Okay.
Yes, the Northern Australia zones, that's right.
And the 32%?
Is for consumers in high-risk areas. It's a smaller area in that area.
Okay, thank you for the specificity of that. That sounds a little different from some of the claims that I recall were trumpeted by the former government. The number comes to mind was more like in the 50% range. So how does the modelling that you have undertaken, that you said was released on the 1st of October?
We've released two rounds of modelling. So we've released our original prices and the modelling to support that on the 30th of June. And then we undertook further consultation with the insurance industry with support from our minister, who wrote to insurers seeking them to provide additional data. And we published revised premium rates and the updated modelling. Maybe if I can just ask my colleague, do you know the date that was?
30th September.
30th September was the date that we published that second report. And so
this is important because people actually need the facts, right? They don't need marketing, don't need the hype. They actually need the facts to deal with the challenges they face. Great place, north of Australia. People haven't been there should definitely visit, but there are some risks there as well. So how does the modelling that you have done based on evidence and in consultation, released, consulted and then released as an accurate representation, how does that compare with the previous government's claim that the pool would deliver premium savings of up to 58%? How on earth could they have that number?
No. ARPC wasn't part of that original process, and I refer you to the Treasury for those comments. ARPC is responsible for administering the pool, and when the legislation was enacted in March last year, we then commenced the process of pricing and modelling, and we had to recreate or actually create our own modelling base. So we did that by purchasing international catastrophe models and taking a very large data set from insurers, and we've gone through a very careful process to determine the premium rates, and we've strived to make that all publicly available. So the reports are all on our website. We do hope to update that again over the next year. We have an obligation in the Act to publish a financial outlook report, which will talk to the financial sustainability of the scheme, and through that process that will help us identify opportunities to further refine the premium rates. We still don't have much data. It's early stages for the scheme, and the data that we've used to price was based on sample data from insurers. Even though it's quite large, it's not the full data set, and as insurers join the scheme, they have an obligation to provide us policy level data and claims level data for all of their exposures. And so as we receive that data, we will have much more accurate information and will continue to refine the premium rates. As I said, my goal is to achieve the policy objective, which is to reduce premium rates in Northern Australia, particularly in medium and high risk areas. And I'm very confident that we can achieve that. At a minimum, we should be able to stabilise pricing, because the global reinsurance market, if you do any searching on the internet around what's happening with international disasters, there's a very large number of extraordinary disasters unfolding in insurance and reinsurance markets around the world. And so there are very large cost pressures flowing through at the moment. Our part of it is, we're very confident that we can deliver our part of that scheme. In Northern Australia, most of the exposure in Northern Australia is cyclone. There are exposures to flood and to bushfire, but most of the exposure is to cyclone, and we're picking up picking up all the cyclone and a large part of the flood following the cyclone in the period of the cyclone and 2 days after.
The people who live in the north of Australia strike me as a pretty robust group. They like to deal in facts. They have to deal in facts. And the cyclonic risk is absolutely a reality for them. I'm sure that'll be considerable comfort to them to find that the government is now on a path to a high level of transparency that you've indicated will be a signature of your work, so they can get on and actually read what's going on and not just be subject to sort of a spinning narrative without factual basis. But I'm sure some of them are a little concerned and perhaps have lost trust in what the government's saying, because there seems to be a very, very vast difference between the predicted premium savings that they were sold and the reality of what is actually able to be delivered at this juncture.
Senator, can I say...
How did that happen?
Can I say that for consumers in Townsville, the average cyclone reinsurance premium that they will be paying, this is an average, and I know averages, simplify things, but the average premium will be $624 in Townsville. In Cairns, it will be $427, and in Darwin, it'll be $457. I would say that these are really good, solid
Massive
prices.
reduction.
This is for home insurance. I'm giving you numbers for home insurance here. We've actually published all of these in our actual reports, and what we hope to be able to do is over the next 2 years and longer, start publishing what the average premiums are for cyclone for the part that we're charging. And our part of the premium is quite a sizable part of the premium. So it will have an impact. In the high risk areas, I know it's a small part of the Northern Australia area. The scheme is designed to maximise savings to them, and anecdotally, we've already had some just very isolated examples of consumers saying to us what savings they've achieved. So I just think we should just wait a bit longer to see what the actual lived experience is for consumers. But as I said, the average premiums for the cyclone part of what we're charging to those consumers, I think they're really quite important numbers. As I said, $624 for Townsville.
And in your opening statement, you indicated Allianz is already on board, but others are ready to come into the fray.
Yeah.
The insurance pool works effectively to sort of balance out risk. Could you give me a sense of whether any Australians will see their premiums increase because of the pool? And if that's the case, by how much?
Thank you. So what the pool does is it introduces an element of community rating into the pricing of natural disasters. And the challenge for insurance affordability has been the increasing sophistication of risk rating in the community. The impact of risk rates ultimately means that each individual consumer is paying exactly for their exposure. What community rating does is it balances that out a bit, and so it means that there's a subsidisation from low risk to high risk areas, and that means that from a community perspective there's easier access to insurance. And so as a consequence, legislation requires us to set premiums that are comparable to private market premiums for low risk areas. And so low risk areas would include, for example, Brisbane and Perth and northern New South Wales, and so we will be charging equivalent commercial rates of reinsurance for those areas. In our modelling, we did actually publish some numbers on our estimates of consumers that might have an increase, and there are small percentages. And these happen because the price might be wrong. The insurance company may have just incorrectly charged the wrong price, or they might have had a view of risk in terms of flood or wind that's different to the reinsurance pool's view of exposure. We're using models that might be different to the insurance company. So there are some small percentages. I won't quote them today, Senator, but I can certainly provide those
on notice.
And I just want to say we have published those numbers before, so we've been transparent on those increases.
With a view to time,
Thank you very much, Chair. There's so much more to ask because the people of the North who are constantly experiencing this exposure really deserve the truth and the benefit of good government policy and enactment. I'd like to know what the impact of risk mitigation and climate resilience measures will have on reducing the insurance premiums also in high risk areas. And I guess that goes to sort of the speech that we heard from Mr Hipkins last night about confronting the reality and not pretending anymore that, climate change is real. We're there. So what's the situation with risk mitigation and climate resilience in your world?
There's two parts to our answer in that. The first is that the premium rate that we set, the legislation requires us to provide financial incentives for risk mitigation. So we've done that in home insurance. We've got some element of that in the strata insurance pricing, and for small business prices, we're developing that over the next 12 months. And so there will be a financial incentive. So as people do risk mitigation, we hope to see that in a lower reinsurance pool price to those consumers. That's the first part of the question. The substantial answer, though, is that there has to be mitigations implemented to improve the safety of the whole of society, and the legislation enables us to share data with other government agencies to be able to target risk mitigation. So I'm looking forward to, once we receive the data from insurers, making that available through appropriate data sharing agreements with other government agencies, such as, for example, National Emergency Management Australia, to perhaps help target where there might be further spending on risk mitigation. We don't have anything in our legislation that enables us to fund risk mitigation beyond providing financial incentives, but there is a strong focus on data sharing.
As a New South Wales woman, I was considered, I think they called me the Mexican on the Northern Australia committee, and it was great to get across the north. I'm sure that they'll be very pleased that their particular challenges are being handled in a professional and careful way. Thank you.
Thank you.
Thank you.
Senator O'Neill. Just a bit of time management. We are running fairly significantly behind schedule at this point. We're hopeful to call our next witness at 11. Senator McDonald, do you have the call?
A little after 11, I think we agreed 15 minutes, Chair.
15 minutes indeed.
And I perhaps
Senator
have a couple more questions following Senator O'Neill's questions. I wanted to, I've got two documents that I've requested be tabled. One that I tabled last night, which is a Townsville Bulletin article on the ACCC premiums report. And the second is a letter to me from Racing Queensland with regard to asset values above $5 million. Perhaps if we could start with the Racing Queensland first, because I assume that they... I'm sorry, is this all right to table, Chair?
Yes, so the lot owners article was tabled last night, and
yes.
The Racing Queensland letter is new, is that right?
That's correct.
Yes, and on a quick
look...
look...
signatures will be redacted on anything that goes online, but for the purposes of today...
Okay. Yes, on a quick look, there are no objections to tabling the Racing Queensland letter with redactions as described. Thank you.
You should, whilst we're not retabling the Townsville Bulletin article, hopefully you'll have a copy so that you'll be able to take that away with you. With regard to Racing Queensland, their operations in North Queensland, which are a very important part of the economic and social lifeblood of Townsville and Cairns, they've outlined how they contribute almost $100 million to those economies. Their concern relates to the small business cap provisions, industrial special risk insurance. They've had a significant cost increase of 150% in 2021 for race clubs north of Rockhampton. Is it possible for businesses with an asset value above $5 million to be able to insure up to the $5 million within the pool?
The legislation and regulations don't allow for that, and so it's a matter for the government to consider, and so refer that to Treasury in terms of policy.
Do you have other businesses and organisations that have contacted you with the same question?
In the business community, no, but I'll just refer to my colleague, Alexander Drake.
Alexander Drake, Head of Public Affairs at the Australian Reinsurance Pool Corporation. To my knowledge, we have not had any requests for consideration for the $5 million figure to be changed directly. I'm happy to take that on notice in case other colleagues at ARPC have, but it's more likely than not that it would have come to me, and I don't immediately recall anyone making that request.
Thank you.
And just to clarify, again, it's in the legislation and regulation, so it's not a matter that ARPC can provide advice on.
Minister, this is it is a community sort of organisation. Is this something that I could request that you would take back to the Treasurer with a view to, or the Assistant Minister I think handles this, the Assistant Treasurer handles this legislation with a view to seeing if we could find a way for race clubs.
I will certainly do that. If they haven't brought it to his attention already, I will definitely do that.
Terrific. I thank you for that. The second matter that I wanted to draw your attention to is North Queensland Lot Owners Association in Townsville. The ACCC has provided their interim report on premiums. They have gone to 15 insurers and received data. When I asked questions of the ACCC last night, they didn't have a verification program that they were able to provide. And the lot owners are asserting that the numbers that have been reported by the ACCC are not reflective of what's happening on the ground. The ACCC is trying to say that there are some individual premium increases, but that is not the lived experience north of Rockhampton. The lot owners have asked that the Assistant Treasurer reject the ACCC report and that it be redone. Have you received any feedback in response to the report?
I'll answer first. So, have I received any feedback in response to the report?
The ACCC's report.
I've certainly had the opportunity to review the report myself. Andrew Turner, who is quoted here, has kindly sent me a copy of his document. So I'm certainly aware of the feedback. The ACCC processes are not part of the pool itself,
No.
and they're not actually referenced in the Terrorism and Cyclone Insurance Act. They've got separate appropriation and separate powers to do that. Beyond that, I might just ask my colleague Alexander Drake to just add to further comments on the Townsville.
Senator, we're aware of the comments made by the lot owners group and also read their submission to the Northern Australia inquiry last year, more generally on the topic of the cyclone pool. We're aware of their concerns about the ACCC report. What I think we will see going forward with further reports as we have more and more insurers participate in the pool is a very, very clear understanding about where premiums are at and the difference that the pool makes to where premiums land for the customers of insurance companies. And so I think in the first instance, a bit of caution on that would be encouraged, but the numbers that the ACCC used on their report were not shared with us in any way, and their numbers that the ACCC arrived at. We at ARPC are very mindful of the concerns that various stakeholders have about the issues associated with the pool. We understand that it is a major consumer financial issue for people living in northern and far north Queensland and across northern Australia. And I know that at our end, at the ARPC, we are working very hard to ensure that the pool will be as successful an operation as we can make it, to ensure that there is that downward pressure on premiums.
So, we've already had questions from other senators this morning about whether or not the premium reductions as estimated previously for the reinsurance pool would translate into reality. We had evidence at the Select Committee last year that we were still on track to achieve premium reductions in line with what was quoted. So I'm not sure where you got your question from, Senator O'Neill, but it's not in date because we have had updated data that reflects that these premium reductions are coming.
Since the new government started dealing with the data poverty that you left.
Senator O'Neill, is there a question? Thank you, Senator McDonald.
Thank you. And so my question is that this sort of reporting from the ACCC, if the new government is so interested in transparency and clarity of data, then they would be all over the ACCC report, because that is exactly the sort of thing that undermines Northern Australia's confidence in the government and the ARPC's delivery of the premium reductions that they require. It's part of the very important cost of living issue, particularly given that it's so much higher in North Queensland than it is in Northern Australia than it is in the rest of the country. So I would ask you to to acquaint yourself with the work of the ACCC in regard to these premiums, because it is undermining the confidence of the North in the process, and not reflective of the individual premium results that North Australians are reporting to me in their community groups, and hopefully to the ACCC. So is that something that, I appreciate it's not in your legislation, but how will you take that on board if it's a reputational risk for the ARPC?
Well, there's two things that we can do. The first is we can publish our part of the scheme performance. So we hope to make available the cyclone reinsurance premium component of policies and publish that over time so that people can see what's happening with that part of the premium. Now, we can't control the other part of the premium, and that's the role of the ACCC to monitor what's happening with the other part of the premium, and they've got powers to be able to collect information from insurers to be able to show what's happening with that. And so we will be working collaboratively with the ACCC to support their processes where we can, but we'll do our part also by publishing and making information available to the community.
What information do you have on programs and strategies being used to encourage policyholders to mitigate cyclone and related flooding risks in Northern Australia?
Well, in the premium formula, there are direct questions as part of the formula that provide discounts where consumers have undertaken specific risk mitigations. So that's already in the premium. So we've started that journey, and we're looking to consult with experts in this area to further improve that over time. So we are, as a reinsurance entity owned by the Commonwealth, we're very keen to actually do our part in supporting risk mitigation, although we can't directly fund it, but we can provide all the incentives to support it.
Are you provided information from other departments regarding what programs they have in place, so that you have an understanding of outreach on disaster mitigation projects?
Yeah, we're at early stages on that, Senator, so I'm conscious that there is an opportunity for us to engage across government agencies. I think that will become very powerful once we get the data from insurers to be able to share with those agencies. So that will come over the next 6 months.
Okay, so and I'm just thinking it would probably be the disaster, what are they called? The emergency, what is the new name for the disaster response agency? Anyway, that one.
Well, I keep changing acronyms.
Yes, so whatever that acronym is
National
now.
Emergency Management Agency.
Terrific. So do you work closely with them? Do you have any engagement with them?
We will have engagement with them through data sharing, I expect, but that will come as we start receiving data from insurers.
Right.
We're still at the very early stages of this scheme.
So the two insurers that you have signed up, they are providing you with a data stream now?
Yes, we've got initial data from them. Yep. That will become much more substantial once we get through this first quarter. Yep. So once we get more insurers on, we'll start publishing information for the community. So it'll probably be in the later part of this year when we start making all that data available in a summarised way.
So when you say you'll make that data available in a summarised way, what will that look like? On your website?
I'm hoping to publish on our website some summary reports on exposure and losses in each of the areas around Australia.
Right. Oh, so you'll go right around Australia, not just Northern Australia where the reinsurance pool is operating? Well,
we'll cover low, medium and high risk areas.
Yes.
That includes Northern Australia, but it also includes Northern New South Wales, for example.
Right, okay.
And South East Queensland as an example as well.
And
Senator McDonald, just noting the time and our arrangement. Do you have a final question or two?
I will have a final question. Thank you. So, sorry. My train of thought is just broken. It's about reporting. How frequently will you provide updates on that data information from the insurers?
So we have I'll answer first of all by saying that we have an obligation to publish each year a financial outlook report. So the first of that is required under legislation next year as part of our annual reporting process, and that will be tabled in Parliament. And that will include, I expect, some information such as what you're asking. So there'll at least be an annual process. Our corporate plan outlines an objective, a strategic objective, which is to collate data and make it available. And so I would hope pragmatically that we would be able to do some quarterly reporting. And we're looking at, for example, what APRA does. APRA publishes really good quarterly reporting to the insurance sector on insurance policies and claims. And so we were looking at the way they do that and seeing if we can do a similar sort of thing for the cyclone reinsurance premium component.
Thank you, Senator McDonald. Final
Sure.
question.
No, well, I
Final
will leave it.
statement?
No,
Okay. Thank you.
No, I will leave it and look forward to seeing you at the next estimates. Thank you.
Thank you very much, Senator McDonald, and thank you very much to representatives of the Australian Reinsurance Pool Corporation. We release you now and you go with our thanks. Thank you.
Thank you, Chair. Thank you,
Good luck
members.
with your work.
Thank you.
Thank you. And we now invite representatives from the Australian Small Business and Family Enterprise Ombudsman. The committee welcomes the Australian Small Business and Family Enterprise Ombudsman. We welcome you, Mr Bilson. Welcome back to Estimates. In the interests of time, I'm wondering if it would be agreeable to you if we just table your opening statement and you may wish to make a few opening remarks.
Thank you. If I could make a couple, that would be much appreciated.
Indeed, thank you.
It's interesting times for small and family businesses, Chair and Senators, and it's pleasing at least this Christmas and this summer trading period there were no COVID lockdowns and the like, and that brought an air of optimism. There's still an enormous economic contribution being made by the small and family business community, and we want to honour that. Small business community, Chair, still seems to be quite optimistic and reporting a growth mindset, even with some headwinds. They include the labour market challenges and filling rosters, still some supply chain challenges. Energy costs are a concern. Cyber security fears remain front of mind, and even adjusting to an environment where inflation's higher than many are familiar with is presenting some new challenges as well. Still making that enormous contribution though, Chair. 2 out of every 5 private sector jobs and a third of our GDP comes through their endeavour and enterprise, and something that's perhaps not well known. 43% of all apprentices and trainees in training are hosted by small and family businesses. That's nearly double the number of big business, so that's a very important contribution. Some of those key facts are on a new data portal that we've released, Senators, which gives some really good insights into what's happening in the small business community. Interestingly, nearly half, 47%, of small business owners are aged over 50, so we should maybe turn our mind to that demography and what that might mean for the future. Yet only 8% of those business owners are under 30, so there's something happening there, and our need to replenish that generation of entrepreneurs. Flexibility around self-employment still seems to be a really important priority for many. 22% of non-employing owner-managers aged over 60 are self-employed, and compared to that age cohort, only 9% of that age cohort are employees. And particularly for women, Chair, still self-employment is a really important option for balancing work and other responsibilities, and the statistics are quite compelling in that space as well. Good to see female business ownership continues to be really strong, and we're seeing the proportion of business owners increasing in terms of women's leadership of them. Something also I'd encourage the committee to turn their mind to, the total personal income total personal income from all sources for 61% of small business owners is less than $78,000 in 2021. These are not wealthy Australians. That's a number quite notably under full-time average total earnings across all industries. I might skate through some of the other information just to emphasise we are seeing some trends up in insolvency numbers. They are coming nearer to pre-COVID levels, and that's not unsurprising, although there is quite a spike in the construction industry. We've been very active contributing to the corporate insolvency system review that the parliaments are bringing forward, and that's part of our advocacy work, Chair and Senators, that's seen us respond to 8 regulatory impact statements, 102 submissions to various inquiries and Treasury pieces of work. Working closely with other agencies, though, you'd be aware we're very involved with other federal regulator agencies and also the Cyber Security Centre and others, and still continue to get over 6,000 requests for assistance from small and family businesses, and 175,000 odd or more visits to our website where there's important resources and tools. Senators, you might be aware that we've had a fair bit to say about payment times and performance of larger businesses paying their smaller businesses, and 40% of our disputes still involve payment-related matters. So we're working closely with Dr. Craig Emerson and the review process on that. And I heard the remarks about insurance earlier. That still is a very big focus for us, ma'am, and we can maybe take some questions on that. But there is a gripping opening statement in full, and I'd commend people to it. It's not Gettysburg, yes, but it's some interesting facts in there that may be of use to the Senate and the Parliament.
Thank you very much, Mr Bilson, and we will table your opening statement. And Senator McGrath has some questions.
Thank you. Welcome, Ombudsman. Creditor Watch have released a report which ranked the hospitality sector the highest in terms of probability of default by a considerable margin, noting that, and I quote, "The RBA's tightening of monetary policy is beginning to bite on top of other challenges like labour shortages and supply chain disruptions." End of quote. Are you aware of this report?
Yes, sir. I think it was released this morning. Okay. And in fact, it's a phenomena that's been with us for a little while. The hospitality sector is also experiencing quite a challenging time with commercial rents, in some cases being asked to recover adjustments made during the COVID period on top of CPI-related rent increases and also financing costs. So there's quite a lot going on there, including labour supply challenges, and that hospitality sector's really feeling many headwinds at the moment, sir.
Do you know how many small businesses will go off a fixed interest rate this year and risk defaulting?
No, sir. There's probably 2 parts to that question, Senator. Half of all small business loans are actually secured by personal assets, in most cases housing. So there is that correlation, but how that finance is structured can see it a business loan with housing, or a general loan funded by housing applied to the business. So that's where it gets a little bit confusing. The small business, let's say working capital financing, where housing's not a connection, having a fixed interest rate is unfamiliar. Those rates are also going up to about 6.25% just for small business loans generally. So, but I don't have a line of sight on how many of those business owners who also have housing loans will be caught by that shift from fixed to variable.
Okay. Are you aware of anything about the risk of default of small businesses under this increased interest rate regime?
It's been, I suppose, encouraging to observe that major financiers have been really quite proactive, working with small business lenders to, in some cases, restructure the origination so that risk of default is down. There's also quite, for the major banks, where there is that risk, they lean in quite quickly on hardship provisions and the like. We haven't seen any great increase in that formal area of finance, but in the Creditor Watch report you were referring to earlier, Senator, it does point to trade receivables becoming more challenging. So there's something going on there. We haven't seen any direct data about what the risk of default is for small business loans.
The report said that credit inquiries are up 129% year on year. What have you observed in relation to that particular aspect?
That trend's been there for some time. The appetite for credits continued to be quite high. I could only offer a hypothesis because I know Creditor Watch didn't offer one themselves, but in some cases, and we look at the Reserve Bank figures where business owners are tapping into their own finances to provide the liquidity they need for their business, I suspect it's partly that there's quite a number that aren't trading profitably at the moment. They're needing to have access to working capital. We can make some inquiries through Creditor Watch if that's of assistance to you and the committee to get a greater granularity on the nature of that credit inquiry. But we think it's about cash flow. In some cases, it's also about retooling. I mentioned earlier there's some data suggesting small businesses have quite a strong growth mindset at the moment, and there was another finance report that pointed to a growth ambition also sitting behind an increase in credit inquiries.
If you could come back in relation to that, so what support do you provide to those at risk of defaulting?
Well, there's a few things that we do. If there's a dispute at the heart of the matter, Senator, we'll get involved in trying to equip the small business with tools to engage effectively with the other party. We give early encouragement for them to speak to their financiers. If there's obligations owed to the tax office, we help navigate those avenues that are available. And in some cases, our team may refer them to the Small Business Debt Helpline or other resources like that, and sadly an increasing number also need emotional wellbeing support. So we'll come in at that level. If there's a sense, and we have had some examples of non-AFCA members being quite aggressive, they sit outside the AFCA framework of a commitment to arbitration. Those difficult, may I use the phrase, fringe financier disputes come to us, and then we get involved where there's equipment recovery and things like that. So that's the spread of activity we provide, along with helpful resources that are more generally available for the small business community.
Now, my understanding that about $8 million of funding was partially redirected from you. Is that correct?
Yeah, got quite a discussion at the last Senate estimates. I think the Treasury people explained the nature of that. In not the last budget, but the one prior, there was a one-off allocation of funding for a program called My Business Future. The incoming government looked at those initiatives to identify whether a redirection or a continuation or a discontinuation was appropriate. The decision was made to redirect $8 million into, I think it was a little over $15 million that went towards extending the new access to small business owners mental health coaching program offered by the Richmond Fellowship and Beyond Blue, and also to continue the Small Business Debt Helpline service, which had expiring funds. So that $8 million was redirected, and the program that was announced didn't proceed.
Has this redirection resulted in a reduction of staffing levels across your agency?
No, it didn't. This was a one-off allocation, really geared at increasing support for, let's say, financially informed decision-making. Those businesses that had come through COVID in quite a different shape. It was about ensuring they could make good decisions about what to do next, how to restructure, dare I use the word pivot, Senator, or in some cases a dignified dismount. There's a range of service providers that had communicated to us through our Small Business Natural Disaster Preparedness and Resilience Inquiry that they were very busy, that there were many people wishing for the type of support they gave after the disaster event, wishing it was available before the event, and it was through that lens that a one-off allocation was provided, and that was the $8 million.
Okay, so it hasn't impacted your ability to carry out any of your programs?
No, sir. Our operational funding has been maintained. We've had no impact on that type of activity. This was a new additional initiative, a one-off that wasn't proceeded with.
How many times has the Treasurer met with you?
I don't think I've met with the Treasurer, sir.
Okay.
I was just checking. We are in regular, fulsome contact with senior Treasury officials and ministers. Our primary ministerial contacts are the Minister for Small Business. We also work closely with the Assistant Minister. We've been engaged with the Minister responsible for disaster preparedness, the Minister to my left, and our interest in government procurement for SMEs has seen us involved as well, but I haven't met personally with the Treasurer.
So you haven't met with the Treasurer?
No.
But you've met with the Minister for Small Business?
Yes, a number of times.
On notice, can you list how many times that you've met with the Minister?
I can check that.
Okay.
That's meeting. There's regular email communications as well. So
But between the office of the Minister for Small Business?
Yep.
Okay, but not between you and the Minister
no,
directly?
occasionally. If I see things, I'll give you one example. The work we do with the State Small Business Commissioners involves the Small Business Friendly Council program. I know there's a keen interest in accelerating development approvals for new housing. I would say, Minister, this might be interesting. This looks like a good idea of streamlining development approval processes. Here's a thought. So there's that sort of exchange as well.
Which is good from your end, but did the Minister seek your advice on the example of Labor's industrial relation law changes that they put through Parliament last year?
It might come as a surprise to you. I didn't wait for an invitation.
No, I like you.
I know. I thought you might think that, Minister. No, we thought that was an important set of policy measures, and in keeping with what's in the Fair Work Act that says the specific circumstances of small business will be taken into account. On that basis, we provided some input, and that included sharing our input, I think, to the parliamentary inquiry that was conducted. I think was our channel where we made that available, and we were proactive in that regard, Senator.
Okay. I mean, the Minister was asked in Parliament in relation to these laws if they could name a small business who supported the passing of those laws.
I did observe that question, Senator. Yes.
So are you able to name a small business who would supported the changing of those laws?
This might come as a surprise, but because we are an assistance service provider, a policy advocate, and a provider of data that explains the nature of the small business community, the voluntary contact with our office is usually by people who are aggrieved about something, not delighted about something. So we didn't have contact of the kind you're describing, Senator.
Did the Minister for Small Business consult with you before the announcement about the end of the instant asset write-off and the loss carryback function?
No, ma'am. No, sir.
Okay. Has the government commissioned any reviews or inquiries from you?
Not at this stage. I'm optimistic. There's some under our legislation where we can initiate our own inquiries, and there's some interest in that as well. We're keen to work collaboratively with the government, federal portfolios and regulators so that our work is at least landing on receptive ears. I'd hate to use scarce taxpayers' resources for a frolic on a topic where there's little appetite. So we have those conversations, but at this stage, the last referral we received was from the former government around natural disaster preparedness and resilience.
Senator McGrath, in the interest of managing time, do you have a final question or two?
I do, unless Senator O'Neill wants to ask us a question while I just check something here. So in terms of to be fair, so I can't, Chair, I'm not driving from the back seat or anything. I'm just trying to be a team player here.
I think you
I'm just checking something. So
Senator McGrath.
I think you are a bit of a backseat driver.
That is.
I sense.
Chair, I sense this is a time where there's no contribution I should make. So
I think Senator McGrath's ready to go with the call.
Yes, I do.
The question came through.
Thank you.
I don't want my
I'm also good at filibustering too. So in addition to being
We're
a
all
back.
well supported by teams.
I've got a very good team. So thank you everybody who's watching.
Right now.
Many small business groups have said that the IR laws will hurt small businesses as a support service, do you anticipate an uptick in businesses seeking advice, particularly to comply with the new arrangements around multi-employer bargaining?
We would ordinarily guide inquiries of that kind to the Fair Work Ombudsman. One of the things that's in our statute is not to duplicate activities of other agencies. At this stage, our focus is on working closely with the Fair Work Ombudsman to make sure there's, and I use the phrase actionable information for small and family businesses. These small workplaces don't want some turgid IR speak when they really want a clear answer about what's needed and what's required. So that's been our focus, Senator, is working to make sure those resources are available. Inquiries that we've had have really been of the nature of where did the policy debate land. You might recall there was quite a discussion around the size of a small business that might be exempt from certain provisions, another tier relating to a positive onus on proving that a business should be entered into engaged in multi-employer bargaining. That left a lot of smaller businesses a little confused about where it landed. So we've been providing that information and then amplifying the resources that the Fair Work Ombudsman Office produces.
Just one final question, sorry. What in relation to your assistance function, I just want to check, just confirm, what's the number one issue that's being raised by small businesses at the moment?
Payment times.
Sorry?
Payment times. 40% of them are payment times.
Okay. What's number second?
I think it's franchising. I might throw to my colleague Dr Latham if I may.
Probably second to payment times, actual payment is contracts, and so it will be things like missupply of goods or inappropriate goods or services. Franchising is up there as well. It's another, that would be third probably.
So just to unpack that a little bit, those contractual disputes might be I haven't, a key input has been held up in a supply chain. What am I supposed to do? And both parties sort of advocating their position. We try and find a resolution in a collaborative way. So that they tend to run into payment times. I've had a couple where people have ordered things that haven't arrived in a timely way, and then there's been a little bit of an arm wrestle over whether they should get a refund or a credit note. That kind of thing is in the mix as well.
Right. Thank you very much, Mr Bilson. Thank you, Senator McGrath. I think that concludes your questions. Senator McGrath, thank you.
There'll be one's coming on notice.
There'll be some questions on...
To a notice?
You can put some questions on notice.
Because we've run out of time to keep everything on schedule.
Yeah.
Of course, the franchising sector continues to be of considerable interest, and there are many challenges there. So some questions on franchising coming, and I'm sure we'll be interested in what happens with Mercedes-Benz case. Finally, just to draw your attention to a report that will land, I think, on the 3rd of March from the Work and Care Committee. I think it's very interesting how that might interact with your statement about women becoming small business owners, particularly seeing, as you've indicated, that they end up with a lower income than the employed. We have some stats that are concerning about women in Australia being in part-time work more than any other OECD country. I think there's an intersection there that might be worth exploring at our next opportunity.
Well, and particularly women business owners, it's a greater proportion as well.
If you can have a look at that.
And Senator O'Neill's indicated that those questions will come on notice. So thank you very much, Senator O'Neill. Thank you very much, Mr Bilson. Thank you to representatives of the Australian Small Business and Family Enterprise Ombudsman. Thanks for answering our questions. You go with our thanks. Thank you. And we now welcome the National Housing Finance and Investments Corporation and its representatives. We'll take a short suspension from broadcasting while they join us at the table. Commencing now with the National Housing Finance and Investments Corporation, and we welcome you back to Estimates, Mr Dal Bon. Did you have any opening remarks that you wished to make?
Nathan Dalbon, Chief Executive Officer. No, happy to go straight to questions. Thank you, Chair.
That's music to our ears as we're running behind. Thank you very much, Mr Dalbon. And are you seeking the call?
No questions.
You're not seeking the call. You sure you're not seeking the call, Senator Gray? Okay. I understand that there may be some questions from senators on notice at a later date. Mr Dalbon, it appears that there are no questions in this hearing for you. Questions I'm sure will be put on notice at a later date. That was a very brief appearance and we thank you very much for your attendance to the committee.
No problem.
The committee will now break until 11:45. The committee's proceedings today will resume with the Department of Industry, Science and Resources portfolio, beginning with the corporate division. The hearing will then follow the order as set out in the circulated program. The committee has set 3 March 2023 as the date by which senators are to submit written questions on notice, and 31 March 2023 as the date for the return of answers to questions taken on notice. I now welcome Senator the Honourable Tim Ayres, representing the Minister for Industry and Science. I also welcome the Secretary for the Department of Industry, Science and Resources, Ms Quinn, and officers from the department. I see, Ms Quinn, that you do have an opening statement in relation to department updates that we will table, and it looks like you may also like to speak to that.
So I'm happy to table it. It just provides an update on the restructure that this department has undergone since the last committee, and I thought it would be helpful just to set it out. But it's very short, and I'm sure committee members can read it as they need through the proceedings.
Okay, thank you, Ms Quinn, and the committee will table your statement with those updates, and we'll proceed straight to questioning. And I'm looking for a senator who wishes to take the call. Senator McDonald.
Thank you very much, Chair. Good morning, Ms Quinn and Minister. I have questions for corporate, and starting with you, Ms Quinn. Both Minister King and Minister Husic were both heavily involved in the government's gas intervention last year. Can you, at a high level, explain how the department sees supply-side issues are impacting gas prices in Australia, and how this has informed the advice given to both ministers over the last 9 months?
So I'm happy to give you a high level. It really is our Resources and Strategy group led by Jane Urquhart, which is scheduled next. But from a high level, we're heavily involved with the government processes around all the different components of the gas question. We were part of the Secretary's discussion, part of the Interdepartmental Committee discussions. Our ministers were part of the Cabinet process. Our responsibilities covered, as you mentioned, both the resources side, which is Minister King's responsibilities in relation to resource extraction, which goes to what is the supply of gas and also the export processes, so the Australian Domestic Gas Security Mechanism and the heads of agreement that Minister King has struck with the East Coast gas exporters. And then the other line of briefing and analysis was around the impact of energy prices, not just gas but also coal and electricity prices more generally on the industrial sectors and those that use those energy inputs as feedstock, not just as energy costs. In terms of the overall impact of the government's package, it's very much focused on temporary price cap through the $12 reasonable price declaration under the Treasury portfolio. That's a temporary measure to stabilise the market. And then there is an ongoing process code, which is the responsibility of Department of Environment, Energy and Water, which is working through with industry now what the ongoing relationships are between producers and users in terms of how they interact with each other to strike contracts. In terms of the impact on supply, the latest data that we have shows a very strong pipeline of supply coming through the energy sector in general in Australia. That data was released in December, so we'll wait to see an update coming through, but it does suggest a very strong pipeline and it had picked up, and that partly is responding to the high demand for energy, particularly internationally, in terms of the high prices of gas and coal. And that is a very strong driver for supply going forward. And so we wait to see how that goes forward.
Do you have details on the physical projects of bringing supply forward? We've seen a number of announcements of projects that have been delayed or cancelled that would bring forward supply. But what about projects that have initiated or are increasing supply? Can you point to any of those?
So we do track that through the major projects reporting process, and as I mentioned, the latest data that the department's released was in December, and there are it goes through, as you say, the different stages of processes for government, industry investment decisions. You mentioned there are some companies who have paused and are looking at the regulatory regime now. I'm not aware of any that have cancelled. So there's a pause as people look at the regulation at the moment and work through that with the Treasury, DQ and ACCC, but I'm not aware of any cancellations. But the next time the department updates that, they will go through all the technical detail and go through all the different projects and update where they are at.
When would you expect the next update to be?
It's annual is my understanding, but I might just check with my colleague. It is annual. Yes, it's annual in December.
Do you think there might be any chance of an interim report this year, given the amount of activity that there's been in the gas market?
I'm happy to take that on notice and talk with the Minister about it. I mean, there are updates. The Minister does provide updates through the course of her parliamentary duties, etc. And it may be that we're able to collect interim data, but I would need to check on the most important thing here is comparability through time, so that you can get a sense of how things are happening. Often into year isn't particularly helpful, but I understand there's a great deal of interest in what's happening on energy projects, so I'm happy to take it on notice.
It is great to be talking to you. I've talked to a number of other departments about supply and gas over the last few days and had interesting answers, which I think perhaps reflect that this is the right department to be speaking to. One of them was a suggestion that the new field releases in Western Australia that the Minister has made, that will affect domestic supply, but then they weren't aware of the pause on the two import terminals that had been proposed that have now no longer proceeding. So just a demonstration of their lack of understanding of how you move gas, I guess. I'd be keen to hear how the department manages the competing policies between policy priorities between the ministers and differentiate their respective groups within the department.
So as a department, we very much work across all our areas of expertise. It's rare that any of our policy issues work in silos. We find that the best advice to provide government is when we do look across the different elements. In terms of the energy example, there's a lot of synergies between the objectives of the individual ministers that fit within the government's overall objective, which is for a strong and resilient economy and responding to international circumstances. We haven't found any particular issues in terms of managing different perspectives. We provide holistic advice to both ministers, taking into account the views across the spectrum. Sometimes there are particular nuances. Minister for Industry, for example, has a broader remit looking at the consequences for feedstock and processes, and that feeds into the industrial policy framework. Minister King focused on resources and critical minerals and the need for energy. In developing critical minerals, for example, there's a strong synergy in terms of their approaches on those issues.
How does the department maintain consistency of advice on issues that cut across the department?
So we have internal processes to make sure that our different divisions are working together. I have my leadership team, and we work very closely together to ensure that we're balancing our advice and making sure that we're pulling it together as a whole package. So we have both a focus on it from a leadership perspective, but also mechanisms in terms of clearance of information and sorting through any silos, which can happen when people are busy and looking at issues. We also have a strategic policy group which helps us coordinate issues when they're cross-cutting across the whole of the department. So, for example, issues to do with our engagement with First Nations people or climate change policies, those sorts of things. Job Summit we talked about last time. Those things are really cross-cutting across all parts of the department, and so we have a strategic policy area that helps us coordinate. But mostly it comes down to a very clear leadership direction to have holistic advice for ministers and the government.
Were there any instances over the last 9 months where advice or briefings from officials provided to the industry and resources ministers may have differed or had different emphasis?
Sometimes ministers ask for particular information about particular sectors that might be of focus to them, so sometimes there's a slightly different cutting of data. There is certainly sometimes a different emphasis on things, but in general the advice is very consistent across ministers.
Of course, Senator, you'll know in asking the question that, of course, advice provided by the department for ministers in them considering how they approach their work in the context of cabinet deliberations is not something that can be.
Well, have I asked anything that the
No, I'm just pointing out for anybody. I'm just pointing out for anybody who might have been listening that might have apprehended that Senator McDonald was about to wander into that territory that she had no intention of doing. Indeed.
Yes.
Always.
Yes, Minister, I'm very grateful for
always trying to be helpful.
Explaining the process of government to me.
Thank you, everyone.
Yes, who would have thought I wouldn't have understood that?
Thank you, Senator McDonald, but I might just take the opportunity of that intervention just to seek some advice from Ms Quinn about whether these questions are properly dealt with in corporate or program 1.3.
I think ministerial arrangements are generally dealt with in corporate, which is why I'm directing them at this point.
Okay.
So
you're happy for them to be dealt with in
our
corporate?
ministerial arrangements are actually part. They're a corporate component. The gas issues are actually resources or industry, but so I'm okay.
Okay, well, we'll just be aware that we're trying to stick to corporate, then release corporate and then move to program 1.3. Senator McDonald, you have the call.
Oh, terrific, thank you. So, Secretary, when feeding the department's view into the government's broader response last year, how did this advice balance the need for affordable gas with one minister and the need to maintain and increase development to ensure adequate supply over the forward years?
So I don't see that there's a binding clash there between those two objectives. It's clearly important that Australia has energy security going forward and that we have affordable energy for our industrial processes, also other parts of the resources sector. So that's a clear priority. It's also clear that we need to have profitable firms to be able to explore and to invest and extract the resources that will provide the energy. So as always, there's a balance about near-term versus longer-term challenges and occasions. The situation the government found itself in was a significant spike in energy prices as a result of things outside their control in terms of the Ukraine war and the demand for energy. And there was a set of issues put on the table for them to consider. And so I don't see that there's a clash between those two things. The process we go through for providing advice is always grounded in facts. So what are the facts of the matter? What's the shape of the problem? Defining the problem. We then go to an insight. So what are the insights? We draw from that process, and then we move to a what does that mean in terms of policy options and the tools that the government has before it. And it can be the case that sometimes the tools that you might want to use have different trade-offs in terms of length of time it takes for them to impact on the problem, the complexity and how they engage. And so we have to work through all of those issues. I think there's a lot of benefit in having resources and industry together on this issue, because you do get to see all the different perspectives, and for us we get to talk to the different stakeholders and really test some of those facts, some of those insights, and then what to do about it. So in that sense I think that there are trade-offs occasionally, but on this occasion it felt like there was a lot of synergies, because it's important that industries have stable regulatory environments that they can then plan off. And in response to an extraordinary shock like the Ukraine war, it's important that regulation is clarified for all parties so they can move forward and make business decisions on that basis.
So just on that, I asked questions of Treasury yesterday around their sensitivity analysis of regulatory changes on investment decisions. Is this something that you're having input, your department is having input into that Treasury analysis?
So we do talk to Treasury regularly, as with our colleagues in the Department of Energy and the ACCC. There are processes to make sure that we're feeding in information that we're receiving. We're part of their discussions with parties that are our key stakeholders as well. In terms of the specific question, I'm happy to take it on notice. One of the issues just to kind of think through is that there's still some uncertainty about the regulatory regime, because the government's working through a process of clarifying the code and how the code will work, and the Treasury, DQ and ACCC and ourselves are working through that with industry. So the reasonable price component, as you know, is out for consultation and discussion now. And so part of thinking about how a regulatory regime might consider a reasonable price, it's really important that we think about the implications for decision making for business and what impacts that might have on their investment decisions going forward. That I understand, I didn't listen to ACCC's evidence, but I've been informed that Ms Cascott-Lee highlighted the importance of supply conditions in their discussions, and that is something that we've certainly talked to them about.
So, just in summary, is it correct if I heard you say that you are having input into the Treasury's sensitivity analysis to the impact of regulation on investment decisions, or was that something you're taking on notice?
That specific question I'd have to take on notice.
Okay. Specifically, has the department provided in their advice or briefings to Minister Husic or his office anything in relation to gas supply and or pricing?
Yes, we provide quite a lot of briefing to both ministers on various aspects of the gas industry.
Yes, so pricing is, I guess, what he would be interested in, I assume. If so, when and on how many occasions?
So I'm happy to take that on notice. I mean, we provide, as you can imagine, in a very fast-moving policy environment, we move to a sort of situation update, situation awareness update sort of system. And so at one stage we're providing briefing intraday, then daily, and then we sort of wound back a little bit to a more steady path over Christmas, etc. So we provide information on intelligence and what's happening in the market, what's happening in the environment, and just to be kind of clear, it's very important for industry that there is a supply of gas because obviously supply affects the price, and it's important that they can have access to quantities of gas they need at a reasonable price. So industry cares about both price and quantity, and clearly the companies care about their ability to extract and what price and what costs they incur. So there's not much difference between the focus for both sides of the user and the producer side.
So those briefings would be drawing on the resources group through the industry group through you, I assume, through to the
We provided
Minister.
integrated advice across the different areas to both ministers. And we provided that information into the system as well for other ministers.
As the Senior Minister, would the Minister for Resources or her office be copied in on any advice that relates to gas supply?
In terms of responsibilities and things like that, I mean, I'm happy to... Gas supply questions clearly are the responsibility for the Minister for Resources. If the Minister for Industry was interested in that issue, I would have to check, but mostly it's been integrated advice. So I'd have to double check whether there is an occasion where it went one way or the other. Sometimes that's the case because it's just a fact-based question and it's not a sort of significant policy issue.
Would you take that on notice for me then, please, and let me know how often that's happened? Thank you. Are you aware of Minister Husick's comments in relation to gas supply where he stated this is not a shortage of supply problem, this is a glut of greed problem that has to be basically short-circuited and common sense prevail?
So I have read his media discussions on this topic, yes.
Is it the department's position that rising gas prices are not a result of shortage in supply but rather a glut of greed problem?
So the rising gas prices primarily as a result of global supply issues and the international price being very high, and then the connection between the international market and the Australian market. There is a significant amount of supply available in the Australian market. The question is at what price and what's the influence between the domestic supply and demand and what's the influence of the international supply and demand. But the Russian withdrawal of their supply into the international market was the significant event last year on the gas prices.
Does the language from Minister Husick make it harder for the Resources Group and Minister King to engage with gas producers?
Again, I just, I understand it's an old thing, isn't it? That ministers make political comments in the court that they make in the exercise of their ministerial duties. Senators ask questions about the opinions of officials about that. That's not something that that officials are in a position to answer. Opinions as to policy matters is not something that officials are really in a position to answer for you. I understand why you'd ask, but if you can direct the question to be more on the basis of a question that is about something that the official is doing, then I think it's in order. But questions about opinions are not in order, in my view.
You aren't the chair.
No, please don't interrupt the Minister from explaining the processes of government to me. I'm not sure how I would go on
I'm just not going to allow...
As always.
What, get up from my chair for 1 second, and what happens?
And also, Senator McGrath,
anyway,
I'm not the chair.
Can we keep going? We're going to run out of time.
Answering a question, I believe.
Yes.
I think the Minister was taking a point of order and then answering it himself, Chair. We missed you.
You have the call, Senator McDonald.
Thank you. Minister King seems to have contradicted the Minister for Industry on this issue. In a media release dated the 29th of September 2022, the Minister states the Australian Government has signed a new heads of agreement with East Coast LNG exporters to prevent a gas supply shortfall and secure competitively priced gas from the domestic market. And Minister King appears to be saying that securing more supply will ensure competitively priced gas. So I'm trying to understand, is Minister Husick right that this is not a supply side issue, or is Minister King correct that this is a supply side issue?
I'm very happy to answer that question. There's a contrast, isn't there, really, between two kinds of governments. And I know that you're used to the old show.
Minister, I don't get much time today.
Well,
the chair will pull me up shortly.
You've asked a question. And and I intend to answer it.
You're going to answer a different question, which is not the purpose of today. The purpose of today is the opposition to hold the government and the departments to account.
I'm going to answer your question.
All right.
What your question went to is, I suppose, a difference between what ministers are saying. And the truth is that the Prime Minister is running a proper cabinet-style government, where ministers exercise their functions and duties and get an opportunity to do that in a proper Westminster cabinet-style way. And these issues that you're going to have some complexity, of course, but complexity defeated the last government. And the reason that complexity defeated the last government is because power was entirely centralised in the hands of the Prime Minister's office, which is why he thought it was okay to secretly swear himself into a series of portfolios.
Come on.
And why energy policy was entirely dysfunctional, and we had 22 failed energy policies. 22 failed energy policies.
Of the department, because you are grandstanding on political points.
Well, you've asked a question about the two ministers. I've answered it.
No. Okay, all right. I think the minister has concluded his answer. I'm just going to take the opportunity again to just consult live with colleagues as to whether we're effectively in program 1.3 in general here, or whether you think we're still in corporate, because I could release corporate.
No,
or I could bring up program 1.3 and corporate could wait, Ms. Quinn, just to see if there are further answers for corporate.
Yeah, so I mean, if I had a preference, I'm not sure if I do, but I have my corporate colleagues here, and so if there were questions for corporate given the program, it would be useful for us to be able to conclude those, and then we could move on to 1.3, because I have other staff coming against the...
It does sound, Senator McDonald, like your questions are going to get answered, either way, but they do seem to be effectively program 1.3. So,
I was trying to understand the ministerial interactions and process from the secretary's point of view around, ministerial arrangements and advice.
Genuinely ask then that you just sort of focus the last couple of questions on that narrow focus, and then we release corporate and go on to 1.3 more broadly.
Absolutely, Chair. I'm happy to be guided by you. So, I'm sorry, I'm just getting back to my place in the orders.
A couple of brief questions.
For corporate.
Is that all right, Chair?
Absolutely.
Thank
Senator Duniam.
Hello, Secretary. Does the department have any major capital works projects underway within the portfolio?
So we do have, in terms of the portfolio, there's a diversity of activities, and some of our agencies do require quite a lot of capital works.
Yes.
And so, for example, we look after Questacon, which is, and we look after the building and all the elements to it, and we have the National Measurement Institute, which has laboratories and
I remember the NMI,
very complicated machines, etc. So they do require a fair bit of capital investment, and we do have projects in both of those spaces going to the capital improvements of the infrastructure that they work on at the moment.
Sure.
But they don't necessarily make the major capital works.
Understood.
But there are some areas where we are looking at needing to make capital works, but some of that's in our portfolio agencies rather than the department per se.
Itself. Yeah, understood. More broadly, and perhaps it is something that needs to be taken on notice, but the interaction with the Department of Finance, there's this emerging, as it turns out, property and projects division, which I wasn't aware of until the last couple of days. Does the department or its agencies have any sort of standing relationship with this branch within the Department of Finance and how does that work?
Yeah, so happy to talk at a high level and get further colleagues if you would like more information, but the Department of Finance provides advice to the government on all sorts of aspects, but particularly they focus on capital elements. They're thinking about how they do major projects because they are complicated and they're multi-year projects and require a lot of expertise. And we do work very closely, and the portfolio agencies in particular work closely with finance when they've got major capital works to draw on their expertise and make sure that it's a whole of government approach. So, for example, this question that could go to CSIRO later, that they've got a project of moving some of their staff, and so that's a big capital project movement, and so that they work closely with finance to make sure that works.
With that particular branch I referenced earlier, this
I
project...
have to double check whether that... I have on the top of my head all the different names and components, but there is a part of finance that very much looks at property and looks at capital projects. I don't know what their exact divisional name is.
No, that's fine. Look, I suppose I will put questions on notice. I'm just trying to understand what this ethereal and mysterious unit within the Department of Finance does, and what the standing relationship is between government agencies, large ones, particularly who I had understood in the past at least, and particularly with agencies like SARO or ANSTO, have a lot of in-house experience with the specific nature of the work they do and the capital works required, as opposed to, say, someone with other expertise in the Department of Finance who might be good at signing contracts, etc. So I'll put questions on notice around that rather than testing you about something that's probably very detailed and well outside of the scope of what's on your desk. But thank you, Chair.
Thank you, Senator Daniam. Senator McDonald, do you have questions for corporate?
Yes, I was going to ask the department if they could table a sample of the paper that the Minister is using. I've read about it in the media.
Good question.
And I'm quite excited to see what it looks like.
I'm not sure I understand which paper you're talking about.
I understand that the paper is $100 ream.
Oh, sorry, you mean
from Italy. Yes.
It's a standard paper sourced through whole of government processes, and the department has been sourcing it for ministers in our portfolio since 2017, as I understand it. 2015, sorry. It's standard paper that's been used. I'm kind of happy to take it on notice and see whether the Minister would like to provide a version, but it was used by the previous government.
This is an Abbott era.
Mr. Rees, do you use this paper?
I haven't seen. I
exciting,
don't know what
isn't
the
it?
paper would look like or what
I would like
special
to see
qualities it might have, but I've noticed that. The deputy leader of the Liberal Party has spent some time on this question. The $15 billion program that we have, $15 billion program to rebuild Australian manufacturing, silence and no from the Conservative side of politics.
Can I have discrete answers and discrete questions, please?
We're hearing all about now.
You're subtracting from our knowledge by extending
Senator
the
McGrath.
If you want to spend more time on this, be our guest.
We will. It's the hypocrisy of Labor.
But the judgment
about supporting Australian manufacturing, and yet the minister concerned uses imported paper. So this is where we're coming from. Labor talk about doing one thing, but when it comes to delivery, do the exact opposite. That's what we're asking this government about.
It's the kind of
for their words.
It's the kind of inane political sloganeering that characterised your period in government.
No, this is about
if you want to ask questions that are relevant,
Senator McGrath, this forum is for questions that are appropriate to the estimates program, and I really appreciate discrete questions being asked and then answers being given, and then another question that is appropriate can be asked. So I'm looking to see who is seeking the call to ask an identifiable question of the Minister. Is that you, Senator McDonald?
I still have more questions, yes, thank you. I referred to the appointments announced by the Minister on the 13th of December 2022 in regard to the National Robotics Strategy Advisory Committee. How many expressions of interest or applications did the department receive?
So this is a question that I would refer to my team that do science and technology, who are looking after the robotics strategy. Appointments to that body were dealt with through those staff who are program 1.1 who will be here this evening. So I'm happy to take it on notice and get them to answer it this evening if that assists the committee.
All right, we'll come back to those ones. So, back to, oh no, sorry. I wanted to ask questions about the, I'm sorry?
The other committees are having too much fun though.
Would this be an opportune time to move from corporate? Or?
Chair, no, I
Okay.
still have
Rightio.
pages of
Okay.
questions.
You are the eternal optimist, Chair.
I know, it's lovely, isn't it? Not losing hope. The Minister for Industry and Science recently travelled to the US. Is that correct? Is this the right place to ask questions about that?
So he did travel to the US, that's correct.
Terrific. What were the dates of that travel, including any personal stopovers that the Minister took?
I would have to take it on notice. I'll just pass to my colleague Jane Urquhart, who looks after the international division.
Thank you.
Senator Jane Urquhart, Deputy Secretary. Minister Husic visited the US between 25 January and 2 February.
I'm sorry, just say that again, please. It was quite quick. I didn't get it down.
Between 25 January and 2 February.
And 2 February. Did the Minister fly business class?
Senator, my assumption is yes, although, you know, I would want to check that because there were different flights in the program, and so I would want to check, you know, there may be exceptions to that depending on route availability.
All right, so you'll come take that on notice, please. Did those attending alongside the Minister, personal staff or department officials fly business class?
Again, I would assume so, Senator, but I would want to check.
Thank you, so I'll take that on notice. Thank you. Could you please provide a detailed itinerary for the trip, including official meetings or events and who attended, and including any personal appointments, meetings or events the Minister attended?
So on details, I'd need to take it on notice, but at a high level I can tell you that the trip took in San Francisco, Los Angeles, Washington DC and Boston.
Thank you.
Oh, and Senator, it may be helpful, obviously, to state too the aim of the trip was about promoting commercial and economic integration with the US, which is obvious, you know, the US being a priority partner for Australia and the portfolio.
That is terrific. Thank you. Can I move to the Boosting Women in STEM program?
So this is not in our
It's not in
corporate area.
corporate?
This is in our science and technology 1.1.
Okay.
Which is on
this evening.
O'clock tonight.
All right. Well, I think, I'm just looking at these, I think I'm going to be directed to other sections of the portfolio throughout the day. So I can hand back to another senator, or you can let corporate go.
Okay. On that basis, we'll release corporate with our thanks. Thank you very much. And the committee will welcome representatives from program 1.3, supporting a strong resources sector. Ms Quinn, do we need to bring someone to the table?
I think we can start with
Okay.
Deputy
So-
Secretary responsible.
Thank you. So we're now in program 1.3. And Senator McDonald, do you have the
Terrific,
call?
thank you. Right, try again. Secretary, the ACCC has twice now forecast a gas shortfall across the East Coast in 2023 and in 2027 and beyond. The government has legislated a price cap on gas and is planning on introducing a mandatory code of conduct with a reasonable pricing provision attached. Industry and energy analysts have consistently warned that the impact of these measures will result in less supply, resulting from a lack of investor confidence in the market. What is the government doing to bring on new gas supply in light of the ACCC advice that predicts gas shortfalls for the foreseeable future?
So there's a sort of near-term and then a longer-term framing to this answer. In the very near term, in response to the ACCC's initial forecast of a shortfall in the near term, the government reviewed the Australian Domestic Gas Security Mechanism and reviewed the operation of that and decided to change some of the arrangements of the regulatory regime to be able to make it more nimble and more enforceable and more actionable. And that is designed to address the near-term shortfall in terms of the mechanism as a backstop the government would have. As part of that consideration, the government also negotiated with the LNG exporters heads of agreement about their willingness to provide supply in the near term to plug that shortfall gap. And they have signed that agreement with Minister King. And that agreement was to ensure that there was quite a large amount of petajoules above the shortfall that would be available for Australian customers. So in the very near term, there is the heads of agreement and then there is the ADGSM that provides for enough supply into the system. In the longer term, there is a little bit of uncertainty at the moment as people work through the regulatory regime on the reasonable price. But as I mentioned, the ACCC and Department of Energy has been really clear that the reasonable price is about ensuring appropriate supply comes into the market under that regime. So there's working through those details to achieve that objective. And then, of course, it goes to technical things such as acreage releases, the provision of information on exploration data, the geoscience information which the government is supporting through the Geoscience Australia, and then there's working with others about the regulatory regime around the Environmental Act reviews and things like that to make sure that there's a clarity on the regulatory regime that the agencies regulate, but also that the industry experiences. But I'll just pause and just check if my colleagues would like to add anything on what the government's doing on supply.
Senator Jane Urquhart again. So the Secretary's just covered off some of the mechanisms or levers that the government's using around, or did use to take action around shortfall last year for this year, and the reform work that we're doing around the Australian Domestic Gas Security Mechanism in terms of providing a framework to address shortfall and make it more effective. And we can certainly talk more to those reforms should that be of interest to you. Just to be really clear on supply outlook, notwithstanding these current short-term challenges, the ACCC's gas inquiry interim report released in January forecast for the medium term that production from 2P reserves would be sufficient to meet projected domestic and LNG export demand. But beyond 2027, it did raise the question of forecasts potentially being insufficient without additional gas being supplied. It also identified in its report 25 gas projects that were planned to come online by the end of 2027, sitting against that prediction. But noting, of course, and I think the Secretary went a bit to this, there are all sorts of dependencies in this space that we obviously monitor closely, be they geological, commercial, environmental and other approvals, land access agreements, infrastructure requirements, joint venture-related constraints. So, there's a whole host of things there. There's also onshore exploration data from the ABS that shows onshore exploration increasing year on year by 8.5% and has done for a number of years now.
I'm just sorry to interrupt. What date was that last report on the 8.5% increase? What was that most recent date?
Yeah, just let me pull that
Thank
for
you.
you. You go ahead.
Senator David Lawrence, Acting Head of Division Oil and Gas. The report Ms Urquhart's referring to is an ABS one, and my understanding is that was released in December, and the next, well, that is prior to December, and the December figures will be captured in the next set of data, which is published on the 27th of February.
20s. I'm sorry, I didn't quite.
27 February will
27th of February.
There will be an update on that information. So
Yes, we're still in February, sorry.
Yes, that's right.
Terrific, so that'll be the next update. I interrupted you, Ms Urquhart, if you weren't finished.
Yeah, so I'm just thinking about what's further useful. I mean, when you take into consideration that the Australian Energy Market Operator, through its gas statement of opportunities, has forecast that a continuing need for gas as we transition to net zero, I suppose mirrored that picture about needing to pay attention to gas supply. It's important, obviously, that we keep a close eye on the pipeline. And the government does support responsible exploration and development of oil and gas resources, and so we follow that data very closely, as well as talk regularly and both informally and formally to the various players in the sector. I should note that state and territory governments do have primary responsibility for regulating onshore oil and gas leases with respect to exploration and development. And so there's obviously a need for governments to work together very closely in that space. Factors impacting exploration include obviously settings at Commonwealth, state and territory level, but also commodity prices and market conditions, community engagement, including with traditional owners, and I mentioned land access before, as well as taxation and royalties. So the government funds several programs that support exploration. There is the Gas Industry Social and Environmental Research Alliance, which brings together CSIRO, the Commonwealth, states and territories and industry to provide high quality independent scientific research and information to communities in the regions on related topics to exploration. Equally, Geoscience Australia collects and publishes pre-competitive data that assists in de-risking investment and exploration by industry. Programs including Exploring for the Future, the Trusted Environmental and Geological Information Program, and the Data-Driven Discoveries Initiative. And I should mention that those programs do support multiple industries beyond resources, also agriculture, hydrogen applications, carbon capture, utilisation and storage.
Thank you. Earlier, I can't remember if it was you, Ms Urquhart, or the Secretary mentioned the offshore acreage releases.
Mm-hmm.
Which releases were you referring to?
So we've had pretty much annual acreage releases, Senator, up until and including last year. So the 2022 offshore petroleum exploration acreage release was announced on 24 August. Bids will close on 2 March this year. 10 areas were released for bidding. Offshore Northern Territory, Western Australia, the territory of the Ashmore and Cartier Islands and Victoria, all in established what's known as petroleum provinces close to existing infrastructure. That comes on top of the 2021 release, announced on 15 June 2021, comprising 21 areas and covering approximately 80,000 square kilometres across the Bonaparte, Browse, Northern Carnarvon, Otway, Sorrel and Gippsland bases. Bidding for that one closed on 3 March last year and resulted in 10 bids across 9 areas. The National Offshore Petroleum Titles Administrator, which is embedded in the department, has assessed those bids, and we anticipate joint authority decisions soon.
Oh, so that was March of last year, expressions closed.
Yep, on
And-
3 March 2022.
And 12 months later, we should have a decision on... Has anybody withdrawn from that process?
Oh, I'd have to take that from... Would it be...
Senator, I think we'd need to take that on notice.
Yeah, okay, thank you.
Senator McDonald, I know you'll have a couple more questions. I'm also advised that Senator Pocock has some questions of AWA, who are in this program and would be here somewhere, so we might just start to bring them forward while you continue your line of questions.
Okay, thank you. So I'm interested on those acreage releases. So the acreage release for 2022, which went out on the 24th of August, what was the close date for that again? I'm sorry?
That was 2 March 2023.
Right, I see. Okay. I think that the acreage releases have been raised as a possible solution to supply shortfalls. How would you propose that gas enter the eastern domestic market?
Well, the extent of the areas covered by the acreage releases do extend into areas that could supply to the eastern market. Notwithstanding that, it's obviously, a coverage that we are alert to. And what I didn't do, Senator, was point to the future. Nominations for the next offshore exploration acreage release closed on 1 September. So we're into another process of public consultation and bidding dates. I think what's important to mention again is that acreage releases are obviously critical to advancing exploration and then investment and new projects. But notwithstanding that, there are lots of other considerations that come into projects advancing successfully through that pipeline, as I mentioned before.
Can we come back to that in a moment? So could you take on notice the number of acreage applications? I'm not seeking any commercial in confidence. I'd just like to know the number for the 21 release.
I can tell you now, Senator.
Well, I want to do it comparatively with 21, 22 and then you're about to do another acreage release. So when will that go out, did you say?
So, Senator, for 2021 it was 10 bids over 9 areas, but for 2022 bids will close on 2 March, so we don't have a figure yet that we can give you.
Right, okay. So given that I never get responses for some time, I shan't continue with that. So 10 bids for 2021, 2022 will close on the 2nd of March. What date is the close date for questions on notice?
Is it 3 March? 3 March.
So I could ask you on notice how
Absolutely,
many applications
Senator.
you get for 2022, and then I'll follow up on 23 at the next lot of estimates.
Sure.
Which acreage releases would provide gas to the East Coast market? You referred to some would be able to.
Senator, the areas released for exploration around the Otway and Gippsland basins would definitely provide gas to the East Coast market.
Do you have an idea of the prospectivity of that?
I don't have that, but given both basins are, producing basins and are close to existing infrastructure, I'd say they're highly prospective.
How many releases were in the Otway?
Senator, I think we'd have to take that on notice.
definitely.
We know that there were 21 areas across the group, but specifically broken down per basin. We'll need to come back to you on that.
Okay, thank you. So if you'd take that on notice, the number of releases or the 20 across the 21 areas.
I just just note that you've asked about the continuum over years, which is really important given the length of time it takes from the acreage through to approvals, through to companies organising their finance to supply. And so clearly acreage releases going back in time would also be important because they nest with each other through time.
Yes.
So there would have been acreage releases back earlier than 2022 that would then have subsequent ability to feed into the East Coast, and so that's just a perspective. It's not 1 year that matters; it's the consequent sequence over time, building up the stock of available area for companies to then make their commercial decisions on.
Yes, thank you.
Senator, could we beg your indulgence just on the question you asked us to take on notice? We'd like a bit more clarification of what you'd like to know.
Which question?
So in relation to where I answered about bids, you'd asked a question about, and I just wanted to catch your terminology again and just, the relevant general managers with us and is just asking for clarity on that.
So I was interested in the annual acreage releases, and to Ms Quinn's point, I think we were starting at 2022, perhaps if we start at 2021.
Or even 2020, to be honest, because 42 areas were released in 2020, and so that's building up a stock. So, I mean, we can go back to 2020 and provide the sweep of acreage releases where they were, the number of bids. We could provide that take it on notice.
And the areas.
Yeah.
And then I'd like to know if any bids were withdrawn or not, any acreage was not continued with post-offer.
So sorry, Catherine Kesterman, Acting General Manager, Offshore Resources Branch. So just to clarify, bids for the acreage or bids once it had been, so nominations of acreage areas or bids for acreage once it had been released. I think that's where there are different numbers for those.
Right, so perhaps you could explain to me then the difference between nomination areas and bids for acreage.
Sure. So at the very beginning of the process, we invite industry to nominate areas to be considered for release. The government does a comprehensive internal consultation process to sort of eliminate areas where there are conflicts with other activities or particularly sensitive environmental areas. Then it goes to public consultation, and so we take all public comments into consideration then. Then the Minister will make a decision on the final acreage areas that are put out for release. So that's the launch of the acreage release itself for that particular year. Yep. And bidding opens. It's then open for a number of months. And that's the one that Ms Urquhart referred to for the 2022 round. And so then the bids would be put in for the acreage and then awards will be offered and granted.
Thank you for clarifying that. So I'm interested in the acreage bids, not the nominations.
Yes. Okay.
That's interesting, and I'm happy to get information on that. But it was really the bids on acreage.
So
one last question on this, yes,
and then I'll go to Senator Pocock.
Terrific, thank you. Secretary, I just want to understand that the stalling and uncertainty surrounding the 2 East Coast LNG terminals, is that a potential risk to LNG being imported into the East Coast market from these other acreages?
There is clearly, in the near term, through the heads of agreement, enough supply on the East Coast. In terms of the commercial decisions around importation, that's always going to be a matter for industry on their business model versus the availability of supply on the East Coast. But I might just throw to my colleague to add anything.
Senator Jane Urquhart again. I stand to be corrected by my colleagues, but my understanding is that the import terminals relate to the processing of LNG for export. They don't relate to bringing gas onshore to the domestic market in Australia.
Could you explain to me then how the gas would come onshore otherwise?
So, Senator, I don't like to correct Ms Urquhart, but in this case, I will. The regasification terminals are about bringing gas onshore into those markets. Your questions around the timing of those projects, you're saying they're stalled. They're probably best directed to our colleagues at the Department of Climate Change, Energy Environment and Water, because they look after gas infrastructure and they also look after the approvals of those projects. But my understanding is that the Viva Energy project in Corio in Victoria is not expected to be operational until 2024. The Port Kembla import energy terminal, I think it's referred to as. My understanding is that construction is not due for completion until the end of 2023. And I think when the price caps were introduced, that there were positive statements made by Squadron Energy that the terminal would still be feasible. And my understanding is that the proposed import terminal in South Australia, proposed by Venice Energy, is not targeting commissioning until the first half of 2024.
So I'm going to insist on sharing the call, and we've got more time with you and with this program, so I'm going to go to Senator Pocock.
Thank you, Chair, and thank you, officers, for being here. My questions relate to the nuclear waste dump at Kimba. Minister, on the 13th of January this year, the Minister for Resources, Madeleine King, visited Kimba to meet with local community members and view the planned site for the National Radioactive Waste Management Facility. I understand, in fact I know because I've talked with the farmers since, that she met with local farmers at length and the traditional owners, the Bangla people. Last night my office was part of an online meeting with the Bangla people where one of the traditional owners, Elder Dawn Taylor, who was born in Kimba, very near the proposed site, said in response to talk of millions of dollars that Minister King has offered to the Kimba community, and I quote, "It's not about the money for us. Madeleine King doesn't care about our country, even though it's part of the Seven Sisters dreaming." What is Minister King's understanding of the Bangla sentiment towards the facility?
Well, as you would know, the backdrop to this is that the previous government introduced a bill to legislate the facility, and the bill would have stripped traditional owners of their right to appeal the decision via judicial review because of Labor, the approach that the Labor Party took to that legislation. We're able to negotiate a positive outcome for traditional owners that has secured their rights to judicial review. There is so that's important backdrop, which gives an indication of the minister, but also the government's view about the rights of traditional owners in this context. Minister King has visited. It's our approach not just to meet with people who agree with us, but people who disagree with these projects. And I think she would have listened carefully to the views that were expressed to her at the time.
And Minister, how do you reconcile the unanimous opposition, the persistent opposition, and certainly the expenditure, which I'll get to, of an enormous amount of resources from the community to protest and defend their country? How do you reconcile that with the voice, with a voice for local people, for people who this has long been their country? They are the custodians for the country, and they are speaking with a single voice, asking for this not to occur on their country. And this is a very, very special issue in South Australia with its long history of nuclear weapons testing, and the damage and long intergenerational ramifications from that history. So important. How do you reconcile this going against the voice of Bangla people, so clearly expressed, and your support for a voice?
Well, as you know, the government, in an uncomplicated and straightforward way, without any contradiction, within our own caucus, supports the voice to Parliament. And while it's not the business of this committee, we will bring forward legislation, and there will be a referendum later this year, which will give Australians the opportunity to have their say over that important piece of constitutional reform that I think we agree is more than necessary. Now, of course, the the project that is proposed here, there is a proper legal framework that surrounds the establishment of these kinds of projects. And I understand, of course, I mean, one of the reasons that there has been a sort of failure to land over many decades, the final location and the development of a site to safely store radioactive waste, is that these are controversial issues in communities. Understand that, and I understand the argument that you're making about the backdrop to these issues, in particular in South Australia, but in other parts of the country too, where these issues are strongly felt by communities. But South Australians use X-rays. They use nuclear medicine. They use it for cancer treatments. They use it for all sorts of medical purposes. And we have a responsibility as a government to deal safely with the issue of the safe storage of nuclear waste that is largely produced from the nuclear medicine sector. Now, there's some low-level and intermediate level radioactive waste. It's safely managed at the moment in temporary storage facilities. This is a 40-year problem, though, that cannot be resolved with the ongoing usage of temporary storage facilities. As a government, we believe that we've got the balance right here.
Well, your language of proper legal framework will be of no comfort to Elder Dawn Taylor and her community, who are unsatisfied, disturbed. Indeed, it's a really significant challenge to them as a community, and they've stood so strong. So disappointing answers and a real contradiction between support for the voice, which I share, and for treaty and for truth-telling. We tell the truth about nuclear waste in South Australia, and we ask for no further harm. That's what Dawn Taylor and her community are asking for. But I want to move on. We've just had a third of the nation on high alert over a caesium radiation source, despite being managed and subject to regulations, that has still literally fallen off the back of a truck in Western Australia. Fortunately, subsequently found. Can you see how community concerns about the transport of ANSTO's nuclear waste from Western Sydney through South Australia are both elevated at present and legitimate? It's unclear how that transport's going to unfold. There's been no consultation with South Australians about it by land or by sea. What's your response to that very high level of concern about transport of this waste?
Well, I might see if there's any officials from the department who are able to answer questions about what arrangements have been made at this very early stage in terms of transport of waste. Of course, the is it cesium, not caesium? Is that right?
Sorry, I said it wrongly.
Yeah, no. Look, I didn't want to correct you because I wasn't confident. I wasn't confident myself, but my sort of high school chemistry, I think, it's cesium.
Thank you.
The responsibility for the transport of this cesium, of course, was this was not the responsibility of the Commonwealth Government, but of course it was action led by the Commonwealth Government and the Government of Western Australia that resolved this issue far more quickly than people might have apprehended it could be resolved. But we are talking about quite different operations here. This is the safe transport and safe storage, which there is a very strong governance regime that I'm very happy for the department to go through in some detail. And of course, there will be many, many more opportunities for consultation and discussion and explanation of the framework and of the practical how is waste that's currently stored in drums in a storage facility going to be transported safely to a secure storage facility? So I'm happy for questions. Do I know the answers to questions of detail? Of course not, but there will be officials here who may be in a position to do that. And if not, very happy to do that on notice. And I just point out that there are going to be many, many more opportunities. I mean, Australia has safely transported waste of this kind for 60 years.
Minister, I've sat here and been in many meetings where I've been reassured over and over about the fact there's never an accident on this, that it's completely safe. And yet we have had this experience so recently with a $1,000 fine for the transgression. Clearly a completely inadequate response to such a serious thing, and not the only of a kind a transport issue in recent memory. These accidents do happen, and South Australians are very concerned. We've got site works underway without any plan, no discussion in South Australia, no transport risk assessment, no transport route determined, no reassurance. When can South Australians and others on possible transport routes, and especially First Nations people who are going to be living very close to where this transport occurs, expect to see real detail and reassurance? And I find it very hard to think that you can give us reassurance in view of the recent accident.
Well,
Minister,
there are more than...
Minister, just before you answer that, just a bit of housekeeping, timekeeping. That'll just need to be your last question before the lunch break. Sure. We're about to break for lunch. Minister.
There is a proper framework for managing this kind of transport and this kind of storage. There are more than 1,000 movements every month of nuclear medicine-related radioactive waste. We have 60 years history as a country of managing this kind of waste. The kind of issues that you're referring to that go to this cesium capsule, I don't know whether capsule is the right terminology, and the fines regime, I don't think are a matter at this stage for the Commonwealth Government, but I share your concern about the consequences for that mismanagement. But I'm, of course, like every Australian and every Western Australian, delighted that that issue was resolved so quickly.
Thank you, Minister. Thank you, Senator Pocock. The committee will now break for lunch and resume at 2 p.m, continuing with program 1.3. Ready to go? Senator McDonald's ready to go. Minister's ready to go. Everyone's ready to go. Welcome back, everyone. The committee now resumes with the Department of Industry, Science and Resources Outcome 1, Program 1.3. And I'll proceed in 10-minute blocks because I understand a number of senators have questions. Senator McDonald, you have the call.
Thank you very much, Chair. I'm sorry, I don't recall whether it was Ms Urquhart or Ms Quinn who identified the import terminals that we were talking about before.
Misidentified the import terminals.
Excellent. Would you be able to list those for me? And happy to take that on notice if you would like. The name of the terminal, the location, the proponent, and if you know, I appreciate that this may be a Department of Climate Change question, if you know if approvals have been granted and work has commenced.
Status generally. Exactly. What do we know?
So Senator David Lawrence, Acting Head of Division, Oil and Gas. As I mentioned earlier, there's the Viva Energy project, or the import terminal in Corio, Victoria. Corio, Victoria, down near Geelong. My understanding is it is planned to be operational by 2024, but issues relating to project approvals you should discuss with the Department of Climate Change, Energy the Environment and Water.
And proponent, please.
The proponent is Viva Energy. And there's one at Port Kembla. I think it's the Port Kembla Energy Terminal. The proponent is AIE, which includes Squadron Energy. My understanding is that construction is due for completion at the end of 2023. Again, any matters relating to approvals should be referred to the Department of Climate Change, Energy, the Environment and Water. And then there's one terminal proposed in South Australia by Venice Energy. Don't recall the exact location of that terminal. And my understanding is that project is targeting commissioning by the first half of 2024.
Did you say Dennis Energy? I'm sorry?
Venice.
Venice, sorry. EPIC was not, EPIK is not on your list? Newcastle.
Newcastle. Well, I'm aware of the project at Newcastle, but I don't have any details with me. So I'd have to take anything on that on notice.
Okay. Thank you very much. On the 17th of August 2020, Premier McGowan released a media statement claiming that state government will not agree to exports of local gas to the eastern states or overseas. Is it your understanding that Western Australia can prevent the trade of gas from Western Australia to the East Coast, Secretary?
I mean, they have a lot of control over the licensing arrangements for their onshore facilities. And so I'm not entirely sure how far that extends in terms of their licensing conditions and things like that, in terms of kind of onshore. But I'll pass to colleagues who might have more familiarity from that time, because it was a few years ago now.
So, Senator, my understanding is that Western Australia has a policy that says onshore gas developed in Western Australia has to be used within Western Australia, and it cannot be exported to the East Coast or exported at all.
And that's a policy as opposed to a legislative instrument, I understand?
I'd have to take that on, the specifics on notice.
I'm only interested insofar as how it will affect the domestic supply on the East Coast, as if those projects are
So, Senator,
coming to
my
market.
understanding is that LNG exporters such as Woodside that are looking to partner with the likes of Viva have indicated that would be, spot LNG cargoes that would be exported or brought to the East Coast.
Right. So, yes, I have some questions about Section 92 of the Constitution, but I think we may, unless you have a legal resources legal expert here, we might have to leave that for. Do you have a legal expert for resources here?
Matters around constitutional law is tied work with the government solicitor, so we rely on the Office of, there's got a technical term, constitutional something or other, that they provide us. We would refer our legal questions to them.
All right, so we'll park that matter of Western Australia's policy around restriction of gas to the East Coast for domestic supply. Does that mean, Minister, that government supports other large producing states like Queensland implementing their own export ban for New South Wales and Victoria to provide supply?
Sorry?
So if we're trying to address the domestic supply on the East Coast, we've just had a brief discussion about Western Australia's policy not to allow onshore gas to be supplied to the East Coast. So does that mean that we're going to have to look at states like Queensland implementing their own, securing more gas for New South Wales and Victoria and exporting less of it, given that we know that Victoria doesn't have, while they're changing their regulatory environment, that they have not been producing CSG or fracked gas, unconventional gas?
Well, I'd just add to what the Secretary says. If you want a discussion about the sort of constitutional arrangements, I'm not even a bush lawyer, let alone a real one. So perhaps that's better directed somewhere else. It is the case that a significant amount of investment has occurred in gas production in Queensland, but the arrangements that the states make are a matter for them.
I understand, Minister, that Minister Scott Stewart from Queensland is here in the building at the moment seeking to meet with Labor government ministers to express his concern about the gas mechanisms, intervention into the market and gas supply. Are you aware of that?
Nope.
Are you aware of that, Secretary, that Minister Stewart is here?
The department is, yes.
Yes. Thank you. In October, Senator Birmingham asked Prime Minister and Cabinet, is it the government's position that it wishes to see an increase in supply of gas production both onshore and offshore? And in response, Mr Chisholm from PM&C replied the answer is yes. Is that the position of the Department, Secretary?
This is a government position, which is that if gas projects meet all the required environmental and government approvals, then the government welcomes investment in gas production. So that's the government's position, and we support the implementation of government policy.
Great. Minister, would you confirm that that is the position of the government still?
Yes.
Thank you. What measures are the government taking to develop increased gas production and supply, both onshore and offshore? Perhaps you would take that, Secretary.
Sure. We did run through these earlier. So starting at the very high level, or the very first step, which is about exploration information and providing facts on the geological makeup of Australia. So the government supports that through Geoscience Australia and other scientific endeavours. Then you go through the acreage releases, which we touched on, and then of course there's the environmental approval processes, which is administered by another department and minister. And then of course overall there's been clarity around the regulatory framework so that investment decisions can be taken, and writ large there's just monitoring the situation in terms of overall demand and supply. I note that there's a lot of regulations that impact on gas production, and the government's commitment to net zero and the regulation around the energy sector and the transition that it needs to go through also provides clarity for those that want to invest in the industry. So there's been quite a lot of change as a result of the change of government and government policies, but those regulatory regimes are becoming clearer, and industry will respond.
So the department is involved with the consultation on the mandatory code of conduct, is that correct?
We have been involved. It's being led by the Department of, I always get their order wrong, but DQ, the Climate Change, Environment, Water and Energy, and they have the lead policy response process because the Minister Bowen is the Minister responsible for energy. Yes. So he has responsibility, but ACCC is obviously providing quite a lot of support, as are we and others across government.
We had some discussion with the ACCC about the updates that they were providing to industry, interim guidelines and then further updates. Is your feedback from industry that they are now satisfied, they understand the working of the price intervention, or do you expect that there will be further updates coming from the ACCC on how that works?
We've certainly been part of the discussions about clarifying things, because as you know, there was guidelines issued in January, I believe, December, government policy and then discussions. And we've been joining up industry and clarifying things ourselves. In terms of whether there are specific issues to be resolved, I'm not aware of any at this stage. I mean, people might not like the guidance or the clarification they get. But there's been a fairly comprehensive discussion, but I'll just pass to my colleagues in case they're aware of more details.
And Senator, I think the discussion with industry is continuing. I spoke to Simon Duggan earlier in the week, and he indicated to me that, reminded me that the consultations were continuing and into early March. And so, there's some way to go yet before finalising the mandatory code of conduct arrangements. And, they're looking at, opportunity for implementation after April.
I think most of that, there's just two bits because there's the mandatory code of conduct consultation, and then there's the discussion around how the temporary price mechanism is working. Quite a lot of that's been worked through as people have started very much road testing what it means for contracts and discussions. So on both sides there's been a need for clarity, both on the industrial and retail users side and on the producers side.
At the same time as that you're consulting on the mandatory code of conduct, are you consulting on the ADGSM changes?
Yes. So the guidelines for that regulatory change are out for consultation at the moment, and we're receiving submissions, and so that process is on foot as well.
How will the mandatory code of conduct interact with the heads of agreement?
So the heads of agreement is around getting certainty about the supply of gas from the exporters into the Australian market in the near term. The Minister is engaging with the parties to that agreement to resolve any questions around the regulatory changes at the end of last year. So that stands alone. In terms of the mandatory code of conduct, it goes through a set of working through a set of possible obligations on both parties to a negotiation, and some of that information sort of is drawing on the discussions around the heads of agreement in terms of transparency of information, how information is provided, and the requirements to engage in good faith and those sorts of things. So there will need to be a discussion about the heads of agreement subsequent to the code to make sure things are kind of lined up. But the sequence would be heads of agreement is in play now. It is something that is negotiated over time, has a time limit. The mandatory code of conduct would come in, and then you'd look at the needs and the operation of the heads of agreement post the code coming into play. But I'll just check that I've got all that sequence correct from my colleagues. We'll be happy to correct me, I'm sure.
Just while you're doing that, Secretary, and preparing to answer that, we have gone a fair bit beyond 10 minutes, but I understand that you're sort of on a tranche of questions, so would you like to finish that?
One more
Sure.
and then, thank you.
So Senator, as the Secretary said, there is a process, and we've been working very closely with our colleagues at the Department of Climate Change, Energy, the Environment and Water to make sure that everything is sequenced. So the Code of Conduct first sort of consultation closed on the 7th of February. We've made sure that the consultation on the ADGSM guidelines was started after that. It closes next week, and our understanding is that our colleagues at DQ will be consulting on the mandatory code at the end of the month or early into the next. So we've been sequencing things along the way, and that's not just and we haven't just been consulting through the formal processes. So Minister King on the ADGSM wrote to LNG producers, putting a proposal to them at the end of December. We took comments back on that throughout January that informed the guidelines. And that wasn't just sent to LNG producers, also sent to international trading partners. So we've been engaging with everybody every step of the way.
Thank you. The heads of agreement that initially brought 157 petajoules to market, and I think that was subsequently changed to 146 petajoules to market, but certainly met the ACCC's shortfall requirements. Have any of the parties to the heads of agreement subsequently indicated that they can't agree to it anymore following the intervention late last year? It was a voluntary heads of agreement. Is there a new draft being prepared?
So, Senator, the final clause of the heads of agreement says that if there is a material change in the market, such as the price cap or the mandatory code, that the parties will reconvene. We are in that process of reconvening with the parties. None of them have walked away at this stage.
and that you would see that process not commencing again until after you've done mandatory code of conduct and then ADGSM, because otherwise it would be, it could be null and void again for a significant change in the market. Would that be the sequence?
We are currently working with the Minister's Office on an updated draft heads of agreement to send out to the companies. As with any negotiation, people will have their positions and how they would like to proceed, and one of those options is that they will wait until the mandatory code is in place. Obviously, on the pricing mechanisms within the heads of agreement at the moment, they are sort of overtaken, if you want, by the price cap mechanism.
Thanks, Chair.
Thank you. I'm looking over. Senator Pocock.
I'll continue with a couple of questions on the Kimber facility, if that's okay. Thank you, Chair. This is for the Minister in relation to correspondence that Madeleine King when she responded on the 9th of January to correspondence from the Australian Conservation Foundation concerned about the planned facility at Kimber. That correspondence, in reply, the Minister stated, quote, "The long-term management of Australia's intermediate level waste at ANSTO is not sustainable." Yet at the previous estimates, and again in response to my latest question on notice, ANSTO have explicitly stated there are, quote, "no regulatory or legal constraints to continuing interim storage of intermediate level waste at the Lucas Heights facility, and that ANSTO could apply for new or expanded storage facilities subject to regulatory processes." Previously, the CEO of APANSA stated that intermediate level storage at ANSTO is both consistent with international best practice and could safely be stored, quote, "for decades to come." Minister, do you accept ANSTO's position that there are no regulatory or legal constraints to continuing interim storage of intermediate level waste at the Lucas Heights facility?
I should start by indicating that I just want to make sure that what I said to you prior to the lunch break was correct, and that is that the regulatory framework that has been, it's just in relation to the Western Australian matter, the regulatory framework that has caused the $1,000 fine to be issued is, as I said, a Western Australian. There is also ARPANSA's framework, and as I understand it, ARPANSA are examining the circumstances that happened in Western Australia. So I didn't want to leave you just to, from what I said, to take it that there was only the state's regulation there. That there are other matters that ARPANSA will have to attend to there. If I can come back to your question, I'd prefer to answer it unless Mr Usher's in a position to take you through those issues now. I think we have ANSTO this evening where we can take you to their position. But as a sort of headline proposition, this has gone on for 4 decades. This issue can't continue forever. But I might invite Mr Usher or Ms Urquhart to supplement.
Thank you, Minister. Senator, thank you for your question. I mean, I think I've also seen the question on notice response to you. And indeed, ANSTO did state that about there being no barriers to the storage of waste, illegal and the other angle that you mentioned. But what they were clear on was that they have based, or that they answered in their question about operating limits defined in safety analysis reports, and they also pointed out that their capacity is finite. So their answer really did give a sense that there would be a need, inevitably, for other viable solutions to store waste. So I would suggest that, when ANSTO attend later, this would be something to explore further with them, just to understand precisely the capacity limits of Lucas Heights.
There's a big difference from, most things are finite. As I remember, there was a suggestion of decades ahead, storage capacity for decades ahead. That is plenty of time to find a solution which doesn't trample on First Nations rights and attends to the wishes and views of South Australians, which have not yet been canvassed. Isn't that the case?
So Senator Anstow certainly made clear that they have done work around the types of waste streams that would need additional storage capacity and when that would be needed, subject to the facility coming online at a particular point in time. So again, I think that, you know, if you're looking for clarity about that capacity and storage need, ANSTO should be able to provide that.
I'm happy to go there and ask that, but do you accept ANSTO's position that there's no regulatory or legal constraint to continuing interim storage at Lucas Heights?
So my assessment of their answer is that they were referring to their current storage, and that continuing to have the waste that they currently store at ANSTO under those criteria, you know, in that regard, face no barrier like described.
If I can move to, thank you for that, can I move to legal costs? In my most recent response to a question I noticed in regard to legal costs, the government has indicated it spent more than $1.6 million on external lawyers. That's in addition to internal legal costs, I assume, with further, yes, spend on internals. Again, and that's a cost against the Bangala people on the Judicial Review court case. Most of this spend, more than $1.5 million, has been under your Labor government. In contrast, the Bangala people have spent around $500,000, still a great deal for a small community. So I ask whether you think this is an appropriate use of taxpayers' money for a Labor government to outspend the traditional owners by at least 3 to 1 to fight them in court for a project that does not have the support of the community, doesn't have the support of local farmers, has never been tested across our state beyond a small local government area, and does not even provide a permanent solution for intermediate level nuclear waste.
Well, if there's anybody in the department who can indicate whether there's any variance to the costs, put that issue aside for the moment. I'm happy for people to supplement. But the Commonwealth, the short answer is yes. The Commonwealth has a responsibility. I think the phrase, again, I'm dangerously out of my depth here in terms of my a bush lawyer, not a real lawyer, but as a model litigant, the Commonwealth has a responsibility to discharge its obligations fully, and that means getting advice and seeking representation that goes to all of the Commonwealth's obligations, and that means that that significant amounts get expended on matters like this. That is the nature of these kinds of legal matters, and there may be somebody in the department who can add more in terms of the specifics, but as a matter of principle, the short answer is yes.
I must say I think many South Australians would be horrified at this level of expenditure for a project which has not yet achieved a success through the courts, is opposed by local First Nations people, has no plan for the transport of nuclear waste, and nothing's been signed off in terms of detail by local South Australians. So big expense for something which may come to absolutely nothing. But let me move on. Can you tell me what the status is of the Australian Radioactive Waste Agency enabling legislation and when this is expected to be introduced to Parliament?
I can't tell you anything about that today, but on notice I can provide you with whatever information we have, and very happy for anybody in the department to supplement.
Thank you, Senator. Sam Usher, I'm the CEO of the Australian Radioactive Waste Agency. The previous government tabled the Australian Radioactive Waste Agency Establishment Bill in February of 2022. It was tabled but not debated, and the process lapsed with the caretaker and the federal election. And the progressing of that bill is now a matter for government.
And is there a timeline then for ARWA to become a non-corporate Commonwealth entity?
As I said, it's a matter for government.
It's embedded in that legislation. Right. Just a final question. You mentioned, Minister, that there may be a Panzer action in relation to the missing capsule now found. Would you be able to cast any light on what that action is likely to be?
Not any more than I just indicated. I understand that they are considering the
Thank you, Chair.
matter.
O'Neill.
Thank you very much, and nice to be able to ask you some questions about something that matters so much to Australian businesses and the international economy and climate change and for Australian jobs as well. So I'm referring to the matter of gas that I know that Senator McDonald has been prosecuting. There may be a little bit of overlap between some of the questions that I'm about to embark on, as I was unable to be here for the whole of her questioning. But I am keen to get on the record in a very clear way exactly what the situation is that the government found on arrival and what is practically being undertaken to address the very significant challenges that met us on our arrival here. So my first question is, what are the main reforms that are being planned for the Australian Domestic Gas Security Mechanism?
So I'm happy to pass that to my colleagues. It is the case that the government reviewed the arrangements for the Australian Domestic Gas Security Mechanism in response to the energy situation in the east coast of Australia, and then also in light of subsequent actions resulting from the Ukraine's invasion, Russia's invasion of Ukraine. And there was a review and looking at the mechanism. At a high level, the reforms are aimed at making it operationally more effective, a quicker response to the circumstances, and also making sure that it was enforceable and would deliver gas if it needed to be called on. In terms of the sort of subsequent technical detail, I'll pass to my colleague.
Thank you, Secretary, and thank you for the question, Senator. The reforms being implemented to the ADGSM as announced by the government were changes to the activation process, with activation to be considered quarterly, and that's really to bring the mechanism into more frequent consideration. Protection for long-term foundation contracts, obviously with an eye to our relationships with important trading partners and their reliance on us. LNG exporters in a shortfall market being given responsibility for supplying additional gas to the domestic market, and exporters being able to trade their export permits.
So it's multi-pronged.
It is.
So I'm sure that it's a reasonably complex piece of work to undertake and critical to the economy and to the nation. Can I assume that there was a fair degree of careful analysis before the department embarked on the strategy that now is underway? So could you give me a sense of what analysis the department did to inform the areas of reform and the action of reform in each of those four categories you've just outlined?
Yeah, the analysis has been going on for some time. In the sort of second half of the year, last year, as the Secretary mentioned earlier, we undertook a review of the mechanism, but I might hand to my colleague for a bit more of the flavour of the work involved in that review.
Thank you. So back on the 5th of July, the department or the government announced a review of the ADGSM. Between the 5th of July and the 19th of July, there was a submission period to look at the ADGSM extension. That was the result of that was announced on the 19th of August, with the ADGSM being extended to the 1st of January 2030. Between the 1st of August and the 22nd of August, we undertook a submission process for the ADGSM review. That fed into a whole of government process, a cabinet process, with the reforms being announced on the 25th of October.
It might be helpful just to outline the 7 principles that guided the review. One was to ensure sufficient supply of gas to the domestic market to support manufacturing and energy security. Another, to put downward pressure on domestic...
Just before you reel them all off, I mean, 7 principles is a very significant set. We just heard from Mr Lawrence about the complex interaction of a range of ministers and cabinet processes applied. Clearly principles are important in driving this. So could you just restate that first one, because it seems critical to me, and I'm pleased to hear it, but I want to understand a little more.
It was to ensure sufficient supply of gas to the domestic market to support manufacturing and energy security.
Pretty important principle to be driving, and that remains the first principle in your ongoing work. Is that correct?
Certainly, those were the principles that underpin the review, and that review has segued obviously into the work that we've done around the reforms.
The principles haven't changed, though, that continue to inform your work, have they?
Indeed.
Right. So what's the second one?
Put downward pressure on domestic gas prices.
Okay. Can I just ask the obvious question, why is that so important?
So, Senator, I'm not an economist. I know the Secretary will shudder when I say this, but I think that, obviously preserving supply for the domestic market is considered to put downward pressure on prices.
And the third principle?
Maintain Australia's position as a leading contributor to global energy security.
So, good international citizen, number 4.
Yeah, and actually more pointy than that. So there are key partners like Japan and Korea who are reliant on Australian LNG and who regard us as a trusted supplier. And so it's very important for us to have an eye to their needs, as well as the trajectories they're on, as it's a global endeavour, obviously, to move towards net zero.
Of course, it's important that we continue to engage where we've committed previously, and sometimes I feel that there's a little doubt put on the emphasis of that. But that's only point 3. We've got more to go. Point 4.
We do indeed. Point 4 was respect the trust trading partners and international investors have shown in Australia's resources and energy sectors.
Mm-hmm.
So international partners have invested in the resources and energy sector and in the exploitation of those resources, and obviously expect a yield from those investments.
And that continues to be part of your focus as you continue your work.
Yes.
Thank you. What's the 5th one?
Support the energy transition in line with Australia's emissions reduction targets.
The complexity of the task is just becoming more and more apparent to me as you get down the list, because there are many competing needs there. So it is a complex task underway, transition. The 6th point?
Enhance transparency and processes that support competitive pricing outcomes for gas consumers.
Why is that so important?
Well, it's about fairness of the system.
Of course, matters to you and matters to me. We want to make sure that maintains the integrity of the AGGSM. What about the 7th principle?
Minimise implementation cost and complexity for government and industry.
Okay, so I think we're pretty clear that there is a set of principles driving the action to make sure that it progresses in a coherent, ethical and sustained way. Is that a fair summary?
Absolutely.
Okay. Now, you mentioned earlier that there was a shift to quarterly considerations. What drove that decision and what is the rationale for it, and how is that operating?
Senator, previously under the AGGSM decision to declare a shortfall year was annually, and that was based on information provided by AEMO in March, and so the Australian Energy Market Operator in March of any given year, and the ACCC's gas inquiry report generally released one released in January and one released in July. Under the AGGSM process, the Minister determining if he or she would declare a shortfall would have a period between July and October to do that. So you're relying on some fairly, I don't want to say dated, but it's not in real-time data, I suppose, for a minister to make those decisions. Under the new system with AEMO now doing a summer preparedness plan, a winter preparedness plan, and its gas statement of opportunities, there's more real-time data. The ACCC is also gathering data on a quarterly basis, and Minister King, under the heads of agreement, meets with the 3 LNG East Coast gas producers on a quarterly basis as well. So we've got more real-time information coming in on the forecast information that the energy market bodies rely on.
So this is about data-driven policy making and adjustments in the national interest occurring in a timely way in line with what I think would already be community expectations. I think people would have been shocked to find out that every year we'll get some numbers and then we'll have to make a decision in a very short period of time. It's especially given, people's interactions with gas is, you use it more in the winter than you... So it's clearly there's a shift in the market over the seasonal, just household use, let alone the use by manufacturing industries. So how is this changing the practice and changing the nature of, I guess, the quality of interaction between the government on behalf of the Australian people and the sector?
So, Senator, it's probably important to note that that quarterly process is in play now. It's not waiting on the reforms coming into being on 1 April. Through the Heads of Agreement, LNG exporters committed to reporting on how they've met their commitments to the market and meet with the Minister to discuss where they were at. They also committed to publishing information about their engagement with the market on their websites and to supply information to the ACCC to demonstrate that they were in compliance with the agreement that they created together with us. So I think it's fair to say that, as Mr Lawrence said, this responds to a real-world situation where changes can occur more frequently. It enables the government and industry to respond or to consider response more often, 4 times a year in fact, and that way you're dealing or engaging with industry on domestic energy security on what you might call a meaningful time horizon.
Prior to this quarterly engagement,
was an annual process.
What manifests as the problem of that established process, which I'm assuming was the practice of the previous government?
Mr Lawrence has been around longer than me.
I think, Senator, it just meant the government wasn't able to respond to real-world threats to domestic energy security in a timely manner.
Given the principles that underpin what it is that you're doing, that you articulated so clearly, I'm surprised that it wasn't operating in such a, as you said, described a real-world way, because of the practical implications of failing to do so is actually against the national interest and also puts at risk our international reputation. So I think I'm going to get the wind up here for any moment. So critically, Australians will want to know about their own supply. I mean, our reputation internationally matters to us, but clearly our fellow citizens expect their government to be making sure that the attention is paid to the needs here domestically. So how does the new ADGSM ensure that the domestic market is well supplied, not just for households, but critically for industry and particularly manufacturing?
Senator, I think it's fair to say that the Heads of Agreement and the ADGSM work together. The ADGSM is always a measure of last resort. So the Heads of Agreement is an agreement Minister King made with the 3 East Coast LNG exporters to ensure that their uncontracted gas is offered to the domestic market before it is offered internationally, and is also offered at competitive prices as well. And this year would be offered under the price cap mechanism. The ADGSM works that if there is a forecast shortfall, it looks forward to ensure that that shortfall doesn't occur, and as I said, is a measure of last resort. So part of the process that the Minister would go through before activating or triggering, as others like to use, is that she would sit down with the market bodies, so ACCC and AEMO, to understand the information they have about the market. She would also sit down with the producers and to see if the shortfall could be, if there is a forecast shortfall, that it could be addressed without having to, limit exports.
With indulgence, Chair, there was one statement there putting the ADGSM and the Heads of Agreement in context in relation to one another. If you could just clarify for me, when did the Heads of Agreement expire?
So let me check, Senator, because there's been a number over the time. The first Heads of Agreement was originally signed back in October 2017. There was a subsequent agreement signed in September 2018. The third agreement was signed on the 5th of January 2021, and it was due to expire on the 1st of January this year, but the Minister finalised the current agreement on the 29th of September last year.
And it will expire on 1 January 2026, but of course that doesn't preclude opportunity to change it again should there be a need, and there are discussions underway to take account of the government's energy price package and the different elements and how they might interact with the heads of agreement.
And so those negotiations are critical. It's unfortunate that the previous government didn't start negotiations on that heads of agreement before it expired in 2022. Considering how much hot air we hear about how good they are with the gas sector, that's a pretty significant failure. If they were doing it quarterly, maybe they wouldn't have missed the date. Thank you.
Thank you, Senator O'Neill. And I'll go now to Senator McDonald.
Thank you very much, Chair. So is it not the case that the heads of agreement, as it currently stands, the final clause you pointed to before said that if there was a significant market intervention, that the parties would not be bound by it?
No,
Isn't that
Senator,
what we had a discussion just a few minutes ago about?
Senator, I didn't say that they would not be bound by it. I said that there is an opportunity for the parties to reconvene and to determine if any changes are needed.
It's my understanding that the parties are waiting for that to be reconvened, and I think it would be bold to say that the parties feel that the heads of agreement, as it stands currently, was negotiating in good faith, given that the significant market intervention post their signature.
Senator, Minister King met with the 3 LNG producers from memory on the 15th of December last year, and at that meeting there was a discussion on revisiting the heads of agreement, and it was agreed that that would commence in the new year once the parties had a chance to consider the effects of the price cap and also the mandatory code.
Do you think the implication of that is that the parties didn't believe that the heads of agreement stood following the intervention in December?
Somebody's perspective of what's going on in somebody's head, Senator McDonald.
I think, is that a point of order, Senator O'Neill?
I'm happy for the...
Yes, I guess it is.
I'm happy for the department official to answer the question as best as they can.
Senator, I think that the parties to the agreement all agreed that the interventions were significant, and it was important to allow some time to understand those interventions and to come back to determine if the agreement needed changing.
Ms Urquhart, you outlined 7 principles, including the importance of respecting the trust of trading partners and international investors. Given that our trading partners and international investors have publicly expressed concern on elements of the draft ADGSM guidelines since they were released last week, and I quote Mitsui & Co.'s reported comments in the Australian Financial Review on the 13th of February, how do you see that those principles, very, very aspirational, worthy, I got very warm hearing them, but how are they actually working in reality if our investors and trading partners are saying things, as they did in the AFR just this week?
The extensive consultation we've been undertaking, making both review considerations and now reforms, guidelines and, associated regulations in a process, and that communication, which has been constant since at least July last year, seems to me to be all about respecting the trust of important trading partners.
I attended the Japanese Embassy's event this week, and I can tell you that there were a large number of those investors, and not just in gas and resources, but in agriculture and other sectors, who believe that the relationship with Australia, they were shocked, they were hurt, They were puzzled, they didn't understand what they'd done. For us to treat them in this way, the speed of the change. So I appreciate that you believe that you're informing and consulting, but my direct feedback from trade partners is that's not what they believe.
Well, we'll certainly continue our consultation, Senator, because you really underline the importance of that engagement. I think it is important that they understand how built into the process is protection for long-standing contracts and those sorts of considerations. So, we will certainly intensify our efforts.
Yeah. Do you believe that the ADGSM, and it's quite frequent, 4 times a year, review of gas supply in Australia and the requirement that LNG exports take gas from overseas contracts would support that idea of the importance of overseas contracts?
So, Senator, there would only be a requirement to take from overseas contracts. Well, there is no requirement actually to take from long-standing overseas contracts of the type that we're discussing. The process played out very well last year in the way that Minister King engaged with the East Coast gas producers, working together with the producers, with the shortfall identified. Gas was identified to address that. So I'm not sure that I accept that this would necessarily mean any kind of compromise to those important contracts, or indeed necessarily a triggering of the ADGSM, because the process is designed to work together with industry ahead of that potential need.
So if the heads of agreement worked so well and the Minister had agreement from gas suppliers to bring additional gas to the domestic market, why did you then need to intervene first with the price intervention, but I guess more importantly now with the mandatory code and then the subsequently ADGSM changes?
So that process is, Senator, obviously all about supply, but I'll defer to the Secretary.
Yeah, I just wanted to just articulate there are a few different issues happening in the gas market, and we need to think about what policy tool is being used to address the different concerns. So the code of conduct that's being proposed, there was a voluntary code of conduct that was separate from the heads of agreement. The government's decision to move to a mandatory code of conduct addresses behaviour and competitive dynamics in the industry, similar to other codes that apply to other parts of the economy. That's a policy tool that comes under the Competition and Consumer Act to address imbalances of power and lack of transparency in negotiating dynamics. That's a very different policy issue than ensuring that there's adequate supply into the East Coast gas market. The separate issue about price in terms of the near-term concerns that the government had about the spike in prices and what a temporary high price might do to the industrial structure and households in a high inflation environment. That is a different problem again. So the government looked at, through a whole sequence of discussions across different portfolios, what were the problems in the energy system, not just gas, but also the electricity system and the supply of coal, and put together a package of different policies that address those different problems. In terms of our responsibilities, it's around the supply of gas into the market. They all work together to provide a regulatory environment that meets the government's objectives of more affordable energy, supply of gas for industrial users, maintaining export contacts and our investment environment. So we just have to be a bit careful that just because we've got one policy tool for one target, it doesn't mean that it can solve all the problems in the market.
So I just have an article that the Chair agreed that we could table and has been distributed. Crackdown puts gas on back burner. This is from yesterday's paper, the 15th of February. We have been talking about the gas supply. We've been talking about domestic supply and hopefully not having to touch long-term international contracts. That is, of course, all reliant on the investors continuing to invest and bring more gas supply to market. We've spoken about the major investments list that was published, I think the day before or the day after, but quite close to the price intervention. Subsequent to then, we have seen 12 of those gas projects listed in the Resources and Energy Major Projects Investment Pipeline are considered to be facing significant uncertainty following the intervention. We've had discussion that that list won't be updated until next December, but given, you know, the range of conversation we've had just recently and the importance of bringing additional supply to market, of securing the long-term contracts and not damaging those long-term agreements, how confident are you that the future supply pipeline is unaffected by the government's decision?
So, as I mentioned earlier, there is uncertainty at the moment because the government is working through the mandatory code of conduct and consulting and talking to people about how the reasonable price mechanism will work and how that might be applied. There is in policy processes moments where people pause and think about what they're doing. That's entirely appropriate and something that happens regularly. This is a temporary process of consultation. It's not taking a particularly long time. The government's moving very quickly. It's being run by our colleagues at DQ. They are looking to resolve that as quickly as possible.
Can I just...
and then the time will be to assess, because the key principle in the reasonable pricing mechanism that the ACCC chair talked about yesterday, as I understand, is about ensuring supply comes into the Australian market, as well as ensuring that there's a balance of bargaining power and negotiation ability in the domestic market. That those objectives, it's entirely possible for those to be encompassed within the regulatory arrangement, and that's the objective of the Code of Conduct. So we don't know exactly what that looks like now, but it won't be very long until we do.
I think we are getting some indicators very early of what it is, and I appreciate you're saying pause, but investors are saying we have other investment opportunities in the world, and despite us Australians believing that our gas is the best in the world, apparently that's not necessarily, we're not the only suppliers of gas.
Senator McDonald, that is the most self-referential set of questions that I've seen. An article in which you try and spook people with
Are you the acting chair currently?
Well, you can chair it with a series of incorrect assertions in that article, which the discussion with the officials has just demonstrated is utterly incorrect.
Let me ask some questions rather than you make a statement.
I'm entitled to answer your question.
Okay, I just made the point. I just made the point that now I'm focused on what's happening. That obviously,
yeah, I think that's really what's
obviously the way that the chair, who's temporarily out of the room, has run these hearings over the past couple of days has been on the basis that the senators ask the questions, and then obviously the officials and the ministers are able to answer the questions. But I do think that we should revert back to that sort of approach. So.
Excuse me, Acting Chair, isn't it the minister's right to respond to any questions on behalf of officials?
That's what I said.
And I'll conclude. I'll conclude answering my question.
Sorry, I was just confirming. My own lowly new senator.
What your line of questioning demonstrates is that there's a deliberate attempt to conflate the short-term and long-term challenges in terms of supply.
No deliberate conflation.
And I hope that in the discussions that you refer to, that you had with representatives of partners of Australia, that you haven't misrepresented the policy situation to them in the same way that you've done it today and in that article.
Okay.
Because that's not in the national interest. What's
Thank you again for
what's
your
required
advice,
is a level of seriousness. Is a level of seriousness about these policy issues.
Advice to me about how to do my job. It's
Let's just get
as
back to
always.
questions and answers. Yeah.
I'm with you.
I think. Well, at the moment, Senator McDonald.
I'm happy to.
Well, I'm not sure exactly what
I was
we're
given
up to.
15,
So why don't
We're in the deputy chair's hands.
Why don't we? I have to. I think it's no great secret that I wasn't probably as alert as I should have been. I think everyone knows that.
Thank you for admitting that, Senator Bray.
Well, it's always good to be.
Where is the letter?
I mean, given the issues we've had
Very
with.
reflective of you. Senator Cox has got questions.
I think.
Hello, Jess.
Look, it's gone into disarray since you've gone.
funny farm.
So needed.
It almost feels like ASIC's back here, you know, the obfuscating and like.
Chair, I think I've come to the end of my time and I'm relinquishing the call.
Wasn't that bad, was it?
I will seek to call.
The reign of terror is over.
Might be at the end of the tether as well.
Other
Yeah, I'm ready.
Senator
people
Cox.
have had their call.
Senator Cox.
Thank you. I just want to turn your attention to, I'd asked some questions on notice last year about the national strategy on critical minerals. So I just wanted to pick up some of the conversation in the response that I received, and it was that the department mentioned that this strategy will work to support clean energy technologies and will ensure that critical minerals are mined and processed in ways that make positive contributions to the lives of local communities, First Nations, Australians, and the quality of our natural environment, and that aligns with the highest ESG standards. Can the department, or the minister even, please outline for me what those positive contributions to First Nations communities are that the department will be anticipating?
So, Senator Anthea Long, Head of the Minerals and Resources Division.
Sorry, can I get you to
Apologies.
Speak up? Or...
Anthea Long, Head of Minerals and Resources Division. So, as you mentioned, the government is actively seeking to engage with First Nations peoples, communities, associations, as part of updating the new critical mineral strategy. And so we can talk a little bit about the process that we've taken to date and the different kind of organisations and engagement that we've had. But I guess I would just say at the outset, part of that engagement is about being very open and reaching out to those stakeholders to understand their perspective of the benefits and what
Sorry,
their
Ms. Long,
perspectives
can
are
I
around the
interrupt?
strategy.
I don't want to actually know about the engagement. I've spoken to Minister King particularly about the engagement with industry and not with First Nations people in community. What I'm interested in is what are the anticipated positive contributions that you speak of in relation to social licence that First Nations communities provide for mining operations of critical minerals in their communities? What are those positive contributions?
Hello, Senator Andrew Hutchinson, General Manager of the Critical Minerals Office. At this point, I think maybe the best way I can try and answer your question in a bit more detail than what we did on notice would be to talk about some of the specific conversations we're having with different mining proponents around how they're not just engaging with First Nations communities, but what does the project, should it get up, mean for those communities. I would note that it'll be a little bit generic because I don't want to reveal specific business planning aspects of particular companies, but the examples are coming, to us are very real. So social licence as a component of broader environmental, social and governance kind of credentials for these projects is very important from a mining to the mining companies from a range of perspectives. First and foremost, they need to work with those communities in order to have things go smoothly on the ground. Second, there are a range of opportunities, and I'm speaking about, I guess, from the industry perspective here, because that's a more genuine way to answer the question. There are a range of opportunities for those projects through local employment, through access to land, through having community acceptance that this kind of new generation of mines are very conscious of. And finally, if they don't have these sort of aspects tied up well for the project, they're exposed in the international market because increasingly investors want to know that there's community acceptance, community engagements and community benefits flowing from these. So some of the specific things that we talk to proponents about are, firstly, how are you communicating and engaging with the communities? what kind of financial, commercial, economic benefits might flow to those communities in terms of, are you procuring local services such as road building and construction, cartage and haulage, earthworks, that kind of thing, to the extent possible through local communities, including through First Nations? What opportunities to participate are you giving those communities? What sort of direct employment benefits do you think might flow through? And I can talk, I guess, in a second about how we do that in a structured way as opposed to just a nice chat kind of thing. What sort of skills or education or longer lasting benefits might the project be able to provide for those communities beyond just sort of temporary employment opportunities, that sort of thing? And finally, what opportunities are there for the project to work with First Nations people to ensure that they understand where there are sites of particular significance and how they'll be protected? Now, a lot of this stuff is dealt with through state level planning, but we take an active interest, particularly where government is considering being involved in the project through something like, say, a grant or a loan, or even just basic project facilitation. And so that's a very active conversation. Some companies do it better than others. Some really get it and are not just looking at, okay, I've got to tick a box and do 5 or 10%, benefit sharing or employment or whatever.
Chook feed, we call it. Yeah.
Oh, okay. I hadn't heard that one, but I'll pocket that. Others are actually thinking, in particular aspects of projects, are there major infrastructure components that we could actually outsource largely or entirely to a local Indigenous or First Nations, pardon me if I got the language inappropriate there, a company or organisation to take a leading role in. So I can't say which project is doing that, but it's an active consideration. And I guess to my point about how do we do this systematically, through things like the Critical Minerals Development Program that is currently open for applications. The grant opportunity guidelines specifically require applications to articulate what they're going to do with the local First Nations communities, how those benefits will be shared. That will flow through into the assessment of the projects, and then there's a process once the grant agreements are in place to check in that those benefits are actually flowing as described. Similar mechanisms can be built into things like loans, etc. Does that go to your question?
Absolutely.
Thank you.
I'm interested to know, though, is this being driven by industry as self-generating and actually doing this as part of ESG, or is this something the government is generating through that grant system? I don't know if you can clarify that for me.
I might just take this. It's clearly both. So the ESG pressures coming from international investors is clear across different components of the ESG, the Sustainable Millennium Goals and sustainable targets, etc. It's not just the climate change, but it's also about governance and environment and engaging with First Nations people. It's a global step up in views, and given a lot of the money that goes to our resources sector comes from international investors, there is a push from that side. But it's clear that the government has a clear policy intent on improving engagements with First Nations people. It's clear in the instructions from the Prime Minister to our ministers in terms of the operation of the portfolio, and it's clear to departments in terms of our obligations under Closing the Gap. There are specific obligations on how we go about doing our business as public servants, obligations that we're required to meet as part of the Closing the Gap processes, and that flows across the whole public service. And it's an element that secretaries of departments, for example, actively engage on what we're doing to change our processes all the way through our systems so that it's embedded in the processes. And my colleagues have talked about what we're doing specifically on grants and critical minerals, but of course you would be aware of the overarching Environment Protection and Biodiversity Conservation Act also has obligations on engagements and processes, and we work with our colleagues in our sector to make sure that they're compliant with those obligations. And we also work with our colleagues at the in IAA in terms of how to go about it and improving our capability as an institution to be able to do the sorts of work that you're sort of talking about with First Nations people. So I don't say that we're get everything right all the time, but it's a significant focus and engagement driven by our ministers' intentions, but also a commitment from the public service.
And given that, obviously, by the time it gets to final investment decision, and as you noted, that most of those are international investors, free, prior and informed consent continues to be a very, very big issue for First Nations community. And given that, I'm really interested to know that, what is the sort of uniform ESG framework that the government are using at the moment? Is there one in existence?
So it's fair to say that there are different obligations in different parts of the regulatory environment, and that those obligations are being tested through the court system. And so in our portfolio, there's been test cases and legal decisions that will influence the way the law is interpreted. So it is the case that there are obligations in different parts of the regulatory environment, but there is a genuine mechanism for testing those, and then it's incumbent on the government to review lessons learned in one part and work through matching things. So we, for example, have had a case go through in relation to the gas system, the Barossa case, and we work with our colleagues in other parts of the system to see what the implications for that are. And so there is an attempt to move together, but there is the reality of different statutes in different parts of the system.
And we've seen that happen, obviously, in the Barossa gas field, and the example there of the lack of consultation with traditional owners, and the fact now that we have to look very seriously. But I also want to note that, the industry stakeholders that I've met with, particularly MCA and others, that there's not a necessary want to use the ESG framework, and we're adopting language like sustainable mining principles or practices which don't go to the heart of what ESG actually represents, and that when I talk about social licence, these are really important parts of then the Commonwealth, as we've sat here and heard about Senator Pocock's question, where the government can throw an enormous amount of money to contest traditional owners' consultation on country, where they don't want projects like this destroying their environment. And we continue to see the enormous amount of power that is used against that when there's a lack of consent and a lack of social licence that's been given as part of that free, prior and informed consent. So I hope that the department is moving in the direction that I hope they are, to use a uniform ESG framework so we can actually solve that problem. Can I quickly go to methane emissions and just how we're monitoring our offshore oil and gas projects being reported by industry? Can somebody tell me a little bit how we're adequately measuring and reporting those?
Senator Jane Urquhart, Deputy Secretary. That's a matter for DQ, Department of Climate Change, Energy, Environment and Water.
Okay, no problem. I can ask that question there. Thank you. Decommissioning?
Yes.
That is us.
Yeah. Have a bit of a change of seats.
What would you like to know about decommissioning?
Yes. The Centre for Decommissioning Australia estimates that more than 57 billion worth of decommissioning work needs to be done, most of it this decade, and this includes capping and abatement of more than 1,000 wells, the removal of 57 fixed platforms, 535 subsea structures, 5,000 kilometres worth of pipelines, 1,500 kilometres cables and 11 floating platforms. So what are the provisions that the government is making for the $57 billion of lost tax revenue that will result from this decommissioning?
Senator, I think Ms Lawshay could possibly outline for you the provisions under the OPGGS Act in the offshore environment.
Hello. Thank you, Senator. Senorel Lawshay, I'm Acting General Manager of the Offshore Strategy Branch. So decommissioning is a normal and planned activity in the life cycle of an offshore petroleum project. In terms of taxation itself, I think that would be a question for the Treasury portfolio, but I can talk about the frameworks in terms of what we have in place to ensure safe decommissioning and remediation of the environment.
Yeah, I'm happy for you to talk about that.
Yeah. Okay. So decommissioning is part of a broader concept under the Offshore Petroleum and Greenhouse Gas Storage Act. And so that deals with both the removal of property and restoration of the environment. Under the Act, the National Offshore Petroleum Safety and Environment Management Authority, so NOPSEMA, is our offshore regulator, and they're tasked with monitoring and enforcing compliance with legislative obligations. So the base case for decommissioning is that all infrastructure must be removed once it's no longer in use, unless it's able to demonstrate an alternative approach with either equal or better environmental and safety outcomes. If a title holder does not comply with those obligations, then NOPSEMA has a range of compliance and enforcement mechanisms in place to ensure that removal of property and remediation of the environment is undertaken.
Okay, great, thank you. I'll reserve my other questions around tax for Treasury.
Okay.
Thank you.
Thank you, Senator Cox. Going back to Senator McDonald.
The REMP states, since the last Resources and Energy Major Projects report, over $30 billion has been committed to oil and gas LNG projects. Growth in oil and gas prices encouraged FID for several very large gas projects, notably Scarborough, the Pluto expansion and Crux LNG, all located in Western Australia. Most of the future investment in gas in this report seems to be on the West Coast. Is the department concerned about a lack of future projects in Victoria and New South Wales?
It's correct that the significant increase in investment and the final decisions were in Western Australia in the most recent major projects report. We mentioned earlier that there's a flow of acreage releases and the implications that would have flowing through time. There is a significant amount of projects going through the steps on the East Coast and at various timelines and various hurdles they have to go through. So the ACCC has looked at the shortfall situation and other than the immediate issue which is resolved through the Heads of Agreement mechanism, things look okay out to 2027. Beyond that, there is a projected shortfall which would depend on the supply and demand. So it is something we keep a very close eye on. You mentioned the annual release of the official statistics, partly because that's a process we go through, but we do keep a track of things in the meantime. We do need to keep a close eye on the release of projects. It doesn't matter so much where it is on the East Coast, given the connections of pipelines, unless there's capacity issues in the pipelines. And that in itself is a regulatory process that the Department of Energy is looking at to make sure there's sufficient pipelines and the pricing is available to get the gas through the system. So it is a watch point. At this point, the concerns are beyond 2027 against the ACCC's assessment. But as we've talked about, things can change, so it can't be a set and forget process.
Thank you. Over the course of consultation on the ADGSM, Heads of Agreement, Gas Code, has the department learnt of any future investments in gas projects now under a cloud or not going ahead where proponents have cited the government's intervention as a reason?
So we are aware of the press releases where people say they're pausing to consider the situation as they get clarity on the situation, and that's not unexpected at all. There will be clarity provided within the next few months, and then we would assess the situation again.
Is the department aware of any new significant projects to bring gas online that have been announced since the intervention?
So we're not aware of any new ones announced, but I'll just pause.
Senator, I'm David Lawrence, Acting Head of Oil and Gas Division. I believe Santos earlier this week announced that it had received the relevant environmental approvals for the Dorado project in Western Australia.
Sorry, Mr. Lawrence.
So it had it.
Could you just repeat it?
So Santos had announced it had received the relevant environmental approvals for the Dorado project in Western Australia.
Thank you very much.
So just the one, nothing on the East Coast?
So, Senator, I think it's fair to say that in our engagement with industry, companies continue to talk with customers and look at, for forward investment. They continue to talk with customers. In some cases, it's buyers that have actually stopped talking to them, not gas producers stopping talking to customers, is what we've been told. And as the Secretary said, they're waiting to see what the rules of engagement are.
It's also the case, it's only been a few months, and so there's a seasonality as well to some of this assessment, given summer holidays and things like that. So it is something we're actively looking at.
Thank you. If moratoriums are not lifted on gas exploration and production, and there are no additional gas supplies brought on close to areas of demand in the south, isn't it inevitable, as evidenced by the data contained in ACCC's most recent report, that long-term LNG contracts with international customers will have to be broken to meet domestic requirements under the proposed new ADGSM? There will be no choice, given the lack of supply-side policies, but to break contracts and trust with our trading partners. Secretary, sorry.
So there are regulatory environments in place to prevent such an outcome. That is the intention of the government, to make sure there's enough transparency to the market, that the regulatory regime is known to everybody. There are incentives in place for people to provide the gas that consumers need at reasonable prices. That's the intent of the regulation, and that's the process. The government is going through the process of implementing that regulatory regime. There's a whole bunch of steps before you get to the possible outcome that you foreshadowed. And all I can say is that it's in everybody's interests, both the government, industry, consumers and the regulators, to achieve an outcome that balances the need for international investment, reasonably priced gas for industrial users, and the quantity of gas that needs where it to go to. These things usually get worked out in Australia, and that's my expectation.
So, given, as you've highlighted, the amount of time it takes to bring projects to market, the, I guess, fairly clear vision you now have of production, do you have a projected timeline before the government reaches the point of failure and is forced to pull the trigger and to break contracts?
So it's the gas industry is making record profits. There is a very large incentive on them to provide additional investment funds in Australia and elsewhere. There is a very large amount of exploration projects and projects coming through the pipeline. That's the latest data we've got. So the foundations are there for supply to come through. So we'll have to wait and see. But at the moment, the data on the table is that there is record profits, that there is a regulatory regime that is intended to ensure supply comes into the system at a Commonwealth level, that there are projects on the deck and there's funding available. So we'll wait and see. But at the moment, all of the things are pointing in the right direction.
So you refer to record profits, but the price intervention removed that. That's now at a temporary price intervention, it's been described as. But at Treasury yesterday, the mandatory code of conduct and the reasonable pricing provisions were described as ongoing. So do you think that that change in profitability for gas companies will change their appetite for investment in Australia?
So, the short answer is no. The $12 is set above the average price that people were using to make investment decisions in the Australian market for a very long time. So $12, while significantly lower than the prices that were being faced by industrial users, is still higher than the prices that were previously experienced in Australia in the domestic market. The ACCC itself has provided the advice around setting the $12 and how it fits with the reasonable pricing regime for a temporary, the temporary regime that is only for 12 months. So their advice to government, which they have talked about, is that it's a reasonable price relative to the existing projects. As I've mentioned today, and as the chair of the ACCC has said herself, the intention is that the Code of Conduct, when it looks at the reasonable price, is very focused on ensuring additional supply comes into the market, because additional supply will increase the competition in the market, will increase the availability of gas for consumers. And so it does come down to reasonable price, ensuring adequate supply over time. That's the intention of the policy, and that's being worked through with both users and producers as part of the consultation process now, being led by the Department of Energy.
All right. You mentioned earlier about the infrastructure constraints at peak points of demand between Queensland and further south. What recommendations or conversations have you had with the Victorian Government, especially about the need for more supply closer to southern demand points?
So those choke points and the implications for the gas pipelines actually all policy responsibility of the Department of Energy. So I'd have to direct you to them. That they would be the ones, if any, having conversations such as you just asked.
Right. But you will be providing advice to that department on where you're seeing additional gas supply generated from the project pipeline that you're seeing.
That's right. So we talk about where the projects are and where the potential is, and what the resource side of the process is. That obviously informs views about where pipelines need to be. It also informs industry's choices about where they locate their enterprises, etc., and that it all has to come together to work as a market. But the regulatory obligations and the pricing and the arrangements around the infrastructure, the gas infrastructure, is the Department of Energy. So we work together to think about it, and you're right that where the location of new fields has an influence on the infrastructure demands, and the system will need to adjust to work through those issues.
So, given that we know that infrastructure construction is not something that happens overnight, are you engaging with the Victorian state government about how they can bring supply closer to home to ahead to market?
We do work with we do talk to our colleagues across the states in terms of what their arrangements are for supply across the resources sector, not just the oil and gas sector. So we are in touch with our colleagues and what they're thinking about and what they're doing. But it is true that both infrastructure takes time, so do the projects. That actually works in favour of good planning in terms of being able to see what's coming down and being able to make some decisions on planning. The intention would be that it all works together.
Are you aware of any projects in the Victorian geography that are look like they're coming to market to an investment decision within the sort of timeframes that the ACCC is pointing out that there will be a supply shortfall?
I'll pass to my colleagues.
So, Senator, my understanding is that Beach Energy's projects in the Otway Basin will be coming online over the next couple of years.
So the Otway Basin is the offshore acreage that we talked about in the 2022 release that they've put a bid in for and was announced just recently, is that correct?
So, Senator, my understanding is that Beach Energy has had these acreage for some time and is bringing it to market and is developing those projects as we speak.
Right, that's not the Otway Basin project acreage release that we talked about just before?
No.
Different one.
The earlier one.
Terrific. They've got environmental approvals on that?
I believe so.
Great. Have any of your conversations... Oh, sorry, were you speaking to me? Or am I just... No.
That's very good, sorry.
Secretary, have any of your conversations with producers involved, or perhaps actually Mr Lawrence, as the head of this section, I should direct this to you, have any of your conversations with producers involved discussing how to stimulate investment to bring on more gas Or is it focused on the regulation, price control and anti-investment options?
Senator, I think my team has had since July, over 70 meetings with stakeholders. And while they have been focused on the ADGSM and primarily, we've discussed a range of topics, including investment.
Great. Can you give me an example of, project encouraging proposals that you might have been able to consider with stakeholders?
So I think, Senator, we've had, as I said, we met with a whole range of producers as part of our consultation. So we've met with, we've met with Esso, Woodside, Beach Energy, Cooper Energy, Cenex, Comet Ridge, a whole range of them, and all of them have talked about projects either in Victoria or in Queensland. And it's probably South Australia as well.
Sorry, I was just looking for, new initiatives that would assist them to bring new projects to investment decision.
So that all goes to, advice to government on different processes and policies. I mean, that it's all the same sorts of considerations have been around forever, like what's the expected price, what's the expected costs, what's the regulatory environment, what's the market opportunities. It's the case that the demand for gas is significant in Australia. And there's different kind of views about that, but as a transition support for the emissions reduction targets that are in place at the state level as well as the Commonwealth level, there's a lot of clarity around for proponents in terms of the demand side. The prices are very advantageous. There are issues on the cost side that all industry is having to reassess and refocus on in terms of supply chains, etc. In terms of regulatory environment, it's certainty of the regulatory framework that's the thing that people have raised directly with me. The point they make is that they deal with lots of different regulatory regimes in different states and countries around the world. It's understanding what it is, the rules of the road, and then they can optimise their investment decisions around. So that providing that regulatory certainty is important. And in that context, it's important, in order to get regulatory certainty, the regulation environment has to be meeting the needs of the Australian people. And so I think that providing certainty is important. The government's working through that in terms of the processes that it's undertaken now.
Thank you. I'm not sure, Secretary, if I should direct this to you or to Mr Calder, the Acting Chief Economist for the Department. Is Mr Calder here?
So it depends on the question, because
Is it related to resources?
It is relating to supply forecasts.
The question can be directed to me. I'm G. Karunaratne. I'm General Manager of the Resources and Energy Insights branch within the Office of the Chief Economist.
Terrific. Thank you. I wanted to ask if the department is producing its own supply forecasts, gas supply forecasts.
We do not produce a domestic supply forecast in our current work program. We produce export forecasts of our LNG. We share that information with other areas of government that do domestic supply forecasts. So the Australian Energy Market Operator and ACCC.
That's terrific. So that gives me a good understanding, because I wanted to understand with the forecasts, who can we, who will be producing them, and which is the part that government will take notice of. So you're sharing that forecast information with the ACCC and AEMO.
All our information is very public, so they can also access. Everyone can access that information.
Yes, but hopefully they're not just.
No, we engage very closely.
Yes, they're coming and knocking on the door and talking to you.
I would characterise it as a close working relationship with peer review. So there's many conversations about assumptions and information and peer review processes to test the veracity of different assumptions. All forecasts looking forward are based on a set of assumptions, and it's important that people are testing those with peers that have got relevant information.
So when will you produce the next supply forecast? When will you update that next?
So we have, so you may be referring to, I'm not sure which of our publications you're referring to, but so we produce a Resources and Energy quarterly forecast of our exports on a quarterly basis. The March quarter results will be by the beginning of April. And then we produce an annual Resources and Energy Major Projects report, which is always done coinciding with the release of our fourth quarter Resources and Energy Quarterly, which is towards the end of December.
So we've had a bit of conversation about that before. The last one was published, I think, the day before or the week of the price intervention regulations that were introduced. So I was asking whether or not there would be an interim report, but it sounds as though the Resources Energy Quarterly report will take the place of, will inform what's happening over the next 2 quarters, 3 quarters before the next REMP comes out.
Yeah, so that doesn't do a comprehensive list of domestic projects. We are working with AEMO and ACCC on how we can get the best quarterly data to inform the Minister's decision making on the quarterly ADGSM. As you know, the Australian Energy Market Operator does an annual gas statement of opportunities report, which we and the ACCC draw heavily on. And that we'll be looking to supplement that with contractual information that ACCC is able to get through their powers.
Yeah, terrific. Minister, how do changes to the ADGSM, an emergency export limiter, increase gas production onshore or offshore?
Well, the problem, of course, is that there is... Well, the problem for you, I think, is that there is a connection between, very strong connection between what the government is working through in terms of all of these mechanisms and the short-term questions about gas supply, the long-term issues around gas supply. There is a relationship between what we say and what we do. And I know that may be a foreign country to people from the Morrison government period. I mean, during the Morrison government period and the Turnbull government period, the government did everything it could do to increase gas supply, except anything that would increase gas supply. And the only reason that there has been any increases on the East Coast in terms of gas supply is because the Queensland Labor government has opened up exploration in Queensland, and some of the language, I mean, it's really unclear to me how this act is pulled off, both for and against gas supply, for and against regulation, for and against the gas mechanism, for and against price caps. I look back at what Senator Canavan had to say in 2017. I mean, you complain about what ministers say now. He said, the Australian government is focused on ensuring domestic gas users have access to a sufficient supply of gas at a reasonable price.
Minister, because
the world according to Tim Ayres.
Yes,
it's going to be a bestseller.
Relevance
really
is my point of order, Chair.
Okay.
Most specifically, Minister, I asked how do changes to the ADGSM, which is an emergency export limiter, how does that increase gas production onshore or offshore?
I'm not sure I understand that. I'm not sure I understand your question. You've just gone through quite some detail with the department.
Yes,
about the relationship, and it's been, you've sort of jumped around between sort of short and long term supply issues, and I understand there's a sort of strategy to conflate these questions. The department's been very thorough in answering the questions. I understand there's an effort to try and create an apprehension that there's some uncertainty being created as the government works carefully through what future alterations might be required to what has clearly been a deficient ADGSM mechanism that was cobbled together by a previous government, and that case has not been able to be made out.
Minister, thank
I
you.
anticipate there'll be further efforts to do that. But,
well, Minister, I'm only asking questions on behalf of, you know, our shared stakeholders and industry who are...
Is that right? Is that right?
I think she's asking some good faith
yes.
questions
So-
and wants more than political spin.
So they are
Well,
quite,
you've got answers. You've got answers in detail.
I'll just make the standard statement that questions are asked and ministers answer them, and senators may not always like the answer, but an answer's being given.
point.
And
We don't.
Senator McDonald, you do have the call for
Thank
more
you.
questions.
So, as the government, you remain confident that policy interventions will not cause a shortfall. Do you believe, Minister, that the ADGSM will not be triggered this year?
There's arrangements in place, well publicised, the subject of a lot of discussion in the last quarter of last year. The government is so those arrangements stand. I see nothing that diminishes my confidence that those arrangements won't remain in place for the duration that those arrangements were made for. The government is consulting with industry now, and those arrangements are, you know, we are considering the future shape of all of those arrangements, and we're doing that in the interests of all Australians, because it is clear that the task in front of the government is to deal with the short-term price and supply challenges that have been brought into sharp relief because of Russia's illegal invasion of Ukraine and the impact that's had on gas prices around the world. And the problem is, and in addition to that, we secondly have to focus on the long-term supply challenges, because there will be a requirement both within Australia and our domestic market on the West Coast and on the East Coast for gas supply for households, but in particular for business and for manufacturing on the East Coast in particular. And there will be a requirement in global markets for Australian gas. I think one of the officials set out, you know, in response to some of your questions, why that is important in emissions terms, that gas is available for our partners in terms of their industrial processes, why it is important in economic terms, and why, frankly, it is important in security and global cohesiveness terms. And those that the government is going to continue to pay very close attention to those matters, and will do it in a careful and coherent way. And one of the reasons that the last 6 to 12 months have shown that the arrangements that were in place
Minister,
before have not been resilient. Have not been resilient.
Bring this to a head, please.
Is because we sit against the backdrop of 10 years of policy failure.
Terrific. Okay. So,
policy
Minister,
failure.
Minister, can you then confirm?
And that's
can
why.
You confirm? Can you
that's why we are
guarantee-
recovering and trying to bring back some coherence to this area of policy.
Thank you for that You should never ask a politician to say in 10 words what they can say in 100, so thank you for living that out.
Well, we
Minister,
share this challenge,
can
Senator
you
McDonald.
Can you guarantee right now that the ADGSM will not be triggered this year? I did, and he didn't address it. He talked around the world.
Well, I said I think in the first 30 seconds that
The one-way traffic flow.
Yes,
Can you guarantee it? It's yes or no.
I'll just wait.
Yes
I'll
or
just
no?
wait for a bit of quiet. Senator Dunningham's been very well behaved so far.
Generally. Sorry, Chair, I'll
Okay.
admonish myself.
The Minister.
There is a set of arrangements in place.
Yes or
There
no?
is nothing that I've seen that diminishes my confidence that that set of arrangements won't continue for their full duration.
Excellent. So that's a guarantee that the ADGSM will not need to be pulled.
I said what I said.
Great. So noting Mr Lawrence said that the ADGSM is a measure of last resort, would you agree that triggering the ADGSM due to supply shortfalls would indicate that your policy interventions have failed?
Well, the ADGSM is a policy measure that was cobbled together, I think, during the Turnbull period, and we, as a
But
government,
you're making changes to the ADGSM,
are engaged in
So
considering
this is
changes.
Your new, yes, you're consulting on that.
And we'll continue to do that. That's all I can say.
Okay, terrific, thank you. In response to question on notice B1-123, the department stated the department provided advice on the economic impact of the closure of coal-fired power stations and associated mines in specific regions. Can the department advise the specific coal-fired power stations and mines it provided advice on?
So I'm happy to, I'm just checking the officials, I'm happy to take that on notice. I'm not familiar with that advice. I think we had a good exchange last time and it was prior to my arrival. So I'm happy to take it on notice, the extra specificity that you asked for.
So there has been a question on notice that has identified economic impacts on the closure of coal-fired power stations and associated mines in specific regions. You took this question on notice last time, so I would be incredibly frustrated if this was taken on notice again. So I'm looking for the specific mines and regions that the department provided advice on the economic impact of the closure of these coal-fired power stations and associated mines in specific regions. Your response, not mine.
Yes, the government's response, and happy to take it on notice. Don't have that extra information before me, so I'm just checking.
You got it.
Terrific.
Right. So just checking officials. So yes, we have the question on notice. So if you, with your indulgence, the officials that did that work are as part of our government, our industry development area. They'll be here a bit later today, so I can kind of check with them to see they're on program 1.2.
Terrific.
So happy to see what they might be able to provide in the meantime. Otherwise, very happy to take it on notice, the specifications that you've asked for.
Well, I think that's perfect because they are now listening and they know that I'm asking them to bring specific information on the advice that the department provided on the economic impact of the closure of coal-fired power stations and associated mines in specified regions. It is a single document. I would ask that they bring it. It is not a cabinet document.
So I'd have to check all of that because, as I sort of said, I'm not familiar with the exact document. So happy to talk to the officials that were involved in the work and see what we can do to provide support. I just note we always have the option of taking things on notice and consulting with the minister.
Well, that would be the case if the department officials just hadn't had notice that I'm going to ask this question. Like all good organisations, it will be available on a Google Drive or
Senator
something.
McDonald, I think Senator, I'm having a bit of sympathy for the officials who've literally been answering predominantly your questions for hours and doing the best job that they can do that.
Yes, they have. Yes.
So I think
these are fresh officials. Fresh officials who are coming, Chair.
The ones that you're asking questions of at the moment are doing, I think, their best to answer your questions. So I'd ask that you just continue with your questions.
Senator McDonald, the department will do the best that they can to help you this evening and this afternoon, but they do have the option of taking that question on notice if that's what's required.
Yes, I am flagging that this question has already been taken on notice. This is not new question. This is not. It would seem to be an obstruction of the Senate process if it was to be taken on notice again, and so I ask, given that the fresh officials...
As the Chair, I do feel like I've just dealt with this issue and I'd ask you to continue your questions.
Thank you, Chair. I am also flagging that as the inquiry body, it wouldn't be appropriate, and I wouldn't think, for the department to take something on notice multiple times.
I'll just ask you to continue your questions.
Thank you. Secretary, what are the key focuses of the Critical Minerals Development Program?
So, Senator, the Critical Minerals Development Program is a $100 million program that provides co-funded grants. It supports early to mid-stage critical minerals projects through challenging points in their development cycle. So it aims to help them overcome technical and market barriers to their production.
Oh, thank you. The member for Hunter, in a speech delivered to the Federation Chamber on the 7th of November 2022, stated, "The Critical Minerals Development Program has also been reframed to more closely reflect our objectives, incorporating Australia's decarbonisation opportunity, gender equality and Indigenous participation." Was the Minister aware of the addition of these objectives into the Critical Minerals Development Program?
Yes, that's correct. So when the government reframed the program, there was subsequently some changes that were made to the design, and for example, around the grant guidelines for the program, there were changes made to be able to better reflect those priorities in relation to, for example, First Nations Australians and the elements that you mentioned. And so that means that assessment of proposals under the program will take into account the extent to which the projects will contribute towards those particular objectives. And it also means that successful projects may be required to develop, implement or report on action plans in relation to those objectives.
Can you tell me, Ms Lane, that, I'm sorry, have I got that right?
Long. Ms. Long.
I'm so sorry. When did the reframing occur?
So, maybe we've got the specific dates.
Yeah, we could possibly, Senator Andrew Hutchinson, General Manager, Critical Minerals Office, we might take the particular dates on notice, but recollection was through the government's consideration of that measure and then announcement of it in the recent budget.
Thank you. So you'll take that question on notice. Thank you.
Yeah, I might just indicate on that point that, just so that we're straightforward with you, Senator, that, I mean, that work is still ongoing. It will be the subject of Cabinet deliberations. I just make that qualification. So that may constrain what it is that the department can provide you with.
So this was already announced at the last budget, the critical minerals funding.
To the extent that the work is still continuing, I'll just add that qualification. Whatever they can provide you with, I'm sure they will.
Right. So there are no new programs, grant programs announced that people can apply for currently. There was money in the budget, but those programs haven't
Sorry, I
been
thought you were
announced.
talking about the critical mineral strategy.
Yes, that is. That is what I'm talking about. And that had money attached to it. And so I thought that that grant parameters had been landed?
So, Senator, to be clear, so in relation to the Critical Minerals Development Program, there was a first tranche where there were 6 projects that were awarded for $49.7 million in grants, which
They were
occurred
the ones that Minister
last
Peter
year.
announced.
There is now a second tranche of grants, which is available and open at the moment for application.
But the application, the parameters must be agreed, because otherwise that would be unreasonable to say to people. Just to clarify, so we do think the grant parameters have been finalised, and that's not subject to Cabinet because the grant round's announced.
And they were released as part of the opening of the grants.
That's correct, yeah.
So, Secretary, will these objectives impact any investment decisions made under the program? So the 6 projects that have already been announced?
As a general principle, the grants are assessed against the guidelines that go with the release of the timing. So there was tranche 1, which was under one set of guidelines, 6 projects already assessed, already announced. Tranche 2, the grant opportunity guidelines were released at the opening of tranche 2 in January 2023. And so those, any subsequent bids for those grants will be assessed against those guidelines, including the changes that the government included in the budget 22-23 reframing.
Yep, so we can separate the 2 tranches. The first is separate to the second lot. Can you explain how these objectives will be implemented into the strategy?
So the strategy, the team are consulting at the moment. Submissions are being called for, and there's been lots of roundtables in terms of providing a mechanism for the government to update its critical minerals strategy. So this is all in the open at the moment, and so my colleague, Mr Hutchinson, talked a little bit about how some of the consultation processes around First Nations and some of the different options available there. They're all things that we're asking people about how they would like to see these sorts of things reflected in a new strategy. Consultation has happened across different stakeholder groups, industry, as well as community organisations. So that's all part of the work that the department's doing now to support government deliberation.
Right, so, because I was going to ask you about a timeline for the strategy being published, but this is what the Minister's referring to, that will be the subject to Cabinet deliberations.
Yeah.
Right, okay. Can I ask about a timeline, or is that part of Cabinet deliberations?
So the government has been consulting now. I think we closed in February, the kind of formal submission stage, but I'll just pass to my colleagues to update you on timing.
Senator Jane Urquhart, the 6th February, the department had received 108 submissions in response to the consultation discussion paper. Those submissions are currently being reviewed, and we anticipate being able to provide a strategy for consideration to the Minister in the first half of this year. So the opportunity is there for her.
Well, that's a terrific response, isn't it? That's exciting. I'm not asking for your opinion. I think that's a terrific response.
There is a lot of interest in critical minerals, given the net zero targets, but also the geostrategic implications for the goods that use critical minerals.
It is no secret that I'm lobbying for phosphate and potash to be included on that list.
I believe you raised that last time.
I did raise it last time, but I figure if I say it 1,000 times, it'll be heard the first time, so thank you. Will the implementation of these objectives affect investment? To your point about the criticality of supply chains.
There is a lot of demand for critical minerals around the world. There are great opportunities for investment. As I mentioned in relation to a previous consideration, investors are looking to make sure that they meet community standards. Those community standards are being brought into sharp relief around environmental governance and social objectives. So I don't believe that there's a mutual exclusion between meeting community standards and having investment opportunities. Long-term investment frameworks need community support. So there's a mutual benefit.
I was at the Sustainable Minerals Institute in Brisbane, University of Queensland recently, and they raised the requirement for sand as a critical, as a strategic resource requirement that is not considered, you know, it's a very everyday, but for construction, for glass, for solar panels, and I hope that they have made a submission on this matter. Can I ask if they've made a submission? Is that something you'd disclose, or is that confidential?
We'd have to take on notice, Senator, whether they did. Some submissions are confidential and others are happy to be public, but we can take that on notice.
I've read it into Hansard that they have an interest in that, so that's terrific. How will these objectives assist in developing critical mineral projects in Australia?
Well, I'll just restate or just refer to my previous answer, which is community support for investment's really important for the stability of projects over time. And so where community concerns are addressed up front in any process, it tends to result in a better outcome for everybody. So having good consultation, clear regulatory frameworks, appropriate processes for dealing with any differences of view or conflicts early and openly generally improves the investment environment for all concerned. So we've seen this time and time again, the importance of good consultation, good engagement. We've seen many successful investment processes and projects achieve those objectives, and we will be working to that aim.
Yeah, terrific. All right. Department officials, thank you very much for your patience. You've given me a great deal of information, and the Chair will be delighted to know that is the end of my questions for this part of the day.
It may not just be the Chair, but I am delighted. Thank you, Senator McDonald. I understand Senator O'Neill just has a couple of questions, and we're on track for our break and to release you.
Thank you. Could I just go back to a comment that you made, Mr. Lawrence, that piqued my interest? I think you said at one point of time, with regard to consultation, and this was in the context some time ago of Senator McDonald speaking about tension with suppliers. You said, in terms of negotiations, I think you responded, it's actually buyers who stop talking to suppliers. Did I hear you correctly?
Senator, in a couple of instances, gas producers have told us that gas buyers have stopped talking to them while they wait for the rules of engagement as well around the mandatory code.
Senator, can I add to that?
Yes, please.
Just to say that ACCC is closely monitoring gas supply. We do too. Concerned to sort of understand the behaviour of market participants. As a newcomer to this area of policy, it's been very interesting to me to learn from my colleagues about the patterns that you tend to see in contracting of gas across a year. You know, we've had some visibility through our engagement of producers, but also of industry users. I'll just repeat that Minister King had secured commitments last year from producers to supply 157 petajoules in addition to the 195 or so of gas already contracted to be sold. Now, while there are some East Coast businesses who purchase gas from the retail market who may remain uncontracted, you know, for the most part, the year is contracted well ahead. So it's not really a genuine indication of the state of contracted gas to be looking at the year in the year, if you see what I mean.
This goes to Ministeria's statements about the conflation of the near-term and the long-term market and the multi-year nature of arrangements, which really are about significant amounts of gas and money.
It goes to the practices of buyers, and so obviously, you know, like in any market, there'd be some who would work ahead, dealing either directly or through, you know, established large retailers, others who might leave it and then be working through, you know, spot or other sort of avenues. But what we know is that the majority of users had secured gas contracts for 2023. We also know through Minister King's work with the producers that sufficient supply was found to plug the forecast shortfall. And what we know is that in January, typically only short-term deals are struck. So at the moment, it's very difficult to see that there's an impact, but we are very alert to it, watching it very closely, and will continue to do so.
I guess in any market where the ACCC starts to take an interest, and in other work in this parliament, it's become apparent that where there is a power differential, negotiation isn't always what we might hope it would be. I think it's important to give the flavour of the complexity of those relationships, that it's not just suppliers who might have some uncertainty at this point of time, but buyers are also saying, hey, let's take a deep breath. And I think that it reflects well on the department that you're very aware of that, and the complexity is revealed in both parties being engaged in perhaps a redress of imbalances of power and making sure that they serve all the needs, not just international needs, but Australians' domestic needs as well. So I thank you for that comment, Mr. Lawrence. I think that was quite instructive for me, watching it at a bit of a distance. The other thing I want to come to is the last part of the questioning from Senator McDonald, which was around the critical minerals. Was that $100 million, did you say, was the...
Yes, the program is $100 million.
And there's a sort of a before and after tranche 1, tranche 2 situation in which different entities are engaged in bidding for that investment of up to $100 million in toto. Now, could you just confirm for me if this is correct? I understand that the former Liberal National Government released the first critical mineral strategy in 2019 and updated that strategy in 2022, is that correct?
Yes.
Correct. Okay. Now, did this strategy released by the former Liberal National Government discuss the role of critical minerals in regard to net zero?
Would you be referring to the 2019 or the 2022 strategies?
I'm happy to take your evidence on both.
No worries, thank you.
Because the problem's been around at least that long.
I understand, Senator, thank you. The 2022 strategy does refer to clean energy technologies at a number of locations throughout the document.
And when did that occur? What date did that come out?
The 2022 strategy was in the first quarter of last year, I believe.
Okay.
But perhaps if you'd like, if we take on notice, we can come back to you with the precise date it came out and those references as well.
Okay.
But it's still publicly available on the website, Senator. So.
Thank you. And if you could confirm for me if this is the case, did the former Liberal National Government instruct the department to avoid references to net zero or to decarbonisation in the 2019 strategy?
I wasn't around then, so...
We can take it on notice and see whether we have any instructions and consider what we might be able to help with.
Okay. And just because I wasn't quite quick enough on getting the information down, what were the critical parameters that changed in the new the new round that you were discussing? You mentioned a few items that were now going to be, what did you say, managed. There were going to be new tests, reframing of priorities, change in language and grant guidelines that people would have to develop, implement and then report on in terms of their obligations. What were those key things that weren't there previously? Yeah.
Yeah, so, and I might pass to my colleague to give a bit more detail, but what I mentioned was that there was a number of areas. So that would include climate action, gender equality and also First Nations Australians. And so, as I said, in relation to the grant guidelines for that tranche 2 with the Critical Minerals Development Program, assessment of proposals will take into account the extent to which the projects contribute towards those objectives, and then also successful projects may be required to report on their implementation and achievement of those objectives.
Okay, thank you very much. Yeah, you speed talk sometimes and my hand doesn't move fast enough. I appreciate that. Thank you, Chair.
Thank you, Senator O'Neill. And Senator McDonald has one question to be put on notice.
You're going to take on notice by agreement. Has the department provided any advice to the Minister or undertaken any work on a domestic or East Coast reservation scheme since the change of government?
So
I'm happy for you to take that on notice, as the Chair has asked me to go that way. Don't want to hold you for another second.
Okay. I have. Thank you, Senator McDonald. And that concludes our questions for the Department of Industry, Science and Resources, Program 1.3, Supporting a Strong Resources Sector. We very much appreciate your attendance and answering our many questions today, and you go with our thanks. And we will return at 4:30 with NOPSEMA. The committee will resume. The committee welcomes the National Offshore Petroleum Safety and Environmental Management Authority and its representatives. Welcome to you all. Do you have an opening statement that you'd like to make?
No, we want to use all our time answering questions, of course.
Thank you, Mr Smith. I'll go to you, Senator McDonald.
Thank you very much, Chair, and welcome. Thank you for providing your time this evening. My first question is around your 15 December stakeholder briefing, as mentioned in NOPSEMA's question on notice answer B133. What were the outcomes of that meeting? Oh, no, my first question is, did it proceed? Sorry. Did you proceed with the stakeholder briefing as you mentioned in your question on notice answer number 33? Did that briefing proceed?
Yes, a briefing did proceed. If it's the one I'm thinking of, it was in regard to the Barossa court case. And yeah, very good turnout from industry. Over 400 participants in it, and it certainly went ahead, and we outlined our understanding of the court case and how we will be looking for it to apply.
So that was my next question. What were the outcomes? Could you expand on that, of you know, the purpose and...
Sure. I'll get Mr Grebe to elaborate. He was one of the speakers at the forum. But yeah, I think probably the key outcome is providing greater clarity for industry on how we interpret the decision from the full bench of the Federal Court, and therefore what it means for industry going ahead to secure approvals from us.
Thank you.
Would you like Mr Grebe to
Yes,
elaborate
please.
at all?
Thank you. I think to add to, Cameron Grebe, Head of Environment, Renewables and Decommissioning Division at NOPSEMA. The purpose of the briefing was, as can happen after a court case, that new interpretation of the law, and NOPSEMA went through a very rapid update to key guidance and policies that describe how we take into account the environment regulations when assessing environment plans and approving or rejecting them, and also obviously that needed to be updated to take into account the relevant case law from the appeal decision. So the purpose was to brief all stakeholders on that, and that included non-industry stakeholders. As Mr Smith said, there were 400 participants in the room. It was also broadcast live online. I understand there was over 1,000 people attending in that manner. The outputs were to highlight the importance to carry out consultation in the manner that the court deemed need to be construed broadly under the environment regulations, to highlight the key parts of our guideline that's being provided to assist title holders and ensure there's certainty in how the consultation needs to be carried out before environment plans are submitted to us. And to explain that the process it would mean that the guideline was being applied because the law decision had been handed down, but for an interim period, and we were taking feedback also. So we explained the process in which stakeholders could provide feedback to us in a continual improvement sense for future updates.
That's great, thank you. So the updated regulatory requirements, have you released those yet? Was that part of that consultation?
Yes. So I think the regulations themselves weren't amended. The appeal decision identified particular aspects and gave a legal interpretation through that decision that have to be considered by title holders in relation to environment plan relevant person consultation and us in assessing and accepting environment plans. And they cover aspects such as interests not being confined to legal interests, interests being individually or communally held, activities being broader than a petroleum activity that's defined in the regulation. So it's giving more clarity around what the court determined should be interpreted by way of the provisions of the existing regulations. So they came into effect from the day of the appeal decision.
What day was the date of the appeal decision?
The appeal decision was handed down on the 2nd of December 2022.
So the 15th of December, that wasn't very long for you to have to consider to update that advice. Are you, you know, do stakeholders feel satisfied that they understand the additional measures or the broader measures that you were talking about?
The guidelines are just a part, and we actually updated 15 documents that directly or indirectly were relevant to the appeal decision and the outcomes from the appeal. We did have to divert staff onto that work while carrying out other regulatory activities at the same time. But it's not the only action we're taking, and there is obviously the feedback process. We're also have a large program of, as part of our normal course, meeting with title holders individually to provide advice and assist them in understanding the requirements and how they now apply and how we make decisions. But we're also meeting with other stakeholder groups such as First Nation representative bodies and First Nation people directly, as well as fishing industry and other stakeholders so they also understand the requirements. And we have other ongoing actions internally in terms of capacity building, training and other system changes to ensure that we make robust regulatory decisions with the new requirements.
Thank you. I had a question written down. Have you consulted with any external bodies or consultants in regards to updating its requirements? So you've just outlined a couple of external bodies.
Yes.
Any consultants to assist with that?
No, we did the initial update and development of the guideline internally. There's a large volume of information already provided in the federal court decision. But we are engaging on a range of other sets of guidance, including fact sheets and information papers to assist stakeholders. And some of that goes to engaging with the National Indigenous Australians Agency, for example, to ensure that we're providing guidance and information and engaging with those groups in an appropriate manner.
Can you, the consultation with the external bodies, did you produce a document of advice or input that they provided?
On this topic, no. The guideline itself is focused on explaining the clarifications and how the law should be interpreted after the appeal decision of the federal court. So there isn't sort of space or a need to consult for input on that. Where we have worked with groups is, for example, with the Department of Industry, Science and Resources and Agriculture, Fisheries and Foods as well on guidance for how the fishing and petroleum sectors could cooperate and consult more effectively. And so there are specific targeted instances where we have sought inputs from those groups as well.
Sure. What does NOPSEMA consider relevant persons in the context of its mandatory consultation processes?
Well, the relevant person requirements are all listed in the regulations, so they're sort of not our requirements. I probably wouldn't describe it that way. The environment regulations stipulate a range of categories of relevant persons. It includes the relevant responsible ministers, for example. So some of them are very self-explanatory. The case that we've been discussing is in relation to a particular category of relevant persons, so those that are persons or organisations whose functions, activities or interests may be affected by the activity. And that's where there's a lot more prescription and detail about precisely how you need to extend the reach and what information should be considered by title holders in determining who is a relevant person. The regulations, this is set out under objective-based, so it does vary on each individual case, and there will be certain persons or organisations who may be relevant persons in some instances and not in others, for geography, the nature of impacts and risks, where the type of activity and so on.
All right, so my next question was around how that differed from the previous directive on relevant persons. So that would be your answer to that, that it's that expansion, yeah.
Yes, Senator. Yeah, the court determined that there should be the provisions of that part I read out, the persons whose functions, activities or interests may be affected should be construed broadly. And, for example, the interests weren't just limited to legal rights, say through native title or heritage protection laws, that it should extend beyond those.
It's prescriptive on what it should extend beyond?
The court's decision was yes.
Right.
Senator McDonald,
sure.
Enforcing the blocks. I'll
Yes.
come back to you.
Thanks.
Thank you. Senator Pocock.
Thank you, Chair. Thank you very much for your time here today. At last estimates, I was asking a few questions about an oil spill in March last year off Varanus Island. And I understand that NOPSEMA don't have jurisdiction over the island itself, but I understand there's a number of facilities around there that you do, that are under your jurisdiction, and that last year you ordered a company to stop drilling near Varanus Island. And in relation to that, I've got a few photos and a brief statement I'd like to table for the committee and then just ask a few questions if that's all right. Chair, is that all right?
Yes, if you give it to Rachel, she'll show us the material. Did you say it was photos and something else?
And just a brief statement.
A statement. So we'll just have to take a moment, Senator Pocock.
Oh, there might be copies, yeah. Thank you.
Try and make it quicker.
Yes.
Like a cooking show.
Senator Pocock, would you be willing to consider tabling the photos without the statement, just as a threshold question? I think if you're wishing to table the statement, we're going to need to have a private meeting to discuss that.
Okay. I'd love to be able to table this statement just to be able to reference a few things in there.
That will require us to have a private meeting, and I'm not sure what the outcome of that will be.
Okay.
We can do it. We can do it. We can have the private meeting. Okay.
Thank you.
The committee will resume, and the committee has agreed to table the documents provided by Senator Pocock, and they'll be provided to representatives of NOPSEMA and Senator Pocock. You have the call.
Thank you, Chair, and thank you to the committee for allowing this to happen. I really do think it's important that people have this avenue to raise concerns. This courageous young whistleblower was working on Varanus and talks about the circumstances of the spill, and then goes on to say, I might just read a few things while you have a look through the document. The tragedy of dolphin carcasses amid a kilometre-wide oil slick should be the story, but it's not. The story is Santos's subsequent cover-up and total disregard for the values they say they hold dear, values such as accountability and integrity. He then talks about how this spill was described as negligible, despite seeing dead dolphins, dead sea snakes. Later on goes on to say, we hoped that maybe the situation would be rectified. Instead, the company doubled down. Instead, when news of the dolphin deaths became public last year, Santos denied any connection. It said these sightings were a couple of hours after the incident, in which time no harm would have resulted from the incident. But he notes that despite tens of thousands of litres of oil in the ocean, Santos had not mobilised environmental assessors to the island until a week after the incident. They could not have known the real scale of impact. It was never checked. So you know, I appreciate that NOPSEMA doesn't have jurisdiction over this particular incident, but last time I think there was agreement that this oil spill would have caused negligible environmental impact. I'm just wondering, in light of this information, like does that change the threshold for negligible environmental impact?
Senator, as you say, the matter isn't within our jurisdiction. We're not as familiar with it as we would be if it was in our jurisdiction. So in terms of the images you've provided and dead dolphin, that's the first I've seen those images. And as I say, it relates to a tear in a hose which wasn't under our jurisdiction. So we weren't the investigating party and don't know the details behind it. If any spill causes the death of a dolphin, then that would be of concern to us. And we would act if it was within our jurisdiction, if a situation like that arose.
Okay. And in areas under your jurisdiction, do dolphins die from oil spills? Is that something that happens? Can those two be linked?
I'm not aware of any instance where it has occurred in our jurisdiction, and I don't know whether it died in this instance as a result of the tear or not.
Okay, and so I guess the specific incident is not in your jurisdiction, but more broadly, the whistleblower suggests that Santos's misleading comments point to wider systemic issues with the company, and you do have jurisdiction over a number of Santos's activities. Will NOPSEMA investigate this sort of thing?
We will if it's within our jurisdiction, and we have investigated matters relating to Santos, and we have taken enforcement action where it's been, where we've found breaches to have occurred.
One of the concerns that this whistleblower raises is the sort of...
Oh, sorry, Senator, perhaps if I can just elaborate further there. Your comments at the start referenced an issue with regard to drilling. There was an incident in November of last year for the Noble Tom Prosser facility, which was operating for Santos, and we did take action. We issued a prohibition notice in that case. So there's some evidence to support the claims that we would take action if we found a breach. As I say, it was in regard to Noble, but they were working on a project for Santos.
Okay. I guess the broader issue that is of concern here, and the whistleblower raises it in his statement, is that, to quote, it indicates a belief within Santos that they can operate to avoid public interest through misinformation supported by a cosy relationship with regulators and government. If a company can do this, not investigate a spill and potentially mislead the public as to what's happened, does that not point to larger sort of reform that we need so that there are investigations, so you do have the power to investigate?
Senator, I'd say we do have the powers to investigate, and we do, and where enforcement action is warranted, we take action. There are various actions on the record that we've taken over recent years against Santos, so any suggestion that there might be some sort of cosy relationship between us and Santos, I would refute, and I think the company would refute as well.
Okay. And so what would the process be if this happened in Commonwealth waters?
In the event that it was reported to us by the company or by any party, or we became aware of it, we
Can we just maybe start with, what are the obligations on a company to report this sort of thing to you?
This would be an incident that they would be required to report to us. Pardon?
In what time frame?
Straight away.
Immediately?
Yeah, they'd report to our duty officer. Yeah.
And then? Sorry.
For an incident like this, depends the nature of it, but we would typically, if it's a serious incident, and this appears it might be, we would undertake an inspection. If it's serious enough, we'd undertake it offshore as well as onshore. We'd try and do that straight away so that the staff on the facility are still there. It's easier to undertake the inspection straight away, and the evidence tends to be better then. If further action's required, then the inspection findings would reflect that. And if it's a particularly serious matter, we would consider an investigation with the possibility of a prosecution.
Mm-hmm. And I'm guessing the WA government has a similar process?
I would think so, but I wouldn't want to speak on their behalf.
Okay. And just back to the, I guess, based on these photos, like, would this be considered negligible environmental damage if it was in Commonwealth waters?
We wouldn't consider a dead dolphin to be negligible environmental harm. But as I say, I don't know the background to this matter and whether it's linked to the spill or not.
Mm-hmm. And what are the consequences under your jurisdiction if a company doesn't report this sort of thing?
If they fail to report under the Act, I'll just get Mr Grebe to confirm the details of
There are a range of penalties that could be brought. Infringement notices apply to offences for not reporting, for example, but if they provide false or misleading information, then there may be breaches of the Crimes Act that could be pursued. And depending on the nature of the issue, there are obviously a range of breaches under the legislation. I think we've steered you previously to, Senator. Mm-hmm. It's an offence to prevent the waste or escape of petroleum, for example, and it's prosecution pathways that we could take as well for offences like that.
Thank you very much for your time. Thank you, Chair.
You have concluded.
Thank you.
Thank you, Senator Pocock. Senator Whish-Wilson.
Thanks, Chair. I've got just three brief sets of questions. The first one is a follow-up question to the last estimates when I asked you about the Schlumberger TGS seismic program. You mentioned there was an investigation underway into Schlumberger. Is that investigation still ongoing?
Senator, yes, the investigation's still going.
It's still ongoing, and can you give us an update on when you think it will be wrapped up?
I don't know when it will be wrapped up, Senator, but since you've raised the subject, we're aware that there's been media reports suggesting that the issue that we would be investigating is in regard to unexploded ordinances. And you were asking previously what it was we were investigating.
You weren't able to say.
I can advise you that that is not the matter that is under investigation.
Okay. No, that's fine. I think last time you said, I won't paraphrase you, but you said if you were to tell us, then it might jeopardise other investigations with other companies that might find out what you're up to. But no, I was interested because my friend and ex-colleague Rex Patrick, Transparency Warrior, has, through an FOI request, has received some information from you where you mentioned the investigation was ongoing at the time he received those documents. So I just wanted to get an update on that. But you also mentioned that the documents you've obtained so far are reasonably likely to be used to compile a brief of evidence for submission to the Commonwealth Director of Public Prosecutions. So just two questions on that specifically. The investigation may still be ongoing or not completed, but you've got some kind of indication there that this may be referred to the DPP?
Yes, Senator, if we undertake an investigation, it's with the view to possible prosecution, in which case we would prepare a brief which we'd submit to the DPP, and then they actually make the decision whether or not to proceed with a prosecution. So at the moment we are investigating, and our investigation is with a view to preparing a brief of evidence if we think there's sufficient grounds to pursue a prosecution.
So do you kind of have a similar philosophy to the DPP then, in the sense that you don't begin an investigation unless you think you have enough evidence to get it to the point to give it to the DPP? Or do you investigate anyway?
We'll investigate if we think a matter is serious enough, and during the investigation we'll make a decision whether we think there's sufficient to put together a brief of evidence.
Would all investigations you do be initiated with I suppose, the possibility or the intention of, provided you get information hand it on to the DPP?
It's always a possibility when we undertake an investigation, yes.
A possibility. I'm a bit confused because I got the sense from your earlier statement that was generally why you did it, but now you're saying it's just a possibility.
Well, I mean, an investigation we undertake with a view to a possible prosecution.
So you commit that time and resources when you get to a point where you think it's worthwhile investing in it, and then if it stacks up, you give it to the DPP.
Yeah.
So would it be fair to say that this matter, in its current form, relates to criminal breaches of the Act? If it's assuming the DPP deals with criminal matters?
Yes, Senator, we're considering that possibility.
That would be why you would give it to the DPP?
Yeah, if we think there's reasonable grounds for a prosecution. So.
Okay. Look, I know you won't, and you've got I accept your reason for not explaining what the investigation is. Can you give us some examples of what would be potential breaches of the Act that would constitute a criminal offence?
Oh, well, the sort of things we're prosecuted for before are
that's
fatalities or serious injuries to people, but they could also be for environmental impacts as well. How much detail would you like me to go into, Senator?
Perhaps we can have a private briefing. But would it be fair to say that they're serious matters?
Yes.
Right, yes. Okay. Look, I'll leave the questioning at that for now. But you can't give me any likely time that... Well, actually, in relation to... It might just be a timing issue where ex-Senator Patrick received his FOI on the 20th of January. But we noticed the recent documentation put out around the seismic survey proposal, the Schlumberger TDS Otway Basin 3D proposal is now simply called the TGS Otway Basin proposal. Do you know if why Schlumberger's dropped their name from the latest round of consultation and official documentation?
I'll just check with Mr. Grebe. He may be aware.
No, Senator.
It's got nothing to do with your investigation into them, possibly?
I don't know.
Okay.
No, and I don't know.
It was just a point of interest. I was wondering why that. Because I've got their earlier draft documentation for the consultation versus their current one, and of course, the other thing is they've obviously reduced the size of the proposed area for 3D seismic. At this point, they don't have to come to you for any advice on that. They can just do that based on their own commercial prerogatives or talking to other stakeholders. Do they need to come to you to adjust that?
The answer is probably it depends on where they're at with the approval process, but when they're in the planning stage, a title holder or a proponent's free to vary their activity. It usually happens probably as part of the consultation process and the feedback they get, I suspect. That's before it comes to NOPSEMA. Once it's in the assessment process, changes can arrive because of the issues we identify, and there can be changes made by the proponent or title holder. and it isn't always possible to vary it on your own choice. If there's significant changes in the activity, for example, for a seismic survey, then we require the assessment process to start again because it starts out with a public comment period.
Okay.
And so if the proposal changes substantially, it's not possible to simply vary it during the assessment process.
Okay, so just to be clear then, they're not at that assessment process yet, right? That goes into 2024, is that correct? Or could you update us on that?
I don't have any information now on whether they've told us that, but it's their proponent-driven timeframes in terms of that. Once it comes to us, that's the statutory timeframes do kick in.
Yeah, can I ask, just as a matter of interest, sorry, your name's fallen down there. I'm not sure if one of the Secretariat could help you get it back up. And my eyesight's not that great anymore. Sorry, Cameron. The original proposal for the seismic survey, obviously, while it's been reduced significantly, does interact with two special purpose IUCN 6 marine protected areas, the Zeehan Australian Marine Protected Area and the Nelson Australian Marine Protected Area. How common is it for these 3D seismic programs to occur in marine protected areas?
Senator, there's probably, I can recall, certainly more than a half a dozen or so that I'm familiar with and have seen recently where they do cross over marine protected areas, but only where those marine protected areas are managed in a way that permit multiple use.
Yep.
And petroleum falls under the category of mining. And so not all marine protected areas allow seismic survey activities to occur.
Yeah, so right next door you've got the Murray Australian Marine Protected Area, which is a green zone, which doesn't allow that. And that literally is right on the border of this proposal, but it does go through too. So does that mean they have to, you interact with what departments then to assess?
So we are Parks Australia, and we have a memorandum of understanding with Parks Australia and co-regulate petroleum activities in marine parks. So there's various authorisation processes that are established under the declarations and the management plans for those marine parks, and we work closely with Parks Australia during those assessments. What I was going to add to the answer before actually was that whether or not a seismic survey goes over a marine park, the potential for impacts and risks on the values that are protected by that park have to be considered and demonstrated to be managed in a manner consistent with the management plan for that marine park. And we aren't permitted to accept an environment plan that is inconsistent with that management plan.
So would you, as a matter of interest, given the green zone, the Murray Australian Marine Park, which is an IUCN 2 category, a green zone, so no extractive or fishing activity allowed at all. With a seismic survey, a 3D seismic survey, obviously we had a Senate inquiry into this. These noises are very loud and can travel a long way. Will you consider impacts? How do you consider an impact where this is literally, according to their mapping, is right on the border? How do you assess whether there's going to be any potential ramifications or possible risks for a green zone?
And whether the values occur within or without a marine park, the process is the same. In a sense, the title holder is required to identify the values and sensitivities, evaluate the impacts and risks, and submit evidence in the environment plan that demonstrates that they're managed to acceptable levels. And a LARP, and we can only accept an environment plan where they're met. The overlay of the marine park puts additional constraints on our decision making, and if the activity can't be managed in a manner consistent with the management plan, then we won't accept the environment plan either. So there's, additional considerations that come into play because of the protections provided by the marine park. I'm not familiar with the specific values and sensitivities in there, but they will be a feature of the environmental assessment and decision-making process.
Okay, I'll put some more detailed questions to you on notice. Just one another issue, and thank you for responding to me so quickly. I wrote to you relating to Woodside's aged production assets off Ningaloo Reef, and you responded. It was my letter on the 20th of January 2023. Senator Cox might be able to pronounce.
I knew you were going to do Nanhura. I'll help you out. Nanhura.
Nangura.
Nangura.
Yeah, Nanhura.
The Nangura riser turret mooring. You said to me since 2018, NOPSEMA has had a heightened focus on decommissioning. What do you mean by heightened focus?
Thank you, Senator. In that year, we received an updated statement of expectations from the Minister at the time, requesting NOPSEMA to take a heightened focus in the industry's compliance with its decommissioning obligations, and called out some specific aspects in relation to ensuring that planning was for full removal unless otherwise agreed. We implemented a strategic program to first of all understand the level of compliance currently, and then took action through a series of tiers of compliance and enforcement, which is still ongoing. The compliance strategy and the compliance plan included issuing general directions where there was property and equipment that it turned out weren't in use and they weren't to be used. And
So in your letter, you mentioned in relation to that, you've taken escalating compliance enforcement actions, including issuing of an improvement notice and 2 general directions since 2018. Could you tell us, what does that mean, just in layman's terms? Like, how much? What are we talking about here? Is it a fine, or what do you mean by?
Well, it's not a fine yet. So the enforcements require, and they're established under the Act itself. And so there's a range of compliance enforcement tools that the regulator has. An improvement notice is where there is a significant threat to the environment, or in the case of safety, threat to people, and it requires specific action to be taken by the duty holder, and there's penalties under the Act for failing to take action or taking action that's contrary to an improvement notice.
Okay. Well, following that, you issued in response, NOPSEMA took further compliance monitoring and enforcement action after the company had notified you they had an impaired ability to remove this in a safe and environmentally responsible manner. A general direction was issued on February 2021, which required Woodside to plug and abandon all wells, and another one in December 22 requires them to monitor and status of the RTM and steps to mitigate risks. Why were, if these aren't in operation anymore, why was the general direction issued that these needed to be plugged and abandoned and removed by 31st of December 2024? Why have you given them a couple of years to do this if it's been on the cards since 2018?
And Senator Wilson, thank you for that question. And just before you answer that, I'll just need to share the call in a moment.
Sure.
So if you could think about wrapping up shortly, that would be great. Thank you.
Thank you, Chair. Yeah.
Senator, the enforcement was issued the general direction was issued to ensure there was a specified time frame. Without that, the provisions under the legislation left some uncertainty as to the time frame in which the property equipment and the wells need to be plugged and abandoned. That's the first direction that you mentioned there. And so to ensure there was certainty and an end point in which we could enforce, clearly we stipulated those timeframes. The second direction related to circumstances which has evolved since that direction was issued, and Mr O'Keefe can talk to that.
Thank you. It became apparent that over time the equipment had started to degrade to the point that there was a change in the buoyancy where it floats in the water, and there was a potential risk there that if that continued, then it would represent or could represent a risk to navigation. So we then directed the company to take specific actions there to identify and mitigate those risks there, specifically in relation to the level of monitoring and the level of mitigation that we applied to control those specific risks there.
And what do they do? Put some kind of float underneath it or something? Like, have they done anything?
This equipment is something like 80 metres long and weighs something like 2,500 tonnes. It's made up of a series of compartments and anchored by chains to the seabed. It's a complicated piece of equipment, and I understand that a lot of engineering is taking place to do that. Now, that might seem like a simple solution that we'll all like to do, but this is a long-term project.
I'm not suggesting that, by the way, I just read it. So
They have taken steps that have improved the buoyancy, so they've got 2.8 metres of additional
And they've
draft.
removed some of the weight and chains off it, which is a reasonable step to take to try and reduce the degradation over time.
Well, speaking of reasonable, would it be, the last question, Chair, would it be fair to say they make billions of dollars in profit and they should be able to actually do this? Is that a reasonable expectation?
Yes.
There's a reasonable expectation that this project should be decommissioned in a timely manner and done correctly, yes.
Right, well, I wish I had more time, but I'll hand.
Thank you. I'll go to Senator McDonald and then I'll come to you. Senator McDonald.
Thanks, Chair. Can NOPSEMA provide an update on the status of the environment plans sent for resubmission? I'm following on from my questions earlier.
Right. Yeah. Yes,
Thank
I'll
you,
get Mr. Green to answer that one.
Thank you, Senator. We were after an update on the specific environment plans related to the Barossa project.
Well, in response to a question on notice, NOPSEMA stated as of the 30th of November 2022, there were 3 plans under assessment with NOPSEMA, with the majority up for resubmission. So I'm wanting to find out where that list is up to. Have any not been resubmitted?
Yes, Senator. I don't have the specific number of ones yet to be resubmitted. They're occurring on a daily basis. But certainly a number have been resubmitted, and there have been progress where one environment plan has been accepted. That's for activities in the Otway Basin, for additional wells for an existing production operation for Beach Petroleum. And we have had plans resubmitted that have progressed through past completeness checks and under assessment. We'll have to get you the precise numbers on notice, but they are progressively being resubmitted.
Terrific. So perhaps on notice then, if I could ask how many in total required to be resubmitted, and so now how many have been resubmitted? You've said one has been approved. That should be enough to
certainly
get me where I'm looking for. What feedback has NOPSEMA received throughout this process? Have any concerns been raised with NOPSEMA by title holders as to the future of approval processes?
Yes, Senator, there's been a lot of feedback. As part of the action plan I talked about earlier, we have been engaging with title holders directly and also with the industry peak body APIA on a couple of occasions. The range of feedback relate to those broadening interpretations, I'll call them, that came through the full bench of the Federal Court appeal decision. So the extent that it broadens and widens the capture of persons or organisations' interests, given they're not just restricted of a legal variety. So there's concerns about that taking additional time. And that's part of the reason why not all environment plans, I suspect, have been resubmitted, because the consultation task they're telling us is much larger. We're also hearing concerns about uncertainty in other areas that I think the guidelines assist in steering towards possible solutions in the form of processes that are applied under other legislation to consult and engage with First Nations groups, such as native title legislation, and similarly the court identified those as a possible pathway. And that probably summarises the main concerns. I think
Thank you. What is the average time frame for assessment?
So the assessment process is actually iterative under the regulations, because it requires that if we don't have enough information, we can and are required to request the further information. Also, if we first determine on the first assessment that the plan doesn't demonstrate compliance with the requirements, that we must provide a reasonable opportunity to modify and resubmit. And so the assessment timeframe average depends. Certainly in terms of the statutory timeframes for us to assess and make decisions, the average is below the 30-day period for us to assess and make a decision. think last time was sitting at about 28 days. So those timeframes are what we're able to control. What we can't control is the timeframe that it takes for a title holder to modify and resubmit the environment plan. We don't let that run open-ended, not just because it affects overall statistics on the total timeframe, but the idea is that you're supposed to be using the time to modify and resubmit your environment plan. So we do have a policy where we don't let that run on for more than 12 months. But I would have to take on notice if you wanted to know the exact figure on average for different activity types, how long it was from submission to a final acceptance through those iterative processes. And it does vary depending on the activity type, obviously. But
yes, could you please give me that information? And could you also put next to it your target timeframe for each of those assessment types, please? How many applications, EPs, OPPs, etc., is NOPSEMA currently assessing?
So we aren't assessing any OPPs. That's the easiest one to answer. In terms of EPs, the number depends on which stage of the assessment process it's at. So I think they have been provided before. There was 43 under assessment. There are additional environment plans where they've been submitted, but we've returned them to the title holder because they weren't complete and ready to start. That aren't captured in that number, and we can get you a more precise figure on each of those categories on notice, Senator.
Thank you. Are you adequately resourced to achieve these targets?
Oh, yes. So we...
Senator, we'd always say we could do with more resources, and would welcome it and would look to apply it.
It's your opportunity to say so.
Yes, I can't miss that opportunity.
Sorry, it's a bad line. Sorry, it's a bad line. I missed it.
Oh, it's in the slogan.
I drifted off.
So we've talked through the impact of the recent court decision on consultation requirements. What effect is the decision likely to have on project timeframes?
I probably already answered that by all the detail I maybe played out earlier, and that at least in the preparation stage for environment plans, title holders are reporting that it's taking longer to get the necessary consultation completed. It's too soon to tell because we haven't had more than one go through the assessment process to completion, and it was already under assessment at the time of, had been submitted, and assessed under when the appeal decision was heard. But so there could be certainly additional work if the deficiency was consultation that we identified through our assessment. But it isn't affecting timeframes in terms of our statutory timeframes to assess environment plans and make decisions.
How does the guidance material interact with existing requirements under the native title and cultural heritage regulations?
So the guidelines that we've issued for the consultation of relevant persons is obviously all underneath the requirements under our regulations. But the guidance does assist, and as the federal court did, identify that although it isn't necessarily applying native title legislation, there are processes that are established under those laws or heritage protection laws that provide a pathway where title holders should be able to adopt and engage and consult with First Nations people on understanding matters that relate to their activity, cultural heritage features, and ensure that they have an opportunity to have those views taken into account and ensure that the management of impacts on those is acceptable. So the guidelines do cross over into that territory. And we obviously have regard to, and this features more in our decision-making guidelines, the EPBC Act, because our regulations are endorsed under the EPBC Act under the strategic assessment provisions. So the cultural heritage aspects that come from the EPBC Act are also covered in our guidance as well.
Does NOPSEMA have experience or expertise in assessing cultural heritage, the process, or is that something that is assessed under another department and comes to you as a tick?
No, we're required to make the decision and do the assessment, but we do engage with, from time to time, consultants or other agencies to help inform our assessment of cultural heritage. since the appeal decision, we've taken actions to improve in staff's awareness and understanding. The key aspect here, though, is that given the significant diversity in cultural heritage and communities differing all around Australia, that the importance of understanding the need for consultation to elicit information about cultural heritage values is what we're focused on ensuring occurs. And so we're not making judgments about the values that other people hold. That's for them to express their concerns and expectations on how those values should be protected. And the consultation process requires title holders to demonstrate that responses to those issues raised are addressed appropriately. I guess I'm saying that because we aren't going to be experts or hire experts who understand First Nations people, cultural heritage values and make judgments on them. That's for them.
Thank you. Are NOPSEMA concerned about the consultation requirements impacting other projects like offshore wind, other things that you'll be...
Well, the legislation and the court case, obviously, the regulations apply to offshore petroleum specifically. As I'm not sure if we're here as the offshore infrastructure regulator, but I'm aware that there's legislation being developed to implement under that framework, and it's not yet in place, but we would administer that however it came out. So it's not for me to have a concern. I guess we would apply the law as it stands, and that work is still ongoing for the offshore infrastructure.
Yeah, I wouldn't say we're concerned about it, but we are looking to see whether or not there are implications of the decision on other industries, including offshore wind.
Yeah, okay. Thank you, Chair.
Thank you. Senator Cox.
Thank you, Chair, and welcome. Just going to the judgment or the determination of the Santos case with the Tiwi traditional owners, I just wanted to clarify just a few points, and thanks to Senator McDonald for raising the issue around consultation. Are there any views that you might have in relation to the time frame which it takes for consultation period to occur?
Any views in terms of how quickly they can do it?
Is there a minimum?
Oh, we don't have a particular number or a minimum number of days or months or years. We expect the process will take a significant amount of time. It'll take as long as it takes, in effect, but we do think it needs to be genuine and appropriate level of consultation to meet the requirements of the decision, and that is not something that can be done in a matter of days, for instance.
Great, thank you for clarifying that. And just noting, obviously, that NOPSEMA only see the end part of the plans in relation to this, and not an oversight necessarily of the process, because I know we've talked about this at length, and you're not at liberty to sort of direct people about the processes that they undertake. But is there anything in the current legislation framework that ensures that companies not only comply with the legal requirements, but also do this in a genuine or appropriate and respectful manner that's consistent with the principles of free, prior and informed consent?
Not in terms of securing consent, Senator.
Okay. Excellent. And given this determination now with, particularly around consultation with the Tiwi traditional owners, how has NOPSEMA how are they thinking about assessing consultation processes in the future following this judgment?
Mr. Green, perhaps you can just summarise some of the points you made earlier.
Yeah, I did cover some of this territory earlier, but I think it's a broader question, and so I think the key change and about the appeal decision is ensuring there's a scrutiny of the process that's been established. As you pointed out, the process has already been implemented by the time it comes to us. And although it seemed after the fact, there is actually an ability for us to direct them, but it's only once it's submitted. So it's accurate up to a point, but once the company submits an environment plan, what we're focused on, if the process wasn't good enough and or the actual consultation outcomes aren't good enough, meaning meeting the requirements of the regulations, including allowing sufficient time so that relevant persons can be informed about how they may be affected. If those features aren't present, we do have the power to not approve. In fact, we're required not to. And we can either request further information or find that we're not reasonably satisfied, and I guess that in a form actually is a direction to the title holder to carry out the consultation. It doesn't extend to, of course, the elements of genuine and that behaviour. We aren't there arbitering or mediating.
Yes.
We don't have a function and role to do that. And so we do, and we have had a lot of emphasis on the consultation. The amount of information is very large, so it does take a fair few resources. The information we are required to see by title holders includes a sensitive information part, which includes confidential information that's been exchanged between title holders and relevant persons. And at times when that hasn't been sufficiently documented, for example, we can direct them to go and gather further written information about the concerns of relevant persons.
Okay, great, thank you. If you can just quickly outline for me the response from industry in relation to the determination in this court case. I know that you've held one industry-specific consultation workshop about some of the outcomes, and you're in the development of a document, consultation guideline, is that what it's called? Yep.
Yes, so we carried out an information session, which Senator McDonald asked about earlier, which we announced and explained the guideline that we developed and issued. That was actually open to all stakeholders and not just industry, and we've met twice on 2 occasions now with the at meetings arranged by APIA to discuss the guideline and the decision and the implications of it. And they've raised concerns about the amount of time, the uncertainty about whether they're going to be able to get through the consultation in time to support their approval needs, the ability of stakeholders actually and relevant persons to be able to have enough resources to respond to them, and a range of concerns like that.
What's the general vibe?
Sorry, I should just add from Mr. Grieve mentioned earlier, the consultation hasn't just been with industry through APIA, it's with the companies as well and a broad range of other stakeholders. So he's already on the record as pointing that out, but I thought it's useful just noting it now.
Just to clarify, Mr. Smith, is that including First Nations communities in relation to this?
Yes, it is, yes.
Okay, that's great, thank you.
I'm going to Carnarvon in 2 weeks to meet with...
Oh, lovely.
And Mr. Greaves already held a range of meetings with First Nations groups and as have others, including myself.
Yes, great. I've got one question, Chair, if that's okay. I believe that in the direction that was published on the 13th of January, that I have, it states that NOPSEMA have been conducting short notice visits to Santos facilities. Is this common practice for NOPSEMA to do this, and has there been an investigation as such in the conduct of Santos? Is that what's triggered this?
It's not exceptional for us to conduct short notice inspections. We've done it on multiple occasions with a range of different companies.
Okay.
The matter you're referring to, Mr. O'Keefe, if you want
But
to
my
elaborate anything.
Yeah, is my understanding correct then, Mr. Smith, that there's usually a trigger for this or some sort of indication that there's maybe misconduct or some type of, something being concealed, or is this just a general...
No. Senator, so is that the general direction in relation to the Barossa gas export pipeline?
That what, sorry?
Is it the general direction in relation to the Barossa gas export pipeline you're referring to?
Yes, it is, yeah.
Yes, I can answer that question. I guess we have a series of planned inspections that are programmed over a year,
right.
But it isn't static, and it needs to be dynamic to be able to respond to issues as they arise. In that instance, we determined that it was necessary to conduct an inspection at short notice.
Okay. Is it, and correct me if I'm wrong, but is it because of the issue with Santos and the consultation process with the Barossa gas field, is it the position of the regulator that they would see that, there may be an issue that you need to have regular checks, particularly with one of the title holders that have been part of particular, this has been a pretty high profile case across the industry and now obviously has caused much attention to it. Is this something that, would develop, I suppose, a trust issue and would we, essentially be able to trust someone like Santos to be able to conduct offshore projects across Australia in relation to their behaviour towards traditional owners in this case?
Like I think the inspection, what the best way to explain this probably is we don't. You might not be aware, and some other regulators have. Lots of regulators have different ways that they determine how they go and inspect compliance. We don't just have a random list and cycle through on a static basis. We look at general compliance risk and target the areas where there is most need to ensure there's regulatory oversight. And the factors that drive that vary, and we consider all of them, including compliance history.
Performance, type of activity, range and scope of activities. There's, in fact, in the last year, we've gone through and built compliance teams where we look at things very holistically, and so very much pointing to risk-based, considering a whole range of factors there. And from that, we then determine the timing at which we do inspections, the nature and scope. The reason we struggled a bit to find out which short notice you're talking about is because we actually do quite a lot of them, because they'd be appropriate to something we need to go and have a look at straight away. So we vary our programme based upon the risk, the nature and scale of activity there, and the particular issues at hand.
Great. Thank you for answering that, Mr O'Key. That's it, Chair, from me.
Thank you, Senator Cox. So, a bit of time management. We are a little bit behind, but I understand that both Senator Whish-Wilson and Senator Barbara Pocock have just a couple of questions each.
Just a few quick ones.
Senator Whish-Wilson.
Thanks, Chair. Just to finish off in relation to your letter to me on the RTM, the riser turret mooring, you mentioned NOPSEMA's commenced an investigation into the issues associated with the RTM and potential breaches of the OPGGS Act. Can you elaborate on that?
Well, I can confirm that we're investigating, and as we discussed earlier on another matter, when we undertake an investigation, it's with a view to assessing whether or not there are grounds for a prosecution.
Okay. Potentially to go to the DPP again?
Potentially. But we are not at that stage, Senator, and may never get there.
No, understand. You also mentioned Woodside's proposed revision to the existing environment plan to provide for the removal of the RTM is currently under assessment. What do you mean by revision?
Senator, the environment plan for the facility, there was one in place at the time that the facility started being decommissioned, and it's been revised on a couple of occasions. The regulations require revision in a number of circumstances. I think I talked about this a bit earlier, but maybe you weren't present, where there's significant change in risk, a new stage or of the activity.
So you've compelled that revision essentially
in this instance, we requested the proposed revision.
It's not Woodside coming to say they want to revise their
No, we issued it as an enforcement.
Good.
Because
just wanted to check that. And lastly, you mentioned failure to comply with the direction constitutes an offence under the OPGGS Act.
Yes.
What kind of offence are we talking about, and what kind of fine? I'm just looking at whether this is a cost of doing business for these guys, like paying fines, or whether what kind of liability we're looking at.
The general directions in place both carry penalties of non-compliance if there's criminal penalties applied of 5 years imprisonment or up to $1 million.
For the CEO or for someone involved in, how would you apply a prison sentence to a breach of the Act in this case?
Wilson, is that your final question?
I've got one other after this. That's it. One complete.
Right.
That's done for.
That's obviously officials of a company.
Yeah, it'd depend on the evidence, Senator.
Okay. Just last question. Are you providing any advice to the current government in relation to, Senator Ayres may be able to answer this question, in relation to Petroleum Exploration Permit 11? That's the federal courts now flip back to the joint regulator. Is that you?
Senator, I can answer that. The answer is no, we are not. We haven't received anything from the proponents for us to assess, so there's nothing for us to advise the government on at this point.
But you would be the agency that would be doing that?
If they submitted a document like an environment plan, then we would make the decision as to whether or not it should be approved.
So that's what we're waiting on then, whether they're going to do that or not?
Yes, whether it be an environment plan or safety case or whatever, if they get to that stage.
Just to drill down on this though, have you provided any advice to the government?
Pun intended.
I understand the government asked that the government, to put this correctly, spoke to Asset Energy and the other proponents and agreed to a settlement for it to go back to a new process. Did you provide any advice in relation to that?
No, we haven't been involved.
You haven't
Senator.
been asked to provide any advice?
No.
All right, thank you.
Thank you. Senator Pocock.
A minor for the next.
Oh, excellent.
ANSTO.
Okay. Right, well.
Sorry.
Yes, indeed. Senator Kennedy.
You should invite me up, Senator McDonald. I guess that's been
I thought if I just looked in the other direction.
This has been asked, just fob me off. But just asking about the ramifications of the decision, I think on Barossa and the requirements for extra consultation. Is the interpretation now following that court decision that a proposal or a proposed new development would have to consult with any affected party for a worst case oil spill scenario? So potentially, say, a well in Northern Australia would need to consult with basically the entire coastline of Northern Australia. Is that the ramifications of that court decision?
Mr. Grebe, if you'd like to summarise that one.
Oh, well, potentially, it would. So the consultation requirements following the appeal decision identify that the process to identify relevant persons that title holders must adopt need to consider all of the impacts and risks in the environment plan. And one of the risks, if it does involve drilling, of course, not every activity does involve the potential for unplanned releases of hydrocarbons. And so that information about that risk in the court's determination should be used to inform that.
So there's a lot of small towns all around Northern Australia. They have to go to each town or provide a direct mail, or what do they need to do to meet the requirements? Yeah.
Well, there's different processes that could be used to ensure that there's an opportunity for persons who believe they may be affected to be able to be consulted. I noticed last week, for example, there's an advertisement by a company in a couple of newspapers inviting people to identify themselves. Is the newspaper
advertisement enough?
I think it's important to be part of the process. I think there's obviously a need for a title holder to ensure that they do some work to identify relevant persons and make the approaches directly, and that's been a practice that's been ongoing since we've administered the requirements. But
you can't give me, or by extension any investor in this country, a set list of people that are relevant persons now. You can't say these are the people, these are the communities you need to consult with. They've got to kind of fly blind now.
Well, the regulations aren't prescriptive in that way in terms of a list, other than some relevant person categories like ministers, government departments, and anyone else the title holder deems as relevant. But I think that there are processes, and the court identified there are processes that can be followed to ensure that there's sufficient opportunity for relevant persons to be able to come forward.
Okay, thanks, Chair.
Thank you.
Thank you.
Who lost their livelihoods over the Montara oil spill be a good example.
Thank you, Senator Canavan.
They're not Australian people.
Thank you, Senators. Thank you, Senators.
Well, if they're not.
I believe that is the end of our questions for NOPSEMA. We thank Mr. Smith and representatives for joining us. We're happy to release you. You go with our thanks. Take a very short suspension while we welcome the Australian Nuclear Science and Technology Organisation to the table. With representatives from ANSTO, and we welcome you, Mr. Jenkinson. I see that you've provided us with a written statement. I'm wondering how you would feel in the interests of time of tabling the statement, or would you prefer to speak to it?
It's quite short. I'd quite like to, if I may.
Yes.
Thank you.
If you'd like to speak to it.
Thanks. So thank you, Chair and committee members. It is a privilege to once again address you as the CEO of ANSTO, the Nuclear Science and Technology Organisation. So ANSTO owns and operates landmark national infrastructure that benefits Australia's scientific, business and broader community through the application of nuclear science and technology. As we approach our 70th anniversary of the establishment of the Australian Atomic Energy Commission, which was the forerunner to ANSTO, we continue to play a key role in addressing the big challenges facing Australia today. in health, the environment, advanced manufacturing, defence and national security, to name just a few of the areas in which we work. We are leading Australia in the development of a nuclear-capable workforce and providing nuclear advice, expertise and services to governments, academia, industry and the community. Our sovereign expertise was put on display only a couple of weeks ago when a dedicated team of radiation specialists from ANSTO, working together with our PANZA, Defence and the Western Australia Department of Fire and Emergency Services, successfully detected and retrieved a missing radioactive source that was in the outback of Western Australia. It took just 2 hours into a multiple-day project to locate the missing radioactive source, smaller than a 10-cent piece, along a 1,400 kilometre stretch of highway in remote Western Australia. And I'm sure you all saw the media coverage. The portable radiation detection technology used as an important part of the equipment to locate that source was developed and commercialised at ANSTO and is known as the CORIS 360. ANSTO was able to detect the gamma radiation emitted from the tiny capsule while travelling along in a car at 70 kilometres an hour. ANSTO's capability in this area and many others are the result of our 70 years of experience in nuclear science and technology, and it was a tremendous source of pride for myself and everyone at ANSTO, and it was a testament to the capacity and our ability to commercialise technology we develop. This exercise also demonstrated the capacity and collaboration of ANSTO with agencies including our PANZA and Defence. And finally, I would like to reflect on the capability that exists across ANSTO, our PANZA, also ASNO and ARWA, and more recently, the Nuclear-Powered Submarine Task Force, which positions Australia as an advanced nuclear nation with sophisticated nuclear science and technology expertise to provide benefit to all Australians. I'm joined today by my colleague at the desk, Mr. John Edge, our Chief Operating Officer. Thank you.
Thank you very much, Mr. Jenkinson, and welcome again, and welcome to the team. And of course, I'm sure on behalf of the committee, we all do congratulate you and your team for the work that you've done in recovering that capsule, and I'm sure there'll be more questions about it this evening as well. With that, I'll go to Senator Pocock.
I think some Australians would be surprised to hear your characterisation of Australia as an advanced nuclear nation, but I'll leave that to one side. My question is really relates to a previous answer at an estimates hearing. At estimates in November, ANSTO indicated that if the facility in Kimba for the disposal of intermediate and low-level nuclear waste doesn't go ahead, the production of nuclear medicine may be impacted. This is a serious claim and quite surprising given ANSTO's primary role is to enable Australia's manufacturing and distribution of nuclear medicine. What evidence do you have to support this claim? What modelling, what documentation, what internal or external papers have been developed to underpin a claim, and can they be made available?
So thank you for the question, Senator Pocock. So yes, I remember obviously the question, and the question on notice was around our ability to manage and capacity to manage waste on site at ANSTO should there be a delay to the National Radioactive Waste Management Facility. I think at the time I said it has the potential in the future to affect operations such as the production of nuclear medicines. So at ANSTO we constantly monitor the need for the volumes of waste that we produce. And we are, as you know, an interim storage facility until such time as there is a National Radioactive Waste Management Facility. But we are a finite site. And so ultimately, if it got to the stage where, many, many years into the future, there wasn't a facility, a national waste facility, it would start to impact operations on site. We would, of course, work closely with the regulator to ensure that we could develop more capacity on site until such time that there is a national waste management facility.
So am I to take from your answer, Mr Jenkinson, that there are no analyses, no modelling, no document, no papers which actually underpin the statement that the production of nuclear medicine would be impacted if Kimba does not go ahead?
There's no specific analysis about at what point nuclear medicine production would stop, but there is analysis around when our current waste facilities are full.
And previous answers and documentation suggest that there are decades of such capacity available.
In our current facilities, there are storage up until, depending on the waste stream, up until, for some instances, mid-2030s, some less than that. But we would have to apply for regulatory approval to build additional capacity on site to store additional waste beyond that time.
And such projects could be undertaken.
They could be undertaken.
And they could be undertaken. Thank you. Given the South Australian Government's clear statement and commitment to listening to First Nations people in South Australia and to their commitment that they will not support a waste dump proposal if it's against the wishes of the Bangala people, a stronger commitment one can only guess, given last week's progress in the Parliament of a First Nations voice for all South Australian First Nations people. What contingency plans, given the real risk that this creates to the possibility of a dump in the longer run at Kimba, what contingency plans do you have to produce nuclear medicine and to store it if the facility doesn't go ahead at Kimba?
Well, we continually look at the storage capacity on site, and we, of course, look at the projected time for the National Radioactive Waste Management Facility, and we work closely with ARWA, and if there was to be a delay in that, we would be seeking approval for additional on-site storage until such time as a National Radioactive Waste Management Facility was ready. So we're doing that. It's an iterative process. We do that every year.
So you're constantly looking at possibilities, alternatives,
correct,
new capacity available where the waste is.
To ensure our operations continue.
So that your operation can continue. Thank you. That's a real level of insight that's useful beyond what we heard last time. I wanted to come to ANSTO's 2021-22 annual report, which indicates the intermediate level waste storage facility is at contract stage, with completion due in May 2026. Can you provide an update on the status of this project, including where the contract is expected, when the contract is expected to be awarded or announced?
I may have to take that on notice to come back with the specific dates, but I'm not aware of anything that's meaning that we're not on track, but I'll come back. I'll take that on notice if I may.
Thanks. I look forward to your answer on that, and thank you for your answers today.
Thank you.
Thank you, Senator Pocock. Just looking at who's seeking the call. Senator Canavan.
Thank you, Chair. Thank you, gentlemen. I just wanted to go to, I think, an issue that was canvassed at the last estimates around the development of the CSIRO's Gen Cost report. I believe last time we met, we discussed what interaction you'd had with the CSIRO. I think it was either none or minimal. Could you take us through whether or not you've had, or your officials, your staff have had communication with the CSIRO since the last estimates around the estimates of cost in their Gen Cost reports? Cost of nuclear, I should say.
Thank you. So thank you for the question. Yes, we have communicated with them, and we are engaging with the CSIRO. In fact, we have a follow-up meeting coming next week where we're meeting with them to provide input to the next generation of that report around the nuclear, our nuclear knowledge and nuclear information to that next Gen Cost report. Okay.
And the consultation you've had, the interactions you've had have been constructive, have they, with the CSIRO?
Yeah. Yep, happy that they're progressing and that we'll have an opportunity to provide our information.
It's good to hear. I don't know if you've seen the CSIRO has put out a consultation draft in December for the next iteration. I think comes out about mid-year. In that draft, there's a significant reduction in the cost of small modular reactor technologies. Was that a result of the input that ANSTO has provided to CSIRO, in your view?
I don't know if that's specifically a result of that, because we're continuing to consult with them and provide information as we will next week, but we want to ensure that the best possible information goes into that report.
Great. That meeting you have with them next week, will that cover off on what they're in the draft and some feedback and comments?
We have a copy of that, which is forming the basis of how we're supporting and putting information into that report.
Is there any information you can provide us on your feedback on what's in the draft at this stage?
We need to, I mean, we're taking the information that's available globally. You'll be aware of some licensing changes that have happened in the US regarding SMRs over time.
Right.
Some recent news in Europe about the licensing in Estonia, or potential licensing in Estonia, that we'll put into that, but we're really going to put in the most up-to-date information we can.
Okay, great. Just maybe drilling down to some of the detail here in the previous iteration that was, I think, released in July last year or around mid-time last year, the 2021-22 report, the GenCost report, they had, under the current policy scenario, nuclear technologies costing, I think, around $18,000 a kilowatt for installation. In the new report, that drops in the 2030s to around $8,000 a kilowatt, so a massive reduction in cost of nuclear technologies. Is that consistent with what you think is for a projection of nuclear technologies, to see the potential for large cost reductions of SMR technologies over the next couple of decades?
I think it's very difficult to give you costs on SMR technology. It's a technology that is as yet not deployed, but we'll be providing information into that, which will be looking at the assumptions that are currently made, but it's very difficult to come up with cost estimates at this stage.
Okay. And I also note that the learning rates for nuclear technology in the new report are significantly increased. Indeed, the learning rate in 21-22 was only 3%. Now, under different scenarios, it's either 10 or 20% increase. I suppose, without asking you the specifics, does ANSTO see potential for the use of modular production techniques to lower cost for nuclear technologies over time?
So globally, you look around, there's great interest in small modular reactors, and a number of countries are looking at them as part of their policy into the future. The type of technologies that's used in them eliminates some of the bigger costs you'd see with siting costs, and so therefore it's sensible to think it would potentially bring down the cost of nuclear depending on the jurisdiction it was used in. So I think that's a reasonable assumption. It could be coming down, but that, as with any new technology we see, is it tends to come down the cost curve over time.
Yep. And I'll just read a direct quote here from the GenCost report. This is the 2022-23 consultation draft released in December. The CSIRO say that nuclear SMR is deployed globally in all scenarios. This is in contrast to the 21-22 results, where the technology was not taken up in the current policy scenario. As current policies evolve towards being a higher abatement scenario, with some countries increasing their ambition in their stated policy, this result demonstrates that nuclear SMR can play a greater role. So now we have the CSIRO saying that nuclear technologies will roll out for countries reducing their carbon emissions. Does ANSTO, through your consultations that I know you're involved in with other countries, do you see that conclusion a reasonable one, that countries will start adopting nuclear SMR technologies in the decades ahead?
It would appear that what we're seeing is that across different jurisdictions, some countries, depending on their energy policy and how they're going about it, the SMR suits what they want to do. And so we're seeing a broad interest in it.
Okay, great. Now, just turning away from the CSIRO report, more generally, the developments that are going on overseas. I know there's different companies like GE and Hitachi, General Electric, all, I think Rolls-Royce as well, maybe, I might be getting it wrong, are all involved in SMR technologies. Do you have any advice, or is any one of those companies proceeding down this track faster than others? Are there any important, interesting developments in recent months in the rollout of the technologies?
Look, I may be wrong, but I think there are around 80 designs out there. 80? Around 80. I'll get back to you on the numbers, but there are numbers of them progressing. I mean, we hear about NuScale have just had a sort of a licensing progression in the US, where they're suggesting they might be deploying an SMR in the US around 2030.
Right.
2032. So
what does that mean practically? They'll actually have commissioned a plant in 2030?
Potentially, that's what they're looking to do. So there's different timescales we're seeing. I mean, this is, these are to some degree first-of-a-kind technologies, but based on existing technology. But obviously, as they progress with this, we'll see the technology mature.
That's a really interesting question, a really interesting point. So to what extent are these 80 designs, or some of these 80 designs, actually advancing technologies or simply trying to take, I suppose, the reactors like we have in submarines or smaller nuclear reactors and making them more efficient from a modular perspective? Or are they actually better or more efficient turbines,
looking at
power
both.
generating systems?
I mean, both of those aspects
They're
have been
both.
looked at. Some is taking existing technologies and using it within the small modular reactors. Others will be looking at new materials and new technologies for future generations.
Right. Okay. What about China? Do we have much insight into what Chinese authorities, because all the reporting I see is largely Western or Japanese-based companies, but a Chinese nuclear
My understanding
industry developing these technologies? Do we know much about the developments in China?
And I take that on notice in
Right.
terms of what we know, but my understanding is they're definitely developing that technology.
Okay. Turning away from SMRs, just back to more traditional light water reactors. Countries are still rolling those out, I see. Is there technological developments in those designs as well, or is it just a rollout of a standard design going on?
There currently exists 422 large power reactors globally across 32 countries, and there's anticipated to be an increase over the coming years. I would need to do a bit of work to understand specifically what technologies are being rolled out, because a lot more interest is being shown in the small modular reactors at the moment.
Okay, yeah, that does seem to be the case. So, and that's very much your or ANSTO's focus, is it, on the SMR developments? More so
Our
than
role is to keep across all
All of
developing
it.
technology to provide
Okay.
information to government to make decisions.
Yeah, okay, all right. Well, thank you very much. Thank you, Chair. I'll hand that back. Anyone else?
Thank you, Senator Canavan. I understand Senator Cox has just a couple of questions. Yep.
Thank you. I just wanted to follow up on, I'd asked some previous questions in relation to terms of reference for the National Science Statement, sort of refresh, and the answer I got back was in relation to centring First Nations perspectives on science, technology and innovation. So I just wanted to get a bit of an update on how that's being included in sort of the wider science system as a priority in this review.
I might, if I can, take that question, because I mean, we participate and put input into that, but we're not in control of that document.
Oh, okay. Is there an actual document of an engagement
I thought you
strategy?
were suggesting there might be. I'm not aware of it.
So there's the terms of reference document that I've got here, this one.
Senator Duncan McIntyre, Deputy Secretary, if I may, that's probably a question that can be best answered in the next session where we'll have all of our science staff from the department.
Yeah.
So if you're happy to defer it till that session,
I'm happy to do
we
that.
can
I'm just
discuss it
seeking a
then.
bit of an update, so I can either take it on notice or I can hold it off for the next session. I'm happy to do that. Thanks, Chair.
Thank you, Senator Cox. I know that both Senator McDonald and Senator O'Neill have questions. Who's ready to go? Are you ready to go?
Yes,
Yep.
absolutely.
Senator
Thank
O'Neill.
Well, first of all, can I thank you for your opening statement? And I just want to put on the record how much I think the imagination of Australians and perhaps around the world was captured by the process. Much has been made of the analogy, the needle in the haystack. And having, had the opportunity to travel around Australia with my husband before we even started our family, I know how big Western Australia is. Days and days and days on the road. So this technology that you're talking about, in your opening statements you referred to how significant that is in terms of innovation.
Yes.
I'd like to get the story of how you got engaged, because you mentioned, I think, in your opening statement, Mr Jenkinson, that within just a few hours of your engagement, there was a quick breakthrough in finding the item, the 10-cent piece size nuclear waste. Is that the best way to describe it?
It's a capsule of cesium which is used in a gauge in mining.
Yeah. So it's the capsule. Let's just call it the nuclear capsule.
Yeah.
So can you fill out the information for me?
Sure. And thank you for the question. I mean, we were contacted by colleagues in WA on the Friday evening
So this is how long after it's gone missing?
Look, I think he went missing around the 25th of January, and I'm not going to get my date right, but we got contacted in February on the Friday evening, and therefore the team obviously need to go through a process to be asked to come and join the task force, and our colleagues in our PANZA were asked. They invited us to participate. So during the time that work was being done to get us across to WA, we did some testing on site to make sure that the equipment we had would be able to detect it. So we set up that detection equipment on site in a car. We deployed a source of about the same size somewhere on site, a bit of local hide and seek, I guess. Didn't tell the team where it was. And on the Sunday, they drove around Anstow and they very quickly found that source and were very confident that if the source was close to the road, and when I say close, you know, we were driving down the southbound carriageway. This was found off the northbound carriageway, a number of metres to the side, that we would be able to detect it. And as they drove past the source on site at Anstow, the equipment spiked and they were very confident they'd be able to detect it if it was there. So they deployed on the Monday night, arrived quite late into WA after some delays with all the equipment, and then started on Tuesday morning. And within 2 hours of driving south from the mine site, the equipment reacted in the way you'd want the equipment to react if you're looking for something. And they just turned around, then used a handheld monitor to find the capsule.
So every science teacher around Australia, I'm sure, would have had some session on this in their classroom, whether it, is at year 3 level right through to year 11, because the practical impact of doing good scientific research and the description there of your micro effort at a small experiment before you headed off is also important.
And I would like to say the inventor of the equipment, who was part of the team, stayed at Anstow, was incredibly confident that if it was there, it would be found.
Okay, so Anstow, if you're not a science nerd, we can be proud of Australians' innovation. It's part of our historical sense of ourselves. But this particular person who created this technology, how did that come about?
Gosh, I can actually, the genesis, I remember the individual coming into my office back in about 2012 and saying he had this idea, and he started to explain it to me, and I thought, well, it sounds good. I don't really understand because it was an incredible idea, which he was calling compressed sensing, which is to filter out all the background noise and just sense that what you want to sense and detect what you wanted to detect. And over a number of years of developing that technology through to a prototype about 2 years ago, the technology was developed, and we now have a very sensitive, very accurate gauge which you can put in a room, and it will take a 360-degree sweep of the room, and it will tell you exactly where any radiation source is in the room and what it is. On this occasion, we used it in a slightly different way because we knew exactly what the source was, cesium. So we were tuned to look for that source, and therefore we were able to find it very easily because the detector was tuned to find it.
So what are the further potential applications of this? Now, having captured the imagination of the world with that, because everybody knows Australia's a pretty big country. I haven't spoken to my cousins in Ireland. Usually they're my filtration source. Okay, we heard about, and they tell me about something big that happened in Australia. There was a fair degree of international coverage, I expect.
Yep.
So how does this sort of an event engage you and the opportunities for the distribution of Australian knowledge, our status as an innovative country, and the solution to problems that are real and pressing in the practical sense of the world?
Well, I mean, this is a technology that we are commercialising, and we're already out competing for tenders globally for this equipment, and it has multiple potential uses. It can be used in nuclear medicine facilities to detect whether or not there are any leaks or any potential hotspots, so improving safety in the workplace. It can be used in border security to scan containers coming in to ensure there's nothing in the containers that shouldn't be in the containers. It can be used by first responders, as you saw a couple of weeks ago. So there are multiple applications for a technology such as this that are spanned across just health and safety, nuclear medicine, national security, defence, to name but a few. And so we're delighted that a number of these pieces of equipment have already been sold both nationally and internationally, and the interest has gone up.
I do love the headline of your media release. WA Outback proves no match for Aussie nuclear know-how. Outback proves no match for Australian nuclear know-how. The concept of actually being able to find this in that huge space is really a testament to the great science that you're doing at Anstow.
Thank you. Well, I would like to say there are no days, I think, in my working career where I don't come away from Anstow with immense pride in what the team do. And this is only one example of many inventions, technology and capabilities that we have on site. And it's very easy to enjoy your job when you work with talented people like this.
So I have had the privilege myself of visiting ANSTO and seeing your storage facilities and also the incredibly productive nuclear reactor that you have at Lucas Heights that creates the nuclear medicine we need. But I actually took a second trip down to Melbourne and had a look at the synchrotron. Now, I want to ask a couple of questions about that because, again, Australians should be rightly proud of this, and I think it has a significant role right now at this point when innovation is so vital to us. What's this Australian synchrotron used for? And could you, in layman's terms, sort of explain it so that people who might be listening or read our Hansard get a sense of what it is and what it does?
So it's an intensely bright light source. So if you think about an X-ray being a light source, this is a light source 1 million times brighter than the sun. So we accelerate electrons around a ring. It's a 216-metre ring, and they travel around that ring about 1 million times a second. And then that light source is divided off into what we would call beamlines, and we use different parts of the spectrum to then look at materials. We might look at proteins, we might look at crystals, we might look at different materials. To give an example, during the COVID pandemic, we performed more than 200 experiments on the COVID virus to better understand the structure of the virus so that people could develop vaccines or think about how they could ameliorate symptoms. It's used to support companies doing drug production. It's used to support so many things. I mean, it's very difficult to try and bring it down to one or two things, but it's really about helping us see the unseen. And that's what ANSTO does in so many ways, both at the site at Clayton and the site at Lucas Heights, is we look and measure things at the level that you can't see to better understand the universe we live in and therefore design solutions for very difficult problems.
Just looking at my phone to see if I can find an image of a wonderful researcher that I just met on Friday who described what it was like for him as a young person being introduced to a microscope and being able to see the world in the way that a microscope revealed, and like just his love of that has led him to be an incredible researcher. And he's working at a research facility called Loam, set in Orange, looking at how carbon can be stored better in the earth. Fantastic. But this is like a microscope for people who might not see a synchrotron. It's another way of looking at things that opens it up. Much smaller than what you can see. Yeah. So this is not a common facility, though, around the world. I understand that you've had recent engagement with the University of Singapore. Would you like to speak to what that's doing? How did that come about, and what's the benefits of such partnerships?
There are a number of synchrotrons and light sources around the world, of which Australia has one, and it's a significant piece of scientific infrastructure in Australia in the Southern Hemisphere. And so we're engaging with a number of countries, one of which would be Singapore, and we've signed an MOU with them that allows them beam time to do their science and allows us to collaborate with researchers in Singapore to help and support their work, and therefore we allow them to use beam time, and that has also a very positive commercial result for ANSTO as well.
So do you get anything from the IP that's discerned?
Well, so depending on the way people use the synchrotron, if they pay for use, they can obviously protect their IP, but if it's merit access, then the IP becomes available for all. And so it depends on the way in which they interact with the organisation.
And just if I can, last number question, how many researchers would you say actually engage with the synchrotron facility each year?
So, checking my numbers, I think the synchron's about 4,000 visiting researchers a year, and our neutron scattering facility at Lucas Heights would be around 4,000 to 6,000 a year.
It's a high level of scientific engagement with others from around the world. Thank you very much.
Thank you.
Thank you, Chair.
Thank you, Senator O'Neill, and I understand Senator Canavan has some questions.
Yes, thank you. So I'm just pulling up. I just got a question for the Minister. In light of the updated findings from the CSIRO there, that nuclear technologies will now be, under their projections, will be rolled out, will be cost competitive. I just wanted to understand whether the Minister has been briefed on these findings.
Well, I think what I heard in the discussion was that that work is underway. I didn't hear the conclusion that you've reached.
I can read it out again.
In the context of all of that.
Well, I'm happy to perhaps for the record.
Well, I'd prefer to finish my answer. I don't know why it's such a preoccupation for you, but the government.
Cheap power. It's not that hard. No, you guys aren't focused on the cost of living.
What we're not interested in doing is taking measures that push up the price of power for households
is going to be cheaper.
And business.
CSIRO think this will be cheaper.
There is no question that it would push up the prices of power for households and business. It would require unproven, undeployed, uncommercial technology to be deployed in Cairns or Caloundra, in Townsville or Tweed Heads. It's not a smart investment in the Australian context. Now, I know that you're enthusiastic about investing enormous amounts of public money in uncommercial projects, but the government will not do that.
Well, the Chair, methinks the witness protests too much. The question was very simple. It had nothing to do. I got a rant in response to a very simple question. Has the Minister been consulted on the findings of the CSIRO Gen Cost Report 22-23 consultation draft on nuclear energy costs?
I'll let you know on notice.
That's okay. That was a lot easier. Could have been done the first time. I note that in a media release released on the 11th of July 2022, titled, this is a media release from Chris Bowen and Minister Husich, Minister Bowen and Mr Husich. The media release was titled Renewables Cheapest Source of Electricity. It was a media release about the last Gen Cost report, so obviously the ministers were briefed on the report released in July. They say in this media release, this joint release, and I quote, "The status of nuclear energy has not changed in this year's report. After extensive consultation, it concludes there is no prospect of any domestic nuclear projects this decade, given the technology's commercial immaturity and high cost." I'm just wondering, is there any plans for the ministers to put out an updated media release to inform the Australian public of the new findings of the CSIRO, which are not consistent with that finding expressed in July?
Well, what you'll see is that that there will be, as there are developments. Let me just check. What I can tell you and provide you with more on notice later if it's required is that that Minister Husich and Minister Bowen's officers were briefed on the consultation draft in December 2022. Right. So they'll be considering that report, and I guess look forward to the final copy. Of course, what the government is focused on is technology that can be deployed now at the lowest cost. That will mean that we meet our emissions and cost targets. That's what the government is focused on, and we do that against a backdrop of a decade of policy failure, of 22 failed energy policies, of increasing costs, increasing uncertainty for investors, and that's the backdrop.
I'm happy to give him enough rope. He's very good.
That we're working to.
Look, I just had a look, and is there any reason why the minister hasn't released a media release about the latest CSIRO Gen Cost report? He's been briefed on it. He put a media release out on the last report. Why hasn't the minister put a media release out on this one?
Well, I can only speculate, but ministers probably aren't in the habit of releasing press releases about reports that haven't been finalised.
It seems like your ministers are only releasing information that's convenient to their political arguments, not actually informing the Australian public. I mean, it seems inconsistent here, the approach to the release of CSIRO reports.
Well,
on this topic,
as I
please?
said, we look forward to receiving the final report.
Okay. Thank you, Chair.
Thank you, Senator Canavan, and thank you very much to the representatives of ANSTO, Mr Jenkinson and your team. Thanks for answering our questions. We release you with our thanks.
Chair, can I just put on the record the name of that researcher that I mentioned?
Oh,
I'm
indeed.
sure that he'd be very, very honoured to be recorded in hand. Along with Mr G, I met with Dr Niraj Purushottam and one of the founders of the Loam Bio, Tegan Nock. Great scientific research going on in regional New South Wales. I'm very proud of what they're doing there.
Thank you, Senator O'Neill. Duly recorded in the Hansard. Thank you again, Mr Jenkinson and team. Thank you. The committee will welcome to the table representatives from the Department of Industry, Science and Resources Program 1.1, Investing in Science, Technology and Commercialisation. Just for the benefit of senators, we'll welcome these witnesses, and we do also have IP Australia scheduled to be with us before 7, and there's some hope that we may be able to ask questions of both sets of witnesses before 7 o'clock.
I'm so sorry, Chair. I was distracted.
No,
Thank
no,
you.
I haven't called you yet.
Oh.
Not yet. And
Did you say something?
I didn't call you.
Well, I'm calling.
Welcome back, Secretary Quinn. Long time no see. Are you and the program ready for questions in program 1.1?
Yes, we are.
Senator McDonald.
Thank you very much. My question is, and I'm just confirming, program 1.1. Does Senator O'Neill have a question? Well, I thought I had 1.1 out, but I...
And through my extensive consultations, that Senator Bragg does have some questions in this.
And I do as well. I'm just making sure that they are... Here we go. Sorry. Apologies. This morning, I started asking questions about the Women in STEM program. Am I at the correct place and time now?
Yes, you are. You asked about boosting STEM, and there's sort of two different programs that could be. So if you could clarify, we'll make sure we've got the right person at the table.
Thank you. So it's boosting women in STEM program.
Okay. Fire away.
Oh, thank you. According to business.gov.au, a grant up to $41.2 million has been available to boost the next generation of women in STEM. Can you allocate that the whole $41.2 million has been allocated to the Australian Academy of Technological Sciences and Engineering to fund their Elevate Boosting Women in STEM program?
Yes.
How are you?
Thank you for the question, Senator. My name is Siobhan Campbell and I'm the Acting General Manager for Science Policies. So can I clarify the question there, the allocation for the funding?
That's correct, and that the whole amount was allocated to the Australian Academy of Technological Sciences and Engineering.
That's correct. So there is $41.2 million of funding allocated from financial year 2021 to 22 through to 2027 to 28.
Has ATSE provided detailed costings, project proposals and plans to the department?
Yes, I don't have the details of those with me, so if there is a specific question to that, I might need to take it on notice, but we work closely on monitoring that program.
Terrific. The ATSE website said applications opened on the 29th of July 2022 and closed on the 1st of October 2022. When was the money made available? Was that in the which budget was that?
I don't have that. So the funding started in financial year 2021 to 22. In regards to when that was, in what budget that was, don't have it in front of me.
Senator Janine Richardson, the Head of Division for Science, so it was in the budget last year, 2022.
The first one,
March.
Is it March? Right, March budget, under the Coalition. Right. Terrific. So, applications open on the 29th of July, closed on the 1st of October. Have any scholarships been allocated yet?
Again, don't have the specifics of that, but yes, those, my understanding is they have been allocated and they have commenced this year. They were scholarships for 2023.
Terrific. I was going to ask you, when will they start to be allocated? And they've been announced then, obviously, otherwise the students wouldn't be studying. Are the scholarships broken down by state or by metropolitan region or regional metric?
So there's 3 groups for those scholarships. The first is undergraduate study, the second is postgraduate study, and the third is leadership. So women that have already studied in the STEM field, progressing into a leadership study. In regards to the geographical spread, that's reflective of the application. So I don't have the specifics of the geographical spread or location in front of me, but they are awarded in reflection to the applications from those specific regional areas.
Okay. Well, on notice, would you be able to provide me some information on where those applicants, the successful applicants, came from, please?
Yeah, certainly can.
How will performance be for the program be monitored and or reviewed?
So for this funding is awarded under a granting agreement, and part of that is there is project milestones and reporting. That sits under our grant agreement and is monitored as such. They have milestones to meet. We also, because this is a longer term project, work with ATSI on the delivery of this program. I attended a meeting recently on their progress against the commencement of this year. So it is a piece of work that we are closely involved in.
Terrific. What does the department consider a successful return on the investment?
I can provide more specifics to that around the milestones and what is required to be delivered. But over the 6 years of the program, there'll be 500 scholarships awarded. Mm-hmm. So part of that would be reporting on how many applicants they receive, how many scholarships are awarded per delivery years would be kind of...
That will be success.
Yeah.
What about success of the students? Graduation, they be success milestones as well?
I can only talk to in the delivery of programs, but that is, of course, something that we'll be looking for, but the specifics of this project we could provide to you.
That will be terrific. I recently visited the Sustainable Minerals Institute in Brisbane and was disheartened to discover that of all the PhD students, only one was Australian. The rest came from overseas. And as I asked each one, how did you end up in this career, in this role, they described that they had to do STEM as part of their high school, whereas I know that in Australia so many young people are choosing not to do STEM. Either they think it's too hard or, for whatever other reason. So I congratulate you. I think it's a terrific program and I look forward to updates on how it's rolling out.
Fantastic. Thank you, Senator.
Thank you.
Thank you. Senator Bragg.
Thanks very much. How are you?
Good.
It's good. Good.
That was an easy question.
Can I... Now...
Nobody asked
Led to furious debate.
Now, I can't ask you
Is
about...
that really the truth?
Can I ask you about the National Robotics Strategy?
Senator, yes, we'll get it's Duncan McIntyre, Deputy
how are
Secretary.
You? Yep, good.
You can start with me and
okay.
The other relevant staff.
But no, I can't ask you about the... what's the other fund that your government's proposing to set up? What's it called? The
National Reconstruction Fund?
That's next, right?
That's correct.
Okay, so this is the robotics.
Yep.
Okay. So you've appointed a council, have you? An advisory committee on this?
That's correct, Senator.
Yeah, who announced that?
Minister Husick's responsible for that committee.
Yeah, so he announced it, did he?
Yes, he did.
Okay. And how many expressions of interest did you have for that?
Senator, I might defer to Anthony Murfitt, who's handled the process of
Yeah,
setting it
okay,
up.
sure.
Thank you, Senator. Anthony Murfitt,
G'day.
Head of Division for Technology and Digital.
Yeah.
So for the Robotics Committee, we consulted extensively around Australia on those nominations we could put forward to the Minister for consideration, but there was no expression of interest process run.
So there's no process to express interest?
Senator, so yeah, no process to run this expression of interest. However, it was extensive consultation across Australia, including WA, Queensland, New South Wales, Victoria, to ensure we looked at the breadth of experience needed to inform the strategy. And I would say, Senator, that in looking at the makeup and the nominations put forward, we looked at a range of criteria from diversity, social inclusion. We know with robotics as well, there's matters around ethics and trust, so ensuring we could put people forward with those skill sets, considering the impact of robotics on workers. So it was a comprehensive discussion around Australia to identify potential nominees.
Okay. So there's an extensive discussion with industry.
So, Senator, it was with industry, it was with academia, it was with a range of stakeholders that could be impacted with robotics. And I guess you'd appreciate, Senator, that with robotics being the opportunity that presents to support a range of sectors, it was important to engage broadly.
I understand it's a sensitive issue, I understand that. But there's no formal process to take expressions of interest. So that means that the department had its own selection matrix or some form of criteria. Is that right?
So, Senator, I'd say, consistent with many appointments and what a department does in providing advice to government, we look at the particular area, in this case robotics. I outlined some of the key themes that we'd seen in some of our preliminary consultation about what we need to think around increasing adoption of robotics. In light of that, we identified the key skills that would be useful and provide insights into thinking about robotics.
Was that a matrix?
There was a matrix prepared, yes.
Okay. Can you supply that?
I can take that on notice, Senator.
Yeah, okay. And did you assess each candidate against that matrix?
So, Senator, I'd say this is going to the matter of providing advice to government. I think I've outlined the process that we followed, which is we engaged extensively across Australia to identify the relevant experts.
Yeah.
We identified the key skills we felt that could provide that advice, and that advice was provided to government.
This committee is an internal advisory committee. It doesn't have an oversight capacity or a decision-making role. It's an advisory committee. It's a matter for the minister who is appointed. It's designed to provide advice to government, ultimately, while there's a process that's been gone through here, and that's a good thing. It's a matter for the minister who's appointed to the committee that provides advice to him.
So it's a committee of the department, though, isn't it?
It's an advisory committee. It's
It's not formally a committee of the department. It's a group of people who are providing advice into a process. I mean, it's not at all uncommon for that to happen for lots of different processes, but it's not formally a decision committee or any governance role in the department.
And how often do they meet with the minister?
So at this stage, Senator, we've convened the nominees and those that are on the committee, believe 3 times. The minister attended one of those meetings, which was on the 13th of December.
So 3 times. Okay. And were there... but was there a list of people that you recommended to the minister?
So, Senator, as part of providing advice to the Minister, yes, there would be a brief prepared with a list of candidates for his consideration.
And all those people that you recommended accepted?
The Minister, that goes to the advice of government. I've outlined the process that we provided. We provided a brief to the Minister, consulted broadly, but it is an advisory committee and for the Minister to decide.
There are people that were rejected?
Minister, I can't answer that. Goes to the advice of government.
So it's probably just, it's highly usual that we provide more names than there are spots on committees. We always apply different options, etc. So it just as a general rule, it's rare if there's three. The target is three, that we would provide three names. We always provide an excess in that sense, depending on the criteria and the makeup, because it depends a little bit on precisely what the Minister's looking for in some roles. So it wouldn't be at all unusual if the selection was smaller than the broader list that's provided for consideration by a decision maker.
Yeah, but were these people interviewed by the department beforehand?
So, Senator, there wasn't a formal interview process as part of this. There was, as I think I've outlined, that we've been out, consulted, we spoke to a range of people, we put forward nominations for the Minister to consider.
Yeah, okay. So what do you think about the idea that, so do people who come onto these committees have to sign any pieces of paper or anything?
Sorry, could you repeat that question?
Do they have to sign any pieces of paper? Do they have to, like, I mean, I know you say it's an informal kind of advisory group, but what do they have to do?
Yeah, so Senator, so from a process perspective, I think we've run through the
nomination.
Nominations are made, Minister appoints people, which is to an advisory committee. Once we know who the appointees are, there's a formal letter that is often written to the candidates. The candidates then confirm or otherwise if they wish to be part of the committee. If they do wish to be part of the committee, then there is a more formal document that sets out essentially the terms of reference and expectations of committee members. In this case, some of the details there is they'd be in place until around the 31st of March of this year. It talks about making sure they abide by conflicts of interest and sets out some of the broad conditions, and as the Minister had said, is providing advice and input onto opportunities for Australia around robotics.
So what exactly, so are there any conduct expectations that these people won't bring this body of work or the department into disrepute?
So I could refer you, Senator, on our website, the terms of reference are there. It's clear on what the expectations are, including the terms of reference, which outline being consistent with the PGPA Act and a range of other areas. I'm happy to provide that on notice.
Yeah, okay. But are there confidential matters that are... I mean, I think the idea of industry consultation is quite a good idea, so I'm not hostile in any way. I'm just trying to understand, would there be...
This isn't an industry consultation group. This is an advisory group.
So you wouldn't use this group to test ideas with?
Oh, yes.
What's the point of it then?
Oh, yes, absolutely you would.
Okay, so it is industry consultation.
But industry consultation's a slightly different exercise.
Yeah, okay, but surely, like, this group is going to be looking at concepts in this robotic space, right? So, otherwise, what else is it going to be doing?
So, Senator, the way I would characterise it is we have an advisory committee has been appointed by the Minister, who is being selected for relevant skills, and I've outlined things from ethics, workers, research and development. So there's a greater pool of diverse views in providing advice on robotics. I would expect that in any development of things such as strategy or what we're going to do with robotics, there will be a broader consultation across industry. But I think the beauty of when we have an advisory committee is there is a sounding board, but of course there is always going to be broader consultation, and its role is outlined in its terms of reference.
Okay, are the members asked to be discreet? Is that part of the obligations when they sign this piece of paper?
Also, we can provide you with, I've mentioned the terms of reference, and there is matters on that. There's a confidentiality clause, which we can provide that on notice, and that would be expectation in any committee, and that as we're testing ideas, there's a level of discretion.
Okay, I mean, I imagine you wouldn't want this committee to bring the department into disrepute. So I just want to ask you about one of these comments made by one of the members of the, what's it called, Task Force Advisory Committee. Mr. Andrew Detmer has said publicly that the opposition leader is Voldemort. What do you think about that?
I'm not aware of the article you're referring to, Senator, and I can't offer an opinion.
Okay. But are you proposing that this committee would be ideally maintaining the good standing of the department?
So Senator, as I said, the Secretary outlined earlier, it's a usual process of government to set up a committee with a range of experts who can provide advice to government. In place here, we've been very clear on what the terms of reference are, what the expectations are, and I'm happy to provide all of that material on notice if that is required.
Okay, well, is there a social media policy?
I have to take that on notice, Senator.
Right, will you look into some of these inflammatory posts? There are others.
Senator, if I may, I mean, when the government appoints such advisory committees, it is our expectation that we want people who bring a variety of different relevant experiences to their role.
Yeah.
It's typically not the case that the government or the department would be seeking to gag the way those people might undertake their broader role. You're correct. It's very important to the department to maintain its reputation, but it is also important to have people from a range of backgrounds who will continue to operate in a range of other roles, and typically we would not place on them onerous obligations which require them to curtail the kinds of comments that they might choose to make on issues unrelated to their involvement in our committees.
So you think it's okay to say that Voldemort thing?
I'm not saying that at all, Senator. That's not what I said at all. What I said is that we expect that members of committee will have a variety of other roles in society outside their participation in the Robotics Committee. If they were making comments about the Robotics Committee, we might have an opinion, but if they're making broader comments that fall outside that role, then it's not really a matter for the department.
It was about 5 minutes ago that I became aware that Mr. Detmer had been appointed to this advisory body. It is an excellent appointment. He is one of Australia's leading contributors on Industry 4.0 and a range of these related questions. I'm not surprised that he's been appointed.
Okay, so you think it's a good idea for people to make comments about other people's appearances, do you?
Well, I don't really have much of a comment to offer on the range of views that people express on industry advisory groups. It doesn't seem to me to be scarcely relevant.
Senator Bragg, can I just do a time check? I know that Senator Cox has a couple of questions for this group, and I'm not sure.
I guess my only other last question about this is
in this group, or
then I'm done with this. It's just really so. I mean, obviously, if you're appointing people into these positions, surely there's got to be some quality control where you can't have members of committees that are providing advice, some sort of privileged advice to government, go out there and say all sorts of kind of crazy things, particularly about people's appearances. I would have thought you would be concerned about the risk to the reputation of the department.
So this is an advisory committee to the government. The minister made the appointments. They have been chosen for their expertise in the area of robotics and what the implications would be for industry, workers and the broader social structure of Australia. So they bring their expertise. That would be our area of focus. As my colleagues have said, people make comments in other course of events, etc. That's outside our jurisdiction. I have no kind of comment on that.
And do these people get paid?
No, Senator.
Okay.
So they're providing their expertise for free.
Thank you, Senator Bragg. Senator Cox, I'm about to go to you with the hope that we can release this program at 7 o'clock. Senator Cox.
I will try exceptionally hard, Chair. Thank you very much. I've got some questions in relation to the Carbon Capture Technologies program.
So
at the next session, I think.
Yeah, so I'm not sure that that's here, because carbon capture is actually a policy responsibility of the Department of Climate Change.
Oh, okay. All right.
In the separation of the MOG carbon capture and storage policy.
My
went to
bad.
them.
I will direct it to them. So, yep. Back to you, Chair. I will redirect that notice.
Oh, okay. Excellent. Thank you very much, Senator Cox. Thank you, Ms Quinn. Thank you everyone who's come to participate in program 1.1, Investing in Science, Technology and Commercialisation. The senators have exhausted their questions for this program and we release you with our thanks and we will return after the dinner break at 8 p.m. with IP Australia.
Okay. Ready, Mark?
Good.
Good evening, everyone. Welcome to Estimates After Dark. The committee welcomes the committee welcomes IP Australia and its representatives. Welcome, Mr. Schwager. Would you like to make any opening statements or just proceed to questions?
Thanks, Chair. Michael Schwager, Director General of IP Australia. No opening statement from us.
Thank you, Mr. Schwager. I know that Senator Cox has questions, so I'll go straight to you, Senator Cox.
Yeah, thank you. One question. It's been identified that the current IP framework provides limited protections for culture, cultural practice, stories and knowledge, and that standalone legislation is a possible solution to this. Is there any standalone legislation currently being worked on in relation to this?
Thank you, Senator, for the question. We are actually looking at options for that and have been looking at options for that for some time, including through the development of a report on options for standalone legislation. That would feed into the government's current commitment to produce standalone legislation for Indigenous knowledge, and we're in the process, as I said, of doing an interim report on that, and I can throw to my colleagues for more information if you would like.
That would be good.
Yeah, Margaret Trevetha, Deputy Director General. So, as part of the National Cultural Policy, one of the commitments is to work on standalone legislation for the protection of traditional knowledge and cultural expression. The Office of the Arts is leading that work together with NIAA, but IP Australia is very much supporting that. You're quite right that traditional current IP frameworks don't deal effectively with traditional knowledge and cultural expression, particularly in the context of community ownership and the ability to sort of manage that collectively rather than on an individual basis, which is sort of how the current system works. So that's one of the sort of key issues. The first sort of stage of this will be to work closely with First Nations people to look at what's the scope of the problem that we're trying to solve here, what matters, what are the key things that we want to address through this process, so we can start to work up something that we can do broader consultation with in the second half of the year.
Is there any thinking about how you might be inclusive, given that we've got 200 plus nations of First Nations people across the country, and the importance of this legislation, as you say, sort of reaching not just artwork, but also the breadth of cultural knowledge and IP that needs to be protected? Is there any of that thinking happening yet?
Yeah, absolutely. We're very conscious of the diversity of issues that we need to look at. Like, yes, it obviously is a concern around art and counterfeit art, but that's just one aspect. There's the cultural stories, there's dance, knowledge related to plants and bush foods, all sorts of issues, and there's questions about sort of protection and respect, but also then use for Indigenous businesses and how that might all play in together. And of course, many people have many different views across the community. So the first step that we're taking is to think about how do we first design a consultation approach which is going to enable us to tap into all of those different perspectives and views so that we can bring something together that can be the subject of sort of further consultation.
Great. Will Australia draw on any of the US or Panama frameworks to inform this legislation? Is that something you've looked at? Really?
So yes, we have looked at those. I think that what's happening internationally is really useful.
Yeah.
They're very different frameworks. So, you know, I think that the US framework is very much, it's a bit old actually. It's sort of focused on craft and arts. Specifically, the framework in Panama is more of that community ownership sort of perspective, so we're very much looking at that. There's issues about, do you have a registered process, or is that actually a barrier? Lots of different aspects coming out of the practice across the globe that we'll be looking at.
Yeah, because essentially there are, you know, whilst the government is sort of in the interim stages, and I appreciate that you're doing, trying to develop a consultation piece around this, but there's many businesses out there marketing themselves as First Nations, and in fact they're marketing themselves to particularly around the products, and so not just, and I'm glad you mentioned not just artwork, but also you know, cultural products that are the use of native botanicals and bush foods, but also cultural items that are not owned and operated by First Nations people themselves, and in fact they're black-cladded in lots of situations. Is there anything being done in the meantime to prevent any of this?
So in the sense of the IP framework, which is really what we look after at IP Australia, as well as the standalone legislation aspect, we are also looking at, do we need to do changes to our existing legislative frameworks, trademarks for example, to better deal with those sorts of issues where people are seeking to use or sort of leverage Indigenous images or words in a way that might be inappropriate, where no consultation or consent is being sought, or it's not associated actually with an Indigenous business at all.
Yeah.
So that's another tranche of our work. Through our Indigenous work plan, we have 6 sort of broad categories, and that is one of those categories.
Yeah, and it's a very a very deep issue, and I think, you know, one that I would like to hear that the government recognise as very deeply hurtful to First Nations people in this country, because essentially it's the stealing or the appropriation of our culture, and it's being appropriated. And if we just picked one element, which is native botanicals, one tea company, for instance, in this country is now looking at a $7 billion economy, which black people in this country don't see any of. And that we are seeing them put a kangaroo on their product, and all of a sudden it's an indigenised product. And it deeply worries me that we are, in fact, in some circles of this government, are promoting that. And I saw that COP27 this year. And we need to actually take action. So I'm glad to hear that you have, and you're doing some of the work, but there needs to be more, and it needs to be quicker, because these companies are developing their international markets, and they're marketing these products as First Nations cultural-based products, and they are in fact not. And so thank you for your work, but I don't know, Minister, if you've got any comment that you'd like to make about that.
Nothing beyond what's been said, except to say, you know, that I can I mean, it's not really for this this committee, but I can tell you that broadly in the discussions in trade discussions with around the world at the moment, there is an increasing level of interest in these sorts of issues. So, First Nations IP. From countries in the region in particular, but also more broadly than that. There's. I'm watching these developments very carefully. I have representations made to me directly by companies that. First Nations-led companies in this space that are doing a lot of pretty interesting work.
Yeah.
And so I mean, you are right to raise the issue from that sort of social justice perspective. There are risks and issues out there, and I think you're pointing to those correctly. There's also enormous opportunity, I'm pleased to hear about the work of IP Australia, but there are other areas of government too that will be engaged in this.
Yeah, and I suppose that one of the easy solutions to that are Indigenous inclusion chapters. So as I take off now to the trade Senate committee, and I've raised this in the trade, treaties committee as well, that Indigenous inclusion chapters would go some way to addressing that. So, if you take that on notice and have some conversations, I'd be appreciative of that. And, I think there's an easy solution. We just have to move along with it. So thank you answering that.
Thanks, Senator. Thank you, Senator Cox, for that was a really interesting, important line of questioning. And Senator O'Neill has some questions as well.
Just to follow up along the lines of the question I followed up after my colleague Senator Stewart asked some questions yesterday around First Nations. The consultation is massively improving. I guess the question is, there is cultural knowledge that is being sought now. It has value. Who is being paid for their cultural knowledge in this engagement rather than just asked to participate? And at what level is Indigenous thought leadership and cultural knowledge being prized at the decision-making level? Because that seems to be a structural problem that we've inherited, and our processes, like the challenge of IP as individuals, right, which some First Nations people might choose as appropriate for what they do, and the community option, a two-path. There will be people who have cultural knowledge that doesn't fit a particular program or model of leadership in structures that we have, but nonetheless they have leadership and elder status. That brings a different set of perspectives. I guess my question is, how much thought has gone into ameliorating those sorts of structural problems in the way that you're proceeding with this work?
Thank you, Senator. We've tried to move fairly carefully and consistently and slowly, taking note and advice from a whole range of different Indigenous people on this. So we've tried to talk to experts, particularly Indigenous IP experts, academic IP experts, practicing lawyers, Indigenous lawyers. We've been talking to people at Garma, people in the land councils. We've been trying to go out into community as much as possible and talk to a range of people. So people who are the owners of stories, people who are the owners either at a family or clan level of Indigenous knowledge, and trying to understand what perspective they might be coming from when it comes to then trying to put in place frameworks and structures to recognise and then protect that Indigenous knowledge that is so complex and integrated with those clan structures. I'm not Indigenous, and so I'm very respectful about listening very carefully to those different experts. What we will do, and what we're hoping to do over the next 6 months, is put a lot of work into formalising our consultation processes through a partnership arrangement. The correct terminology is partnership arrangement, I think.
Yes. So you'll have First Nations people embedded in IP
Totally.
Australia?
As part of the partnership stuff, effectively we'll be working with them. Our own Indigenous staff are very much involved in this, but of course we don't have as many Indigenous staff as we would like, and we're trying to increase that as well.
And I guess at what level they make the decisions. I mean, I just think having a First Nations caucus as a Labor member, the power of those voices in our caucus has changed the whole nature and tenor and quality of the conversation. So I guess I just leave that with that question with you.
Certainly, as we try to build that capability and our own cultural competency, both within the agency and in partnership with Indigenous people, following the examples that are being set up through the Closing the Gap initiatives, we're also engaging specific Indigenous advisory people to help us with this process, and we've had a group of 3 experts particularly help us over the last 12 months on this, and that will continue, and we'll only be escalating that going forward.
As paid consultants?
Pardon, sorry?
As paid consultants?
As paid consultants, those, yes. Yeah.
Thank you, Chair.
Thank you, Senator O'Neill. I don't think other senators had questions beyond that really important line of questioning. So we're actually in a position to release you. We thank you very much for your attendance. Thanks for answering our questions, and you go with our thanks. Thank you.
Thank you, Senator.
Thanks, Senator.
Thank you. See you later.
Thank you.
We'll now be welcoming back the Department of Industry, Science and Resources for Program 1.2, Growing Innovative and Competitive Businesses, Industries and Regions. And will it take a couple of minutes to get everyone? So we'll just have a very quick suspension while that happens. We're good. Welcome back, Secretary Quinn. Nice to see you again. And the committee welcomes representatives from the department for Program 1.2, Growing Innovative and Competitive Businesses, Industries and Regions. I assume you're happy with us to just proceed now straight to questions.
I just have one correction to my colleague's evidence earlier today, just around the Elevate program. Senator McDonald, you asked the timing of the program, and it was May 21 budget, not the March 22 budget. So I just wanted to correct the evidence on that.
Thank you very much.
Hansard.
Thank you very much, Ms. Quinn. And I'm looking to see who would like the call.
I think that's me.
And Senator McDonald.
Thank you. I understand the Office of Supply Chain Resilience has moved from the Department of Prime Minister and Cabinet and into the Department of Industry. Is that correct?
That is correct, yes.
Thank you. And why was this change made?
As part of the post-government, the government did a few rearrangements of responsibilities. There were 3 task forces that came into the department from the Department of Prime Minister and Cabinet. And they reflect all of those that came to the department were very heavily connected to our core purpose. And so supply chains was one of them. We also got responsibility for digital economy and we've got critical technology as well.
What is the resourcing for this office?
Just check.
Deputy Secretary, Industry and Commercialisation Group. Just one of my colleagues to the table. The other piece too, at the point where the Office of Supply Chain Resilience came in, since then with the reorganisation, we've now got a sovereign capability and supply chain division. So those 2 bodies have worked together. I've got some approximate numbers around, or
I'm happy to take that question. Donna Looney, I'm the head of the Sovereign Capability and Supply Chain Division. Where current staffing numbers with OSCAR which is the Office of Supply Chain Resilience. We have a total of 30 ASL. Currently we have 18 on staff, and we're recruiting for additional staff there.
Ms Looney, do you happen to have a nameplate with you?
I'm sorry, I must have dropped it on my way in. My apologies.
No problems.
Somebody else may be masquerading as you. Whereabouts are those 18 staff located?
So the majority of them are based in Canberra, but we do have some staff who are working remotely from other areas within Australia and internationally as well.
Right, whereabouts internationally, out of interest?
We have a staff member who has just located in the UK, and also one who will begin working with us in the Philippines. Sorry, I should say one who works with us but has been relocated to the Philippines.
Is that part of the department? We were talking about this the other night. Is that part of the department's flexible working arrangements or another arrangement?
Well, we have quite a lot of different issues. So we have overseas staff posted. We have some staff that might be temporarily overseas. We do have a flexible work policy that does allow in certain circumstances for people to work in different locations, and a number of staff highly qualified with particular skills. If appropriate security arrangements, they can work from overseas.
Ongoing effects of the pandemic, exacerbated by geopolitical tensions, continues to expose significant vulnerabilities in Australian supply chains, major economic impacts. Can you please outline what critical goods are at risk of disruption?
Tim Wong here, General Manager of the Office of Supply Chain Resilience. The Office of Supply Chain Resilience was set up to undertake the monitoring of supply chains that are at risk and to identify and manage critical vulnerabilities. We use the Productivity Commission's framework that they published in the 2021 report. So using our methodology where we assess criticality and vulnerability, which includes import vulnerability, our import dependence, as well as the degree to which we rely on a particular supplier. We've identified 7 categories of goods, and they're on our website. So the first of these are personal protective equipment. The second of these is pharmaceuticals. The third is agricultural chemicals. The fourth is semiconductors. Fifth is telecommunications equipment. Sixth is water treatment chemicals, and 7 is critical plastics.
So what is the government doing to identify critical agricultural input vulnerabilities?
So, Senator, so what we in the office do is we undertake data analysis to understand what our supply chain vulnerabilities are and what our import dependencies are. Based on our analysis, we would then undertake consultation with relevant industry partners to understand those supply chains and what risks that they face. And then based on that, we'd make an assessment of criticality and vulnerability and provide advice to the government on what risks that the sector might face.
Senator, I might just add to that we do work very closely with the other portfolios within government. While we do the coordination work, often the responsibility for assessing what appropriate measures would be to address issues may be the remit of the related or the relevant portfolio.
What impact is the gas prices having on manufacturing urea and agricultural fertilisers in Australia?
Senator, I think that would be a question for our colleagues in the Department of Agriculture, Fisheries and Forestry.
That wouldn't come under supply chain resilience?
We do look at that, but they would have the information about that specific issue of the gas prices impacting the manufacturers within their sector.
I appreciate the specialisation of the Ag Department, but I was assuming that the Office of Supply Chain Resilience would be across sectors and A little disappointed that it's been pushed off to another department.
So we are engaged with them on the issues. I'm just pointing to the fact that specific references from industry on those issues would be a matter for DAF, for the fertiliser, but my colleague can expand on that.
Because bad news, they referred us to you.
Senator, under the administrative orders, agricultural sector issues do sit with DAF, but we do work with them closely. It's probably worth saying, in answer to your question, high energy costs, which in many ways were driven by the Russia-Ukraine crisis, as well as export controls from China in 2021, did have an impact on urea prices. So that shock does not seem to have persisted. So if I can sort of just read out some stats for you. Over the past 12 months, so this is the year to 10 February 2023, the price of urea has actually fallen by 60%. In the industry engagement that we've done, it does appear that the general consensus is that the situation is easing, and key suppliers are reporting low to no concerns with urea supply.
So, given that Ag has referred me back to you, I'm going to just give you a few questions. If you wouldn't mind going back to Ag and sorting it out, taking these questions on notice and then between the two departments provide that to me. Terrific, thank you. So I've asked you about the impact of gas prices on manufacturing urea and agricultural fertilisers in Australia. You've talked about the 60% fall of urea costs, but if you could talk to if there is a global supply shortage. I want to ask if China still has restrictions on the export of urea. To the best of your knowledge, where or which countries does Australia import its urea from, both agricultural and technical grade urea that, as you know, goes to AdBlue? What is the total consumption of both agricultural and technical grade urea in Australia by metric tonne? And what proportion of our domestic usage or consumption of urea do imports represent? Are there any domestic manufacturers of urea in Australia currently? Can you provide a list of prospective urea projects in Australia? We know about the Perdaman urea project and the New Riser project in South Australia, but for each project, could you please advise the proposed feedstock for urea production, the time frame for the project, the projected output by metric tonne, and can you confirm if the department still has any formal arrangements via contract or grant with Incitec Pivot for the domestic supply of urea for diesel exhaust fluid? That's the end of my questions for that section.
Okay,
Chair?
great. Thank you.
Just note on that last one, we can also contact, but it's our colleagues at the Department of Energy on the diesel component, but we can liaise with them.
If you wouldn't mind, because I do, well, to my mind, that's all supply chain resilience, and so that coordination across departments would be terrific. Thank you.
I'll go to you now, Senator Bragg, or Senator. This was the section you've been here for, Senator Duniam. Yeah.
Questions
Senator
related.
Duniam.
Thank you very much, Chair. On the issue of manufacturing, just with the recent announcement, I think it may have been yesterday or the day before, relating to the Opal white paper plant in Victoria, and attached to that also the issue affecting Parkside Timber Mill in Western Australia. Is that one you're familiar with as well? Well, perhaps not either of you at the table, but the department more generally.
We're certainly aware of the announcement of Opal closure, and
Yes.
I'm not aware of the other mill, but colleagues may be.
Okay, all right. Look, just in broad terms, I just wondered, and I expect it may be largely the same as the answers that my colleague has received, because you are an agency that provides advice, but the portfolio agency, in this case DAF, would be the lead agency, I gather. But what work has been done in response to the situation that's evolved around Parkside in Western Australia, which is a timber mill that uses native timber, and with the impending phase out of native forestry in Western Australia, that mill has decided to shut up shop 2 years early. That will have an impact on manufacturing here, pallets, pellets for wood burners, etc., other products they make, timber, desktops, etc. And what impact will the OPAL decision have on our supply chains and domestic manufacturing?
Deborah Anton, Head of Industry Growth Division. On Parkville, I can't give you any specifics at this stage.
Parkside?
Sorry, Parkside.
Yes.
I don't have some specific information on that. I can say that we have been looking at the situation with Opal, and our colleagues in the office in Oscar who were just up have certainly looked at what that means for the supply of white copy paper in Australia, and they are monitoring that impact. Global supply chains for that item are quite diverse, and we don't expect that Australia would be facing any interruptions to supply on that matter.
Mm-hmm. Will it have any flow-on impacts? Because obviously with the resource that's consumed by a white paper mill, there are other products generated from the fibre of the tree, be they pellets for wood burners or palings for a fence or whatever, who knows. Has there been any analysis done on the impact of those markets? Because if the premium product is the white paper and that market is now gone for the Australian mill, the Opal mill in Maryville that's closed down. Have we done any analysis on those byproducts or other products that come from the fibre of the same tree?
So not specifically. My understanding was not all the operations of that site were closing, that they were going to continue to do some cardboard manufacturing there remaining, but I don't have particular specifics on that.
Okay. Ms Looney, did you have something?
Ms Looney might have something.
So we've not been made aware of any issues regarding sort of byproducts from that facility. We've been in contact with our colleagues at DAF and others, and we can take that on notice if you'd like, and we can get back to you on that.
Yeah, that'd be great. On notice, yes. So any impact on the market for other and manufacturing operations for any other products that came out of the same resource. Just back to Parkside in Western Australia. So the department's not aware of that closure. So that is a native timber mill. The name of the town escapes me, but they relocated there about 2 years ago, and I think there's 80 employees going. The closure was announced last week. Not aware of this one?
No, we at the Office of Supply Chain Resilience, that hasn't been brought to our attention.
Okay. Could you take on notice then, same questions related to that mill, also whether the Department of Agriculture, Fisheries and Forestry has been in touch? The onus is on them, okay, but you don't sit out there waiting and hoovering up information on every sector and every industry. I'm certain that that is not your job, that is the other agency's job. If you could let me know whether they've been in touch about that, I'd be grateful.
Certainly.
Thank you.
Thank you, Senator Duniam. Senator Orman-Payne.
I have some questions about the National Reconstruction Fund. The Minerals Council of Australia, in their submission to the department's consultation on the NRF, has said that carbon capture and storage should be considered as value-adding and low-emission technology. They state, and I quote, "CCUS offers great potential to Australia in terms of enhancing the sustainability of coal and gas industries," end quote, which is another way of saying that carbon capture and storage will expand the coal and gas industry and extend its longevity. What is there to stop the NRF funding going towards CCS projects?
So Narella Keddy, Head of the NRF and Manufacturing Division. So Senator, the government's which has completed extensive consultation in relation to the NRF. We've received about over 230 submissions, 46 virtual face-to-face meetings and various meetings with stakeholders. We're in the process of pulling that information together and providing advice to government, and that'll inform our government deliberations in relation to the investment mandate. So I can't give you a definitive answer in relation to it.
So if I'm understanding it correctly, then unless it's stipulated, for example, in the investment mandate that it can't fund that
it's open to the fund to fund carbon capture and storage?
What I've said to you, Senator, is we are in the process of pulling together the investment mandate and providing advice to government on the investment mandate and also the priority areas declaration. So you're asking me to go to advice that we're providing government, and I can't do that as we're going through our budget deliberations.
No, I haven't said that. I've said, is there anything at the moment in the way the legislation's proposed, the draft bill, to stop?
So the legislation, as you would be aware, Senator, the legislation is framework legislation, so very much based on the CFC legislation. And it points to, and in the explanatory memorandum, it points to the investment mandate and also the priority area declarations, and that's where the further detail will be.
Yeah. So if I'm understanding what you're telling me correctly, is there is the potential for carbon capture and storage to be allowed if it fits within the investment mandate?
It'll be a decision of government, Senator.
What I can tell you is that the sector of the fund that's relevant to the question I think that you're asking, the items that are called out, components for wind turbines, production of batteries and solar panels, new livestock feed to reduce methane emissions, modernising our steel and aluminium manufacturing capabilities, hydrogen electrolysers, innovative packaging solutions to reduce waste. I mean, these are areas of if we're going to achieve our both our objectives to rebuild industry capability in this country, but also to diversify our industrial base, particularly in our regions and outer suburbs, and to reduce our emissions in line with the commitments that we've made domestically and internationally. These are all critical areas for us to be able to achieve those objectives. The reason why the officials have to be circumspect is, there's a consultation process. We've been seeking views, and all views in this area are welcome. But we've been pretty clear as a government and pretty clear prior to being a government what the purpose of this particular fund is going to be.
So do I take from your answer, Minister, that it's not the government's intention to include carbon capture and storage in the investment mandate?
Well, there's a pretty strong track record here of approach to funds like the CEFC, and there have been different views across the Parliament about how a fund like the CEFC should be utilised, and I think one way of measuring what the government's approach to some of these questions is to look at the approach that we've taken to the operation there. But the investment mandate will be the subject of very broad consultation.
I guess our concern is that, this legislation may go beyond this government, and whilst the current minister might not have any intention, unless there's something explicitly there, because there were similar things in the CEFC that prevented some investments that probably wouldn't be regarded as clean technologies. So that's our concern, and that's why we're asking.
Well, these guys are opposed to it, so they're voting against it. One of them couldn't remember the name of the fund earlier on.
I'm not going to go into...
And so if there's a different government, like this task of rebuilding the industrial base in Australia, which involves significant electrification, which involves an enormous opportunity.
Could I maybe ask you to stop there? Only because...
I just want to point out that
I understand the politics of it.
There are a set of risks here.
Yeah, thank you.
And
I'm just conscious
these guys are too ashamed to ask questions because of their position. I'm glad that you're asking questions.
Minister, I have got limited time, and I think...
Well, I haven't heard anything all day. Nothing all day.
Chair,
Minister,
nothing all day.
This is the time.
Minister and Senators, Senator Orman Payne has waited patiently to be able to ask her questions, and she has the call. Senator Orman-Payne.
Thank you. I might go to the next question because I understand the politics of it. I'm just trying to understand what things are in and out potentially and what the legislation can and can't prevent at this point in time. So what would be helpful for me to understand then, and I understand that department can't tell me what's in or out, but what I would like to know is, does the department consider that CCS would come under the remit of a low emissions technology?
So, Senator, what I can say, and to use probably a little bit more detail, is the priority area declaration, which will be a disallowable instrument, will go into that level of detail that you're looking for. It is giving further guidance to the NRF board around investments that they may wish to undertake. And so that level of detail will be, and I would assume it would be under that low emissions technology priority area, under the priority area declaration.
All right, so you're saying that CCS could come within the definition?
If the government made that decision, then it would potentially fall under that low emissions priority area, potentially.
Sorry, can I just clarify a bit further then? Because at the moment, you know, the government's announced some proposed priority areas. It's just a list, you know, broad things like low emissions technologies. Are you saying that those priority areas will be more detailed than that, and there will be a list of things under that heading that say what can be included and what can't?
So the priority area declaration will have greater specificity in terms of where the NRF can invest.
Okay, thank you. That's helpful. So next question, how would the department administer a different priority area or investment mandate under the proposed legislation if a future minister said the LNG industry is a priority area for the NRF investment? Then it's right, isn't it, that the NRFC would then have to invest in LNG, wouldn't it?
So just on the, as my colleague said, the intention is that the priority area declaration is a disallowable instrument.
Yes.
If that was to be changed by a government, it would have to change the instrument. So it would be a matter for
But it could go in there, and that instrument could potentially not be disallowed, and therefore that would be allowable.
So that is the instrument which would provide the guidance of the priority areas, reflecting the will of the government and parliament.
Yeah, so I think what I'm hearing is a yes, it could potentially be used for that as currently proposed if the investment mandate or the priority area allowed that to happen and it wasn't disallowed in the parliament. Great, thank you. Another question, is the NRF intended to support business as usual or low value add activities? It's not in the bill, but it was in the department's consultation discussion paper, and so I'm just wondering why it was taken out.
So the legislation that's before the House is very much framework legislation. The object of the Act is about diversifying the economy and transformation. So the investment mandate and the consultation document that you saw is to inform that investment mandate, and there'll be greater detail in that investment mandate. The NRF is about transformation. It's not about funding business as usual.
Okay, so it wouldn't be for low value add products like paper or crates?
It's about transformation, diversifying the economy.
All right, that's great. Is there any legal requirement, either existing or proposed, for the minister to consult the department on determining the priority areas for the NRF investment?
So the priority areas were the election commitment of the government. So we are in the process of implementing those priority areas. And like I said before, we're doing further work around that priority area declaration, which will be issued as which is a disallowable instrument.
Okay, so technically the minister could just decide, and obviously it would go through cabinet or a process, but could just decide what they are. There's no requirement for consultation.
So the government have been very clear in terms of those priority areas through their election commitment. And
I understand that part. The question I'm asking though is, hypothetically, the minister could, without consultation, just determine what those priority areas are. I think that's what I'm hearing.
We would still have to go through Parliament as a disallowable instrument.
Yeah, noting all of that. All right, terrific.
And the priority areas have their roots in the CSIRO's report from a few years ago about what the, I think it was a report led by David Thodey and others, that identifies key sectors for industrial transformation and for commercialising Australian research.
Yep.
That's where they're derived from. And the evidence that's been given is absolutely correct. Having the priority areas being a disallowable instrument is a very significant instrument to allow. I think it alleviates some of the concerns that you might raise, but it also allows for the future of industrial transformation and scientific development is going to change over time, and this fund is designed to operate essentially in perpetuity as having a continuous capacity to be able to invest in new capabilities. So there will need to be some scope for change.
Senator S, can you, via you, Chair, could you table that report if
So
you've got anything?
you can dig it up on the internet.
No, could you table it, please?
I don't have the report with me, but
Well,
it's a well-known report.
If the Secretary, Mr Raine, you know how this works, if that could be tabled, would be great. I don't appreciate being told to look it up on the internet. If you could table it for the committee, would be good. Thank you very much.
If it can be tabled, it should be tabled, but it's a very well-known foundational report.
Then you should be very happy to table it.
Okay, I'll go back to Senator Orman-Payne, but a request has been made to table a document. What was the document? Sorry, Minister. What was the document, Minister?
I'll just dig up the name of the report because I don't want
Thanks,
to be
consultation.
incorrect.
If you could send that through there, maybe it'd be great, Tim.
Can I ask my next question?
Yeah, it's called the Recovery and Resilience Report. Somebody will dig it up for us in a moment.
Okay, well, if somebody finds it, we can consider tabling it.
I'm sure they're listening. I'm sure they're listening.
Keen ears.
Senator Orman-Payne has a call, although Senator Orman-Payne, I would notice you've gone a fair amount beyond the 10 minutes allocated, so if you could start to conclude, that would be appreciated.
All right. The plan is currently for the National Reconstruction Fund to be able to acquire equity. I'm wondering under what conditions the NRFC would or could take a controlling stake in a company?
All right. So Senator, there's still details that are being worked out as we finalise the investment mandate. So the Act has flexibility around investments, where as we finalise the investment mandate, it will go into further detail and give further guidance to the board.
Okay. I note that the NRF will invest in mainly Australian-owned companies. Interested to know what will be the threshold for mainly Australian-owned. Is there a definition? Is the department working on a definition? And I note that the Australian Chamber of Commerce and Industry think that it should be set at 75% Australian equity ownership.
So the bill currently sets out a definition around Australian-owned and sets that out in the bill. And we'll give further guidance through the investment mandate to the board in terms of the specificity that they might be looking for.
Okay. In terms of mainly Australian-based, is there a definition for that?
I'd have to take that on notice because I think it's in the Act as a definition.
Okay, because I'm thinking about companies, for example, oil and gas companies, producers. They make a big song and dance about being Australian, but we know that they're nearly 95% foreign owned. So just really keen to understand what that definition is. And last question, for clarification, the proposed bill appears to explicitly ban grants, with the exception of states and territories, under the definition of financial accommodation. I just want you to confirm that we have that right.
That's correct, Senator, yes.
All right, thank you.
Thank you, Senator Orman.
I might have one question on notice, if that's right.
Indeed, of course. You indicated, Senator Bragg, that you were ready for the call before.
Sorry, can I just, on the solely or mainly Australian-owned question. The CFC Act has a provision that can't quite say that it's precisely the same, and we'll provide that on notice, but it's essentially modelled on, it says the CFC board will have regard to the following circumstances, conditions and or other matters as relevant when determining whether an investment is solely or mainly Australian based, and it goes on to say where the relevant project will be primarily located, where the relevant project will be primarily used or exploited, where the activity being funded by the investment will be primarily undertaken, where the expenditure for the project will be primarily incurred, and it goes on. I won't take up the committee's time, but there is a definition. It's worth looking at that, but we'll provide you. We'll provide you on notice with the section that's relevant for the CFC, and that's what the corporation definition is.
Thank you. Thanks for that.
Thank you. Senator Bragg.
Thanks very much. What sort of preparations have been done by the department on staffing this proposed reconstruction fund?
So, Senator, in the last budget, the department was funded $50 million over 2 years to stand up the agency. We're in the process. The focus has primarily been around standing up the legislation and the investment mandate. Once we have the bill is passed, we'll start working through the standing up of that agency. We've got some preliminary work already going on at the moment around potential structure and what it might look like.
Yeah, we'll have a CEO.
Yes, it will, Senator.
Or managing director.
At this stage, it's a CEO, as outlined in the bill as well.
A board?
Yes, Senator.
Have you approached anyone to be the CEO of this organisation?
No.
You haven't approached Ahmed Fahor?
No, Senator.
Okay. You sure about that? Yep.
Sorry, I didn't.
I'm just checking you're sure about that? Okay. Is that a yes?
I'm not aware of
okay.
No, Senator. The recruitment hasn't started on the CEO, no.
Hasn't been any informal engagement?
No, Senator.
No.
Not on the CEO.
Not on the CEO or the board, no.
Cool. Now, do you know Minister Husick? Yes, you do, I'm sure. He said that that if the coalition was successful in scuttling this fund, it would put our national security at risk and restrict investment in quantum and critical technologies pledged under the AUKUS agreement. Do you know about these statements in the newspapers on the 14th of February?
Yes, I've read the statements.
You know about them?
Yes, I've read them, yes.
Did you help with them? Did you provide any advice to support that position?
Not that I'm aware of. I'd have taken on notice in terms of the rest of the division.
It's an interesting statement to make. I mean, it's a very inflammatory statement. So, is this a statement that is based on the submissions to the review? To the bill, or what?
So you're asking us for a statement from the minister that
probably best directed to me.
Where did it come from?
Where did what come from?
Well, the statement that.
Well, the statement was made by the minister.
Yeah, and why has he made that statement?
Well, if you lifted your gaze and looked around the world, you would see that there is enormous effort in industrial transformation going on around the world, mobilised not just by economic concerns, but by questions of sovereign capability and industrial capability. You'll have seen in the United States very significant government engagement and investment in industrial transformation for a host of reasons, one of which is absolutely about the future security, industrial capability and sovereign capability of Australia. It goes to our future prosperity and our future security.
Thanks for that.
And it's work that we're engaged in with our partners overseas. There is a relationship between all of these questions.
Yeah, I understand that. It's a significant statement to make, though, when a minister says that the national security be put at risk, isn't it? Is that a big statement for a minister to make?
Well, it is absolutely linked to our future security and prosperity, and undermining this proposition for which the government had a mandate at the election, but which is absolutely related to our future regional and national security undermines national security. I think that's a reasonable proposition to make.
Okay.
And people ought to understand their responsibilities on these questions.
Yeah, no, thanks for that. So did the Department of Defence make a submission to the public consultation?
I'd have to take that on notice. I don't think so, Senator, but I have to take that on notice.
Okay. Because, I mean, if they did, maybe that would be the basis of these inflammatory statements.
It's an utterly unexceptional statement. It's a matter of common sense.
Well, it sounds like the Department of Defence may not have made a submission, so...
It doesn't require a submission from the Department of Defence
but these
to
are the
understand
people that make this. But these are the people that advise
industrial
these matters.
capability is core to our future national security.
Well, last time I looked, the Defence Department made these statements, not the Industry Department. What about the Department of Foreign Affairs and Trade? Did they make a submission?
Not that I'm aware of. But
Okay.
what I can say, Senator, is we do meet. We have an interdepartmental committee that meets whole of government, and we do meet with our colleagues regularly to work on the NRF.
Okay. So has the department sought any advice from Defence or from Foreign Affairs and Trade in relation to this fund and its connection to AUKUS? Apparently there's a connection to AUKUS and national security.
So the department works with, like I said before, the Department of Defence and other departments in relation to the National Reconstruction Fund and establishing it. Remembering that defence is a priority area of the National Reconstruction Fund, and also under enabling capabilities, critical technologies is there as well, which is sort of the conversations we do have with defence, and that's about, you know, the opportunities that exist in those two areas.
Okay, so there have been meetings and there's been advice.
No, we've been working with, like I said, with the Department of Defence and other government agencies on the development of the National Reconstruction Fund.
Has there been meetings?
Like I said before, Senator, we've had interdepartmental committee meetings.
Yeah, how many?
We meet fortnightly.
Okay.
I'll just note that this is a significant government initiative that's also been through a cabinet process, and so through that all the ministers get to provide their views and their equities in the discussion. So there's been quite a large number of discussions in government, and it's gone through a full cabinet process, and there's sort of further to go as part of the decision-making process. So all these, as my colleague has mentioned, there's defence capability, but there's also agriculture, forest and fisheries, transport. So there's quite a lot of areas that require input from other departments and their ministers as well.
Yeah, okay. So the government took the fund to the election, promising to fund how many different priority areas?
7.
7. And are these still the 7 that you're sticking with? Or have those changed?
They're the 7 that the government is sticking with. Yep.
Okay. And what sort of analysis or modelling was done before? Well, I mean, so the then opposition takes these 7 priority areas to the election. They win the election. They stick with these 7. What was the basis of, this is the question for you, Minister, perhaps, what was the basis for the selection of these 7?
What was the basis of the
Labor
Party's election commitment?
Well, this is a hearing into these matters in detail, so I'm wondering what was the modelling or analysis that was undertaken to choose these 7 things, because, you know, usually we say government isn't too good at picking winners, so there must be some methodology behind it.
Well, I can tell you that what's the best way to describe this? Not a minute was wasted during the period that members of the Labor caucus and the broader policy community were engaged over the COVID period and the years surrounding that in opposition. A lot of hard work was done by the Labor leader and his colleagues developing this policy framework, and it was informed in no small part by modern developments in industry policy, and in no small part by the CSIRO report that, of course, is publicly available, but Senator Hughes dragged out of me to be tabled. There is a considerable amount of work done on that. Now, that's not an unusual thing for a party of government that's serious about bringing a constructive agenda, and happened against a backdrop, of course. We've had a crisis in our industrial capability in Australia over the course of the last 30 years. The previous government oversaw 40,000 jobs disappearing offshore when they kicked the auto industry out of the country, where we've drifted down to 91st in the world, 91st in the Harvard Economic Complexity Index. A utterly unsustainable proposition for a country that is going to be relying upon our industrial capability in our region, in economic and security and social cohesion and all sorts of other terms. So we've watched good jobs flowing offshore, and the Labor Party developed a policy framework that is a modern, effective, capable and mobile approach. We took that to the election. It was the subject of a lot of public debate and discussion, and it's a piece of policy work that I think people on the Labor side are very proud of.
Okay, so you made it clear that this is a judgment made by a political party, which is fine, but has the department given any advice on these priority areas as selected by the now government?
So as part of the policy development process, we would have provided information about the priority areas, how important they are for parts of the economy, how they line up on different metrics. There is a fair degree of overlap with the national manufacturing priorities that were used for some of the grant programs that we currently administer. They're not exactly the same, there are different nuances. So as part of that, we would have provided advice on what the contribution to the economy is, how many people are employed, all the usual things you'd expect as part of the policy development process.
Okay, so did you give advice that there were other things that were worth considering that weren't part of this politically driven approach?
So that goes to the precise nature of the advice that we provided, which is not something
Very
we
secretive
usually...
though, isn't it? Very inconvenient for me.
So we don't usually reveal the direct advice that we provide to government of the day.
Well, given the ongoing secrecy, I'll have to abandon my questioning.
Thank you very much, Senator Bragg. I'll just do a quick time check, noting, of course, that we were due to move to our next witness, and I understand that Senator Hughes has some questions. I understand that Senator McDonald has some questions. I'll take the opportunity. Senator O'Neill has some questions. I'm going to move to 5-minute blocks on the basis that we're over time and senators have questions, and see how we go. And I take the opportunity to table CSIRO's COVID-19 Recovery and Resilience report as requested by Senator Hughes, also available on the interweb
as Molly Meldrum used
noted.
to say, do yourself a favour.
Senator Hughes, you have the call.
Thank you so much, Chair, and thank you so much, Senator Ayres, for your tip of how to locate this report. I do notice, though, that you refer to 7 areas of focus. Could you run me through the 7 areas?
So there are renewables and low emission technologies, transport, value add in the agriculture, forestry and fisheries sector, value add in resources, defence capability and enabling capabilities. What happens in the enabling capabilities? Then
Can I just stop you there for a sec? Because that's very different from the industry opportunities in the report that's being referenced. So I was just referred to a report, which I looked up and found as well, thanks to Senator Ayres' tip, and the 6 industry opportunities don't reflect those 7 that you've just said. So where does that disconnect come from?
So I don't have that report in front of me, Senator.
This is Senator Ayres just told you can look it up on the internet. They have 6 industry opportunities. They have digital, energy, food and agribusiness, health, manufacturing, mineral and resources. So, because I know we're short of time now, how did transport now become one of the focus industries? Because according to this report you so kindly referred me to, Senator Ayres, transport was not one of them.
Well, as I said, in very large part, this report and others that are available informed our thinking.
No, you referred me to this specific report, so how did transport now become part of it?
As I said, it in very large part informed our thinking about this approach of identifying sectors that are of critical value for our future in terms of solving key national problems that have been set out here. So this report, amongst other pieces of work, informed our thinking. As I indicated before, there is no time to waste.
Well, you so kindly referred me to this report. What other reports, Minister, were there that brought transport into the fray, or was this a purely political decision?
Well, transport, the transport sector, I mean, honestly, really?
Yeah, I'm really aware of the transport sector, but they are not one of the ones that you're pointed to report was focused on. So you made a big deal about this report, smugly told me to go look it up. I did. Transport's not on here. So how did transport become a priority? All I am asking you is to refer me to the reports where transport is mentioned that you used to make this decision, or acknowledge that there is no report that mentions transport and this is political, one or the other. And we are short of time, Senator Ayres, so I have other things to get to.
I can tell you that one of the things that influenced transport going on to this list of sections, and delighted there's some interest in the Labor Party's policy-making process, but one of the things that informed our view that what we need to do as a country is focus on investments in public transport.
This was not the question. I specifically asked you in time. Excuse me, Chair. In the spirit of time, I am asking what reports were used, and I would ask you to table them.
The way this works is...
Was there one by the Transport Workers Union?
Both Senator Hughes and the Minister, you are, Minister, making the point that I'm about to make, which is that when a question's been asked, we're waiting for the answer. So, Minister, please conclude your answer.
Minutes and he's not answering the question I asked.
And this is running down. This is running down time. So,
so one of the things that influenced our thinking about this is the fact that your colleagues in the New South Wales Liberal government
Chair, point of order.
offshored billions of dollars worth of
billions
of dollars worth
I would
of
ask
public
the Minister
transport
to table all
offshore,
reports that were used,
which
very
cost
kindly brought
thousands
the CSIRO
and thousands of
attention.
jobs.
Minister, I am making a point of order.
And
Minister, I am making a point of order, Chair.
all right, I'll respond to your point of order.
The
You said that
the specific reports that were used to make this decision.
It's
He
not a point
very
of order,
kindly,
Senator Hughes.
I would ask him to answer the
debating point,
question.
it's not a point of
answer
Senator-
the question.
Senator,
We can all run the clock down, and we'll all be here a long time in spillovers.
Well,
So you
Senator-
can make the point that he answers the question, or we can all be
Senator
here
Hughes,
for a spillover.
Senator Hughes, you've asked a question which is about how
It was specifically
how-
what reports were
you
used.
didn't even
That was the
let me. You didn't even let the chair speak, Senator Hughes. So you've asked a question about transport and whether there were reports that underpinned the decision to include transport. The minister has the call. You may not like the answer that the minister gives. The minister has the call.
Well, I can, as I was saying, one of the things that influenced our thinking was the decision of a series of decisions by the New South Wales Liberal government to offshore public transport projects, principally rail projects, but projects in ferries, trams and other projects. And what happened there is thousands and thousands of outer suburban and regional jobs disappeared offshore. Billions of dollars worth of projects disappeared. The projects were delivered late. The projects were delivered at poor quality outcomes. and the projects were delivered over budget. So that's what when I consider what it is,
you were
apart
asked what
from the
reports.
report,
I appreciate you may not
that
know
influenced
what
that.
reports were used. You may need to consult with Minister
It's
Cusick.
difficult. It's difficult
And
to
so
answer while you're being
therefore,
shouted
I'm
over.
prepared to give you this on
It's difficult to
notice
answer when you're being shouted over.
Senator Hughes, you're doing what is known as repetitive questioning. You've asked a question, you're receiving an answer. Well, you may not like the answer that's been given. Do you have another line of questioning?
Oh, I do. So if you could table all the reports, check in with Minister Cusick, he might be able to update you on them. Is the department, we might start with the department, they may be better briefed. Is the department currently contributing to any whole of government work on combating inflationary pressures in the economy? And if so, could you update us on what those details are and what work's happening?
So the main involvement that we've had in terms of direct responsibilities related to inflation has been the work on gas, which we talked about extensively earlier today under our resources priority area. So there we've been working with the government across other sectors to implement a range of policies to put downward pressure on gas prices and therefore into inflation. And I'll just direct you to the Treasury estimates yesterday where they articulated their estimates of what impact the electricity and gas
But
policies.
worryingly, they haven't been asked to do any modelling on the safeguard mechanism. So it's very concerning where Treasury's work is up to. So I'm asking you, have you worked with any other departments, any other industry impacts on the inflationary pressures?
So
Because it won't just be gas.
So priority area has been gas, and I point to the Treasury's analysis that it would take about half a percentage point off inflation through electricity and gas prices. The second area where we're doing work is on supply chains, and in terms of the implication for supply chains on pressures into the Australian economy. We have the Office of Supply Chain Resilience that looks at particular areas and what's happening on the international geostrategic environment and shipping and issues to do with COVID lockdowns in China, etc. So that's another area where we work across government that has an implication for impact on inflation. That would be the two main areas off the top of my head, but I'm happy to take on notice other components which would have an influence on inflation.
Yeah, I'm very interested in particularly if you've done work with DQ and particularly over the cement industry and the use of clinker, particularly clinker manufacturing going offshore to China and then coming back versus it feeding into emissions out of Australia. So I'm happy to put some of that
on notice. It might
on
have come up
notice.
in the supply chain resilience work.
Have any other departments or agencies raised any concerns with you with regards to the NRF and its impact on inflation or potential impacts on inflation?
I'm not aware of any issues at all. I'm aware of positive statements that Secretary Kennedy made yesterday when he was asked this question about whether the NRF would add to inflationary pressures, and I refer you to his evidence, which I concur with, which is that it's about improving the supply side of the economy. It'll be phased over time, and as such, if it does anything, it'll put downward pressure on inflation because it will be building resilience in the Australian industrial base and also adding to productivity.
But I assume...
final couple of questions.
I've got another block, but if I can just finish some of these off, that would be great. I guess, ultimately, have you done any modelling, undertaken, any analysis of the potential inflationary impact?
No, we haven't. But,
why not?
Because it's not necessary.
You don't think in an inflation crisis, cost of living crisis, that there should be some investigation of modelling? I mean, is this just a government that's just walked away from any economic principles, modelling, understanding what's actually going to happen from their decisions?
Well, it's
I mean, seriously, we've got Treasury's done no impact on the safeguard mechanism. We've got no modelling on this. It's like, are we just throwing a pencil at a dartboard and saying where we land?
It's probably worthwhile reviewing the Secretary of Treasury's evidence from yesterday.
Well, it's probably worthwhile you reviewing DQ and a couple of the others.
It does.
Those mortgage holders of Australia.
I don't know what happens in the other committees if you sort of shout over
Chair,
evidence.
I'm happy to leave that there and I'll come back with another block.
So I'll finish my answer if that's okay. It is worthwhile. It is worthwhile reviewing the evidence given yesterday by the Secretary of Treasury because it does speak to and does support that proposition that the Secretary just outlined. Investment.
Senator Hughes.
You've asked a question about the fund. The Secretary just answered the question about the fund. And, you know, investment in productive capability is not generally viewed as being inflationary.
Thank you, Minister. Senator O'Neill.
Thank you very much, Chair. And I hope that we can finish in the way that you asked us today, in an orderly, respectful and courteous manner. These are the new standing orders that are reflected in the opening statements by each of the chairs. I just want to go to the National Battery Strategy, because I know it's captured the imagination of Australia, and Australians are investing in battery technology themselves. So the National Battery Strategy issues paper mentions various other bits of work being undertaken by the government, some of which have been the subject of discussion this evening: the National Reconstruction Fund, Powering Australia Plan, Rewiring the Nation, A Future Made in Australia, and the Critical Mineral Strategy. Could you please provide us with an outline of the work that the department's doing to ensure that these important pieces of work are actually all joined up and moving in the same direction? The leadership that's required to do that and the capacity to integrate. What's happening there?
So, as you said, there are a few strands that go together to create the National Battery Strategy and the NRF and the critical minerals. We do think about integrated holistic advice in this space. Being the Department of Industry, Science and Resources, it covers all of our remit. We have internal processes to align the sequencing of the policies that we're responsible for, and we work with our colleagues across the public service to align the sequencing of their policies so that integrated advice can go before Cabinet. We think of it in a supply chain sense in terms of the critical mineral strategy, which looks at taking things from the resources sector up to the processing and then into the industrial processes side. We have integrated there's a few things happening as well in terms of supporting science and technology research in the middle through CRC programs and the like that are connected to the strategies. The battery strategy and the NRF go together. The NRF is a financing mechanism in terms of co-finance in particular, and the battery strategy is about aligning the different components that you need in the system, particularly across states, to make sure that there's a clarity on what everyone's doing. The Powering Australia component is about the transformation in the electricity sector and the industrial sectors, and they've also got their electric vehicle strategy, which relies on batteries. So most of it's through the craft of the public service of aligning the timing, the sequence, the decision-making, sharing of information, engaging with stakeholders in a coherent way. So we're not asking people to fill in lots of different pieces of paper, so sharing information as we go. And then, of course, there's a cabinet process to integrate that in the government's decision-making.
Sounds very, very complex, but orderly and careful. Is that a fair way to summarise the approach?
So we are working hard to make sure that things are integrated to minimise the disturbance on the system and to maximise the information before government to make the strategic decisions it will make on these strategies and the implementation of the policy programs.
So I do have the National Battery Strategy document here before me, and that's one of the great things about being here in Estimates. You get to look at documents you might not otherwise look at. I was particularly interested in the listing of particular capabilities for each of the states. As a New South Welsh woman, I'm very pleased that we've got priority first on the list. Home to battery minerals, energy storage projects, research and several local battery manufacturers will be boosted by the New South Wales Government's $250 million Renewable Manufacturing Fund. Battery projects are reported in their accelerated New South Wales electricity infrastructure roadmap, including the 850 megawatt and the 1,680 megawatt Waratah super battery. And then it lists all the others. So this sort of sense of competitive federalism to be a part of the process seems to be something that's creating a bit of tension, which can be a very good thing. It's set out in the paper. What's the role of this competitive federalism in terms of the national strategy to get the coordination and harmonise, not just strategically, but practically across the nation to ensure benefit to all?
I'll ask my colleague, Mr Tan, to respond.
Thank you. As you say, working with the states is incredibly important on an issue like batteries. Each of the states are obviously very, very keen to invest in batteries. All of the states have renewables and I guess targets, and are all very interested in batteries. And I think Australia is a relatively small country. It just makes a lot of sense for us to coordinate as closely as we can with the states and territories. So in particular, one of the election commitments that we're working through at the moment is the Australian-made battery precinct with the Queensland Government. And we're working very, very closely with the Queensland Government on implementing that as well. We've had a number of very close conversations with all of the other states as well to identify the different actions that are underway in each of the jurisdictions. And absolutely, we think of this as a national battery strategy, and for us it's absolutely integral that we do reflect the good work that is happening in each of the states and territories.
And not playing one off against the other, trying to find a harmonious way forward for everybody simultaneously, and the value add that comes through that I'm sure is quite significant because it...
And ultimately that's a really important part of us. An important part of why we are developing a national battery strategy is having that coordinated vision of where Australia is trying to head with its battery industry. And working with the states is absolutely critical to that.
Something that governments can do and businesses can't quite achieve, so it's a very significant contribution. A lot of the focus in the listing of capabilities across the states is on natural resources and what lies within, but there's also a degree of smarts that are built into a battery, intellectual capacity, skill development. Can you run me through what those smarts are in addition to the raw materials and how we can really value add with those areas as well?
Yeah, so one of the areas that Australia has a real comparative advantage in is in the research and development that goes into batteries and battery manufacturing. So there's three main centres of excellence around the R&D for batteries here in Australia. So Deakin University has a battery centre which is well known globally and does very impressive work. In WA, there is the Future Batteries CRC, which is also doing fantastic work. And in Queensland, there's the National Battery Testing Centre, which again provides capability across Australia for issues around battery testing, which is a really critical part of being able to manufacture batteries domestically.
Senator, I'll need to reallocate the call, but I know you have another question.
I've got one more.
Yep.
I think Australians actually more and more enamoured of the idea of really having a battery industry and being able to access that technology for themselves and the jobs that they want to create or they want to take up. I think the role, obviously, of helping our green energy transformation is going to be important. What kind of thinking has actually gone in to how we ensure that the battery industry itself doesn't, have an impact that we would be unhappy about? How can we make sure the battery industry is clean and as environmentally friendly as possible?
So that's one of the issues that we sought comment on through the battery strategy issues paper. And in general, when you speak to people in the batteries industry in Australia and with investors, one of the things that is often pointed out as a real strength for Australia is its ESG standards. And to me, it makes good sense for the businesses that are manufacturing batteries or looking to manufacture batteries here in Australia to really focus on some of those ESG standards as one of the areas of recognised strength for Australia.
Thank you.
Thank you, Mr Tan. Thank you, Senator O'Neill. Senator McDonald, I appeal to you as to whether you might be amenable to putting a couple of these questions on notice, but you have the call.
Thank you very much, Chair. And look, I do need to ask these questions, and I'm afraid that some of the answers provided by the Minister has also raised some other questions for me. So
you have the call.
Thank you. Which minister currently oversees major project status? Minister King or Minister Husic? Secretary?
Minister Husic.
How many projects currently have Commonwealth major project status?
Just to clarify, Senator, you're talking about the Major Projects Facilitation Agency? Is that what?
I am asking about Commonwealth major projects. Do you have a, in your growing initiative in competitive business, industries and regions program?
Yeah, my colleagues are just joining.
A late caller, but here.
John Kowaleski, General Manager of Australian Industry Participation and Major Project Facilitation Agency.
Thank you.
There are 25 projects that have major project status. They're on the website.
Thank you. How many projects have lapsed in the last 12 months?
I'll have to take that one on notice, Senator.
Thank you. Could you provide on notice details of when they ceased major project status and why, please?
Yep.
Thank you. How many...
Sorry, Donna Looney here, Head of the Division of Sovereign Capability and Supply Chains. I might just add to that, we can answer your question on notice, but once a period of being deemed a major project and giving that status expires, there is an opportunity for those project proponents to apply again to extend the major project status if it is that they continue to need the support that the facilitation agency provides to them.
Oh, that's great news. Thank you. How many major project status projects are for new projects in oil, gas or carbon capture, use and storage?
Take that one on notice.
Thank you. Could you also provide on notice, I was prepared for that, a breakdown of each project by state and industry or sector? Thank you. How many projects are currently under assessment by the Department for Major Project Status?
I don't have that with me, but I'll take that on notice.
Thank you. Could you please provide brief summaries of these applications when you do that? Thank you. How many projects or proponents have been submitted to the Minister for approval of major project status?
I'll have to take that one on notice as well, Senator.
Thank you. Has the Minister approved all projects that have been submitted to him recommending major project status?
Senator, can I just double check when you refer to the Minister, the current Minister that has responsibility for major project status?
Yes, at the beginning while you were coming in we did confirm that was Minister Husic.
Apologies, thank you.
That's all right, thank you. Yes, you okay?
I am.
Yes. I'd like to know if any projects have been rejected that have gone forward to the Minister, please. Terrific. I just want to go back to this concept, this National Reconstruction Fund and the list of sectors that have been included. Oh, sorry, just before I do, talking about these major projects and investments, Minister, I know that you were insistent earlier about respecting the trust of trading partners and international investors that they've shown in Australia's resources and energy sectors. Are you aware of the Japanese ambassador's comments this evening?
No.
Okay, so he has said within the last hour or so, as Japanese ambassador to Australia, I wish I could say, no worries, mate. But the reality is there is a growing concern, especially on the part of Japanese businesses, So the Japanese government has been conveying those concerns to Australia's friends and colleagues at every level. Minister, what are you going to do to address that concern instead of just dismissing it?
Well, there's a very consistent approach from government. There is, I think, we went through quite some evidence earlier today in the resources section that made it very clear that Australia is a trusted partner.
That's not what our partners are saying, Minister.
That Australian gas and coal is very important in supply chains.
Indeed, it is.
In the region in particular, and that we will continue to be for all sorts of reasons, not just commercial and economic, but all sorts of reasons. A trusted and reliable partner in gas and coal.
Secretary, has the department provided any briefing or advice to the Minister that if the NRF is not passed, this would have a direct impact on the AUKUS agreement?
So I'm happy to take it on notice. I mean, we have provided quite a lot of briefing on different scenarios and NRF design, etc. I'm happy to take that on notice and check.
Okay. Has the department undertaken any independent modelling or analysis which has also independently assessed the priority areas that these are the priority areas for the Australian economy?
So as my colleague mentioned, these were the government's priorities and they've taken it to the election and they've indicated that's the priority areas. We have provided analysis on the implications that would have, the size of the sectors, the number of people employed, the opportunities in that, and we are doing further work in this process. My colleague talked about the priority areas declaration, the investment mandate discussion and consultation. There's also the co-investment plans process, which is around looking at the opportunities and what other regulatory and policy frameworks go together to support the priority areas. So through all of that, there is advice and analysis and verification of the importance of different sectors. So that's what we've been doing.
I just want to specifically ask about the space industry. Have you done any analysis or provided any advice to the why the space industry has not been included?
So we do provide advice to the government on the importance of the space industry and how it connects to other parts of the system, given that a lot of space industries is related to robotics and other technology issues and manufacturing. So we certainly have provided advice on space, and space is one of those enabling technologies, and it also potentially comes under the defence capabilities. So there are elements of space in the priority areas.
So have you done consultation with the sector on how you're going to assist them in moving from being a priority area to not listed as a priority area?
So I'm not sure that we specifically, that's not actually the government's position, so we wouldn't have done consultation on that framing of that question. We've certainly looked at analysis of how important the space industry is and how it integrates with other sectors, just to repeat what I said earlier. And we're working with the space industry in terms of implementing some of the grant programs, etc. So I don't sort of, the framing, as you put it, is not something we would have consulted on because it's not the government's position.
Okay, so, I mean, I've got a list of sectors that, you know, have shared the same concerns about believing that they were a priority previously and now no longer. The recycling industry, complementary medicine manufacturers, you know, I know the chair is looking at me, goodness, there you go, looking at me, keen for me to wrap up, but I might provide a series of questions on notice around priority sectors that are no longer under this government. Thank you. Thank you, Chair.
And of course, many of those sectors would have been engaged in the
that's not-
consultation process.
Yes, thank you. Not a question.
Thank you, Senator McDonald. And I believe that concludes the questions that we have for the Department of Industry, Science and Resources for Program 1.2, Growing Innovative and Competitive Businesses, Industries and Regions. Thank you very much for your attendance and answering our questions. Special shout out to Secretary Quinn for her endurance and answers today. You go with our thanks. We are going to break before CSIRO and come back at 10:45. 10:45. I think we're ready to go, Secretary, if you're ready to go. Yep. The committee resumes and we welcome the Commonwealth Scientific and Industrial Research Organisation and its representatives. Welcome back to Estimates. Thanks so much for bearing with us as we run a little bit late. Welcome, Dr. Marshall. Do you have an opening statement that you would like to table?
Dr. Larry Marshall, Chief Executive, CSIRO. Yes, I do, Chair.
Excellent. We will collect your opening statement. And would you, thank you. So we'll table your opening statement for the benefit of the committee. And would you like to make a few opening remarks before we commence questions?
Oh, thank you very much, Chair. I'll be very brief. Just two things. CSIRO managed to launch our Towards Net Zero mission with about $90 million of mostly funding from industry. It's in partnership with the Queensland Government and the Climate Change Authority and a number of industry partners. But the key focus of the mission is to help Australia reduce the emissions from our most difficult to abate sectors, sectors like steel manufacture, cement manufacture and agriculture. And we've already had our sort of first win in that sector by creating a unique Australian product that's now selling through Europe and the United States that addresses 15% of the entire world's emissions, those from cattle. It's a remarkable example of Australian agriculture and Australian science working together to solve a seemingly impossible problem. And the second one I would to touch on has to do with Alzheimer's disease. And that's Work in Health partnered with Queensland University of Technology, where we used a combination of artificial intelligence and our deep medical knowledge of the human brain to come up with a way to simulate the effects of various diseases in the brain so that the usual technique of assessing the onset of Alzheimer's, which is magnetic resonance imaging, could be better trained to spot the onset of the disease. So two remarkable examples of just some of the work that 5,500 great Australian scientists and researchers do every day to make Australia a better place. And thank you for the opportunity to share that, Senator.
Thank you, Dr. Marshall, and that sounds like absolutely extraordinary work, and I'm sure senators will have more questions to draw out that work and other such examples. I will give the call to Senator Davey, who has some questions. Senator Davey.
Thank you very much, and I'm very pleased to hear you highlight some of the agricultural work you do, including the work with cattle, and in your opening statement identifying the work you've done with cottonseed distributors, which is really important and you know proves to the world that we are world leaders in agricultural production and minimal water use. Which brings me to water. The CSIRO is a partner with the Bureau of Meteorology for the Water Information Research and Development Alliance, WIRADA. It's a partnership that delivers, according to the blurb, the innovation required to improve Australia's water information and make water data more reliable and accessible. Yes. This year, we've seen a lot of issues with the data and reporting, and I questioned the Bureau about it at length the other day with the recent numerous floods and the criticisms that much of the misplaced river and rain gauges or the river and rain gauges that, as I heard from the Bureau, are owned by hundreds of different organisations and have different levels of technology and telemetry and numerous gaps in the information. So how do you assure yourselves that WIRADA and the data being collected for use in your programs is accurate?
It's a great question, Senator. Just briefly, though, we should brief you at some other time on our mission called AquaWatch. It's using space data to actually assess water levels across the country and do a better job of managing and monitoring that. And we'd love to brief you in detail on what we're doing there.
I will take you up on that offer, absolutely, because I did ask the Bureau about whether they were using satellite technology in their monitoring. So I'll take you up on that, but back to WIRADA.
So Senator Peter Mayfield, Executive Director for Environment, Energy and Resources. So in terms of the work that we do in those areas, I guess the CSIRO, we don't, as you said before, we don't operate any of these gauges, but we do use data from that, and we do rely upon groups like BOM to be maintaining those particular measurement devices. As you do each water assessment, one of the things you have to do as you do it is reconciliation of the data and make sure that you're working with the right information. So I'd expect that we are picking that up as we do analyses for our various projects that we do, whether it's for National Water Grid Authority or for other sort of customers. But in terms of specifics of that, I couldn't go into that for you at this stage. I'd have to take that on notice.
Okay. I'm also interested in the Bureau uses the Australian Water Resources Information System. There are far too many acronyms in the water space, but that's AURIS. Did CSIRO contribute to that at all, or is that a completely separate body of work?
So WIRADA's been there in the past for a long time. I haven't been familiar with its activities of late. So again, I'd have to go and take that on notice just to get the update. But we've been doing a lot more integrated water assessment work of late for National Water Grid Authority.
The work you do with the Bureau, is it a fee-for-service arrangement, or how's the funding play out? Who's paying for it?
We tend to work in partnership with them, and they obviously have an operational sort of onus on what they have to do with much of the information, whereas we do studies based on particular questions. So we're coming at a different level. Sometimes we'll do that with BOM personnel, sometimes it'll just involve our own or other third parties, but it depends on what the actual analysis that we're doing is.
And how often are these periodic assessments done?
When you say periodic assessments, can you just
well,
clarify for me?
WIRADA sort of periodically assessed and reconciled? Is it, or?
I would say that as we do each piece of work, that's an integral part of doing an integrated water assessment, is that you have to reconcile your data and make sure that you haven't got erroneous data in there. So I think it's part of every assessment that we do.
Right. So are you doing assessments on an ongoing or a rolling basis, or do you?
No, we're probably doing them more on a when there's a problem commission, whether it's the Murray-Darling Basin Authority or it's Northern Australia, where they want to do things like the Bradfield study. We're doing it on specific studies that have been requested.
That might be a good segue, because I understand you've done work for the National Water Grid Authority.
We have.
Was that using the WIRADA sort of system, or was it? It was more for groundwater, wasn't it?
So we've done a range of projects for the National Water Grid Authority. Probably the most recent piece of work that we did was around the Bradfield schemes, understanding the merits or difficulties with those. And it uses a whole range of different data sources. So WIRADA would be one, but there are multiple sources that we can use. So you want to use as much data as you can.
Is the work you've done for Water Grid Authority publicly reported anywhere? Is there a?
I'd have to check on each report, but obviously the reports are provided to the customer. I believe the Bradfield reports were released.
Yeah.
Yeah. So, we've also done work around the Northern Australia Water Resource Assessment. Those reports were all publicly made available. So the majority of the work should be available, I would expect.
I understand you've done a lot of regional scale groundwater systems reviews or work to look at, and this is predominantly in the Northern Territory and Northwestern Australia. I think there are there about 49 intermediate groundwater systems that you've reviewed?
I don't know if it's 49, but we did some programs around the geological bioregional assessments and bioregional assessments before that. They all involved understanding water and how it was interacting with various systems. And then we also did the work that I mentioned before, which was called NORA, which is the Northern Australia Water Resource Assessments, which are probably the ones that you're referring to. And they were done for 3 major basins, or catchments, I should say.
And Senator, in that one, the team built a machine that actually hangs on the bottom of a helicopter, looks down through the ground and actually detects the water underground, and they actually mapped it. It's quite extraordinary.
Is that like almost a radar version of LiDAR?
It's nuclear magnetic resonance, the technology, but it's essentially finding underground water with a
So we do have a nuclear industry in Australia. Sorry, that was a bit cheeky of me. Got to take every opportunity. And those groundwater reviews, was that looking at trying to establish how much groundwater there is, whether that groundwater would be suitable for irrigation or consumptive purposes? Was any work done to evaluate how much may be available in a sustainable manner to use for consumptive purposes?
In some places, yeah.
So with the NORA work, so I was trying to understand both the below ground and the above ground resources, with trying to determine what is the sustainable available water, and then determine whether there were potential uses of that water, whether it's for agriculture or other applications. So that was the intent of the work.
And my final topic of the night, I understand you're doing some work for the Murray-Darling Basin Authority, looking at the modelling for the basin plan and whether it is still fit for purpose. Is that trying to be as succinct as possible?
So there's some work that's coming up, which is around redoing the sustainable yields for the Murray-Darling Basin, and I guess with this particular iteration, ensuring that we're having an updated look at the climate impacts on that.
So just to clarify though, sustainable yields are completely different to sustainable diversion limits? Is sustainable...
I'm probably using the words a bit loosely there, but I think it is the diversion limits ultimately. Yeah, I'll double check that for you. Just let me check that.
I'll let you take that on notice.
Yep.
So I'll hand over the call.
Yeah.
Thank you. Thank you very much.
Thank you very much.
Thank you, Senator Davey. Senator Rennick.
Thanks, Chair. Hi, guys. How you going?
Well, thanks, Senator. And you?
Good, thanks. Good. Look, I just want to refer to a publication or a figure released by, I'm not sure if Paul Graham still works at the CSIRO or not, but he was the CSIRO's chief energy economist back in 2017, and he said that it would cost Australia a 500 billion to convert Australia to renewables. Now, given that we want to get to 82%, or the Labor Party wants to get to 82% by 2030, do you still stand by those figures, or have they increased since 2017?
So maybe I start off, and I think the work you're referring to there, Senator, is the work with ENA and Energy Networks Australia and the network transition roadmap.
Yeah, technological innovation will drive change in Australia's energy system. Yeah, ECOS, ECOS.
Oh, okay. Oh, so it's different. We've done a few iterations of that.
Yeah, sure you have.
So in terms of that question, we have Mr. Graham is present tonight, so I can invite him to the table if you'd like to talk to him.
Yeah, that'd be great. Thank you.
Paul Graham, Chief Economist, CSIRO Energy Business Unit.
How you going?
Good, thanks. So we've done over the years for a number of different organisations. They've asked us to look at the total investment costs for transforming the energy sector, usually towards some sort of low emission state by 2050. What we find each time we do it, and we do it with the best of knowledge at the time, is that it tends to get a bit cheaper, that number, over time. So when we would have done that work in 2017, we were still probably underestimating the amount of cost reductions that were available to technologies like solar and wind and so forth. So when we redo those numbers now, we might get a lower number.
So what's your number? Or what do you estimate?
We haven't published one in a while.
Right.
Actually the bigger problem we run into now is we've got so many scenarios that have potentially a hydrogen export sector that the number might have gone up in the respect that we're trying to build new industries out of more electricity generation, which means that sector gets bigger, sometimes twice as big as we might have expected in 2017. So the number moves around depending on what you're saying is happening to the future of electricity using
Happens a lot in
industries.
renewables. I know today that Wesfarmers said they had a cost out in their lithium, cost blowout with their lithium mining. So I find that that comment, the costs are coming down, interesting, because in lithium mining, costs are going up. And that's a large part of storage, as you know.
We just published the latest Gen cost, and we found that on average the cost of most technologies has gone up 20% in the last year. So we've recognised that too.
Costs have gone up by 20%.
On average.
In just regards
some
to
technologies
batteries.
by more.
Was that like all renewables or just in regards to batteries?
Across both generation and storage technologies, batteries were one of the technologies that had gone up higher than 20%.
Right, okay. Well, that's quite the rate of inflation. So what, $500 billion, 500 billion, is that still a ballpark figure or trillion or?
It's still a ballpark figure, yes.
Right, 500 billion? Okay, thanks. That's all I need to know
Senator,
with that one.
I think with those, important that you define the scenario that you're costing.
It's modelling, I get it.
So if you don't define that well enough,
I think
the number can move around.
the Chief Executive and I have a very similar opinion when it comes to modelling, so we'll just leave that one at that. Now, there was a study done back in 2013, I believe, that has been pulled off the CSIRO website, but it was on the ABC, it's still on the ABC website, and it said that on average about 2.2 billion tonnes of carbon is taken up by plants each year within Australia. Now, I would have thought if that was the case, that we would be well and truly at net zero now. That sort of uptake.
So, Senator, I'm not sure what particular report that you're referring to, but obviously...
I'm happy to... I'll put it to you on notice as well, so you know.
Yeah.
But it was the lead author was Dr Vanessa Haverd, Havard, of the CSIRO Marine and Atmospheric Research. Yep, she was the... and it was a carbon audit back in 2013.
So, and I think with all... I guess carbon sequestration through land use and changes in land use, that's an ongoing area of close sort of observation to try and understand what's the certifiable sort of reductions you can have there.
Right.
So we have more up-to-date work than 2013.
Is that a ballpark figure?
I'd have to see the context in which that statement was made. I don't...
Right, okay, well, I'll put it to you on notice. But
depends on where you draw your envelope.
Sure, but the current measurement for humans, the Australian people, is that about 500 million tonnes, or are we just below that now?
So currently
emissions?
we're putting at about 485, I think.
485. So even if that was out by a factor of 75%, we'd still be at net zero?
Senator, if it helps, the Department of Energy's data shows that we're down 25% across the board for emissions since 2007.
Since 2007. So the Coalition was in government most of that time, so we've really reduced emissions. Wow.
And that's on the department's website.
We are really good for the environment, aren't we? And my last one is basically, do gases trap convection? Because I find it confusing that we use this greenhouse gas term when a greenhouse is a solid glass object. And I was taught in grade 8 science that basically materials come in three forms: liquid, gas and solid objects. And I didn't know that gases could trap convection in the same way that a greenhouse would trap rising air, cool and then condense. I don't see how gases can do that.
Yeah, so I think we've talked about this before,
Yeah.
Senator, the phenomena of the atmosphere being kind of like a blanket around the Earth.
Yeah, I don't like that description. Does gas trap convection or not?
But we know from temperature measurements going back a very long time that the Earth is about 16 degrees warmer because of the residual greenhouse gases, CO2 mostly.
Or gravity.
In the atmosphere.
Or gravity.
So I'm not sure I understand your point there. Senator.
Well, gravity, anyway, I know you don't think gravity has a part of it, and we'll take that up another day, but that's fine. I just wanted an answer. Does gas trap convection?
Does gas trap convection?
Yeah, well, heat's transmitted in three ways: convection, conduction, radiation.
It's the radiation that gets absorbed. So the Earth radiates heat.
Yep, I understand all that, but that's not the only factor.
Certain molecules absorb infrared better than others. So water vapour absorbs really well, CO2 absorbs really well, methane absorbs really well. So when they absorb the energy, they heat up, and so you warm the
Mr.
atmosphere.
Marshall, it's not the question I asked you. Do gases trap convection?
Senator Rennick, you said that it was your last question. Are you happy for Dr. Marshall?
Well, he's continuing. He's going down the path of radiation.
Okay. We're just at the end of your block, so we'll just let Dr. Marshall finish his answer to your question, and then I'll allocate the call.
So do gases trap convection?
Maybe if I can just try and clarify. So, there's conduction, convection and radiation. They're the three modes of heat transfer.
Yeah.
Convection is heat transfer through the movement of a fluid, whether it's a gas or a liquid.
Yeah.
So convection, or gas doesn't trap it. Moving gas is convection. And then if you look at the Earth, the boundary layer, or the boundary condition you have to put there is the edge of the atmosphere. There is no movement of gas out across that, so radiation is the only way it can happen. That's why we talk about radiation.
Yeah, and it's trapped in the atmosphere by gravity. Thanks. It's all good.
Thank you. Thank you very much, Senator Rennick. Senator Canavan.
Thank you. I've just got a couple of quick questions to start with on the H2 hub at Gladstone. I believe CSIRO is involved in this project. It's a 3 gigawatt electrolyser plant and ammonia. Where will the water, or how much water will it require, and where will that come from?
So, Senator, in terms of is CSIRO directly involved in the project, we may, I don't believe we are, but
it's on your website.
The information comes off our website, which I believe is the High Resource site.
Right.
Which is, it actually captures different projects and information around Australia, but it doesn't.
Right, so you're just
those projects, so we're just reporting
notice board, so to speak.
Sorry?
You're just a notice board.
It's a notice board as part of the knowledge transfer that we're doing as part of our mission.
So, in that knowledge transfer, have you investigated or have any information to share with us about where the water's going to come from?
I don't have information on that specific project as to what they see their water source to be, and each project will have to determine what they want to use as their primary water source.
How much water does a kilogram of hydrogen require made from an electrolyser?
So, theoretically it's around about 9 kilograms, but if you then look at the actual balance of plant that's required around electrolyser, it's probably between 64 and 100 kilograms.
Sorry, 64 and 100 kilograms of water?
Of water, so some of it's for cooling.
So is that, I mean...
So there's the water that goes in, gets converted.
Yeah.
And then there's water in the associated plant.
Normally I'd express water in litres and what have you. Is it 1 kilogram per litre? That's what I remember from school, but what is it? So it is? So is that right, Mr.
1
Marshall?
kilogram a litre, yeah.
Yeah, that's what I thought I remember. So you're saying 64 to 100, was that?
64 and to 100 when you take into account the balance of plant, depending on what technology you're using and how you're doing your cooling and things like that. So it varies.
You could express that as litres instead of kilograms, right? Okay. I'm just asking because there's a lot of people concerned in that region about the lack of water, and if we have these very large hydrogen hubs coming in as promised, where is that water going to come from? We're a pretty dry continent with scarce water resources. Have you I know you're not particularly looking at this project then, or not involved, but have you looked more generally at where are we going to get that water given the demands or desires to make this much hydrogen?
So we're involved in some of the hubs, and those are the sort of questions that they're looking through. And there's a range of sources that they can contemplate. Which one they choose, I don't know. It'll depend on the circumstances. But recycled water, You can do desalination, which is probably not the best choice. You can use ground resources, or you can use potable water, which is probably the least likely source that you would use.
Okay, well that's good to hear, because I'm not sure why we would burn our most important and scarce resource and export it to another country. It's strange that you say that desalination is probably the lowest option, because we just had the Department of Climate Change in a separate inquiry, and they said that increasingly they're looking at desalination. When I raised the potable water issue, they said, oh, well, we'll do desalination, but you don't think that's a good option?
Well, it depends on what the resources are in the particular location that you're looking to do your hydrogen production, and it may influence where you do your production. But, you know, there's a hierarchy in terms of cost that you have to look at.
Because I would have thought the problem, one of the big issues with desalination in Gladstone or Townsville, where there's another hydrogen hub proposed, is where are you going to put all the salt? Are you going to put it all out in the reef? I mean, they do. The people do sort of say, oh, we'll just build a desalination plant. Well, hang on. Where are you going to put all the salt? The Great Barrier Reef's just next door. That's not going to be a good idea.
And these same problems have to be resolved when you're looking at desalination plants for just normal drinking water. Where does the brine go, and how do you dilute that? So I would expect these are all elements that will go through a normal project concept phase to feasibility, and environmental approvals as well.
Cool. There's also a debate here about what's green hydrogen. I realise you might not be the keepers of that taxonomy, but is it generally considered that hydrogen produced from nuclear energy would be considered green?
So I think the common views are that if it's from gas, it's blue.
Yep.
It's from black coal or brown coal, it would be brown or black. Green would be, typically they think about PV or other renewables. If you have zero emission nuclear, I think you could call it green as well.
Great, it's great to hear again. That wasn't the view of the Department of Climate Change, but that's really good to hear. Just speaking of nuclear then, I want to go to the GenCost report, the latest draft. I think you've released a consultation draft in December last year. There does seem to be some changes in regards to your treatment consideration of nuclear. Just quoting from page 39 of the GenCost 22-23 draft, it says here that nuclear SMR is deployed globally in all scenarios. This is in contrast to the 21-22 results, where the technology was not taken up in the current policy scenario. So am I just reading this right, that the new, at least draft, GenCost report indicates that nuclear will be, or is going to be, on your projections, a commercial technology in the decades to come?
So I'll invite Mr Graham to reply to this one in a second, but in terms of where we've got to with GenCost in the last iteration, no new appreciable information for us to use this time around, but we did recognise that we didn't see it was plausible to be brought in before 2030.
Yep.
So the report reflects that.
Yep.
Beyond that time, we're maintaining a watching brief. We don't have a position one way or the other as to whether it will occur, but we're just trying to understand those costs as more deployments take place. So I'll see if Mr Graham wants to add anything to that.
Yeah, what's happened in terms of that current policy scenario is that represents that scenario changes as people's current policies get updated. So, and we look at the International Energy Agency's World Energy Outlook, and they update the various policies that they're including as current existing policies. So, as we've gone to update GenCost, that scenario has become more stringent in terms of the amount of emission abatement in the current policy scenario, and it probably will continue. That'll continue to happen over time as governments globally, ramp up their policies. So what's happened with this latest GenCost report is, because we've got a more stringent current policy scenarios, nuclear SMR has come in a bit sooner and been deployed in that scenario, whereas when we ran it in the previous version of the report, it wasn't deployed. And because it is deployed, the cost reduction in that scenario is lower.
I'll come back to that last point. I just was a little bit confused with the word stringent. What does that mean in this context?
So every scenario that we include, from current policies to global net zero by 2050 or global net zero by post-2050. Those represent global emission pathways, essentially. And the current policies pathway is a steeper emission reduction pathway than it was when we ran GenCost the previous year.
Right, so that
we say it's
encourages
more stringent. That's the another way of
encourages
saying that.
more low emission sources, effectively. Okay, I understand that. Just that last point you made about it reduces in cost. One of the changes seems to be from the previous GenCost to this one is the learning rate for nuclear. So I believe in July last year the learning rate at just 3%, I think. From memory, and then it's now, I think, up to 20 in the initial development phase and 10% in the mature phase. Could you just explain? Is that correct? Have you increased the assumptions around the cost reductions or the learning rate, in other terms, for nuclear? And if so, why have you done that, and what basis has that been changed?
I don't think those have changed, but maybe there's a bit of confusion. We have conventional nuclear in our global electricity model.
Right.
And because that's a more mature technology, it gets a lower learning rate, something like maybe the 3% that you mentioned. Nuclear SMR we regard as a newer technology with greater opportunities to reduce its costs. And so it gets a higher learning rate of sort of 10 to 20% or something of that order.
Yeah, so I'm looking at page 24 in the consultation draft, if you've got that in front of you. And that's got the the learning rate at 30, is it 30? 20, sorry, 20 for the development phase and 10 for the mature phase.
Senator Canavan, can I just ask whether a couple more questions would conclude
it won't be long.
Yeah, sure.
It won't be long. And I'm just trying to find the equivalent table in the previous report. I've got it. Oh, keep jumping. So, yes, I think you're right. I think you're right because it's just described as SMA. You've changed the actual designation of it in the table. So you haven't changed the learning rates there. Right. Okay.
That's
so
correct.
what is driving the cost? Because that raises another question for me. Sorry, Chair. It'll just be one question. In the GenCost in July, you seem to have that current policy scenario drops the cost of nuclear down to around $8,000 a kilowatt, I think. Whereas in the previous report it was $18,000. It was a lot higher. So what causes that drop if the learning rates haven't changed?
Yeah, so the learning rates are there, but you can't, if you like, have that learning unless the technology is deployed, and it just wasn't deployed when we ran the scenario last year.
Right.
You can only get these cost reductions if you deploy the technology.
Okay, just one more follow-up then. Okay, I got that. On that chart that I was referring to on page 40 of the the December report, the consultation draft, you get that initial drop in costs. I'm looking at the lines that drop down, but then it's just flat lines. But I thought in that table you had a learning rate of 10% in the mature phase. Why are there no more cost reductions for nuclear SMR after about 2034 or so?
And this is not unique to nuclear SMR, but some technologies have a period where they're needed by particular countries and they're deployed, but then at some later point they'll switch to some other technological solution. So when it goes flat like that, it just means deployment for some reason stopped and some other technology was deployed instead.
Is that an endogenous change, or is that
that's a choice the model is making? Yes, that's
it's exogenous.
Endogenous.
Sorry.
It's endogenous. It's a choice that the model is making.
What drives that? What drives if the costs have come down considerably, the deployed costs have come down, then they stop using it. Well, I don't quite understand how that would work.
The costs of lots of different technologies are changing at different points in time, so it just makes sense to invest in some at some points and in others.
But this is like it's like a cliff, and then it goes like that. Normally, in most economic models, you'd see a marginal change. What causes the big shift change there?
Technology.
That's endogenous. That doesn't really seem to make a lot of sense to me.
Technologies that don't have much of a current level of deployment, it's easy for them to double their capacity. So those learning rates are the learning rate you get for every doubling of your cumulative capacity. So if you're starting from a very low capacity, it's easy to double your capacity and get really quick cost reductions. but then over time it gets harder to double.
I appreciate the discussion, Mr. Graham. You're just confirming my complete cynicism in all economic models. I say that as someone who's built them myself, they're usually a total load of rubbish. But thank you for outlining all of that. Thank you.
So the lowest possible cost for SMRs in that report, $8,000 a kilowatt hour, is that what you said?
No, it's not now, Minister, but happy to read through it. I believe that's I'll happy with Mr. Graham to answer your question, even though that's not usually the done thing, but I'll ask it on your behalf. That graph is that graph on page 40 is dollars per kilowatt of installed capacity, not kilowatt per hour.
Okay.
I didn't see a kilowatt hour per figure, but happy to take it on notice.
Senator, I do think
extraordinary proposition, really.
But there's very low fuel costs.
I do think Senator Canavan, Minister. I do thank Senator Canavan for kindly agreeing to conclude his questions. I'll remind senators that we're 20 minutes over time. It's getting very, very late. We're getting very, very tired. I've got 2 senators who do have questions. Just to remind senators we're moving in 10-minute blocks. And Senator Roberts, you have the call.
Thank you, Chair. Thank you for appearing again tonight. I've got 4 segments, but by the sound of that, I'll probably only get to 2. So, one. Very briefly, Minister, I'll be asking about CSIRO reports and then asking the CSIRO about energy generation. Minister, the government's climate and related energy policies, in compliance with the UN's 2050 net zero dictate, have a huge effect on our economy and incur huge costs to the budget and to the people, particularly workers in mining and manufacturing. Firstly, ministers in this government and in previous LNP governments have said they take advice on the scientific basis for climate policy and legislation from the Bureau of Meteorology and CSIRO. So I'm now going to ask some specific fundamental questions about the basis of your policy and legislation that's severely impacting budgets and our national economy. Now, MPs across parties have advised me in writing that they have never been given scientific evidence for cutting human production of carbon dioxide. Others, including ministers, have advised me in writing others advocating cuts and climate-related changes to energy policy have been unable to provide the evidence and underpinning their policies and legislation. The evidence that the Minister gave to me at Monday's Bureau of Meteorology session made it very clear and proved that the government does not understand what is science. So my Freedom of Information requests and parliamentary library searches have failed to find any Bureau or CSIRO reports to ministers or MPs providing the logical scientific points with the empirical scientific data showing that carbon dioxide from human activity needs to be cut. So I'd like to table this document that I made. It's only summarising what I'm about to read. So it's very, very clear what I would like from you, Minister. Senator McAllister took this during the BOM session. My constituents and I need to know the scientific basis for your climate and energy policy and legislation. On notice, please provide CSIRO reports, scientific papers, government papers that provide logical scientific points as the basis for your government's climate and energy policy and legislation. A logical scientific point, this seems to be missed by many politicians, a logical scientific point is empirical data within a scientific logical framework that quantifies the specific effect of carbon dioxide from human activity on climate as the basis for policy. That is, per unit of carbon dioxide from human activity, what is the effect on atmospheric temperature, ocean temperature, severe weather storms or other climate variables? In each case, please specify the report title and the specific page numbers presenting the logical scientific points on which you rely. That's my first question.
Well, Senator Will, I suppose examine your note. There is, as you know, an overwhelming scientific consensus on the questions that you raise. I suspect that no amount of information that could be provided to you would satisfy you on these questions. But in the interest of time, and I see that you've asked for this to be on notice, I'll see whether it's possible to provide you with a series of reports that go to these questions, but I suspect that you'll be back at future estimates asking fundamentally the same question, and that no amount of reports or other material will satisfy you.
Well, Senator, I note that that's an implied smear, but it doesn't bother me because
I've sat in estimates with you many times. You've asked the same question over and over again, and there is overwhelming evidence base and scientific consensus on these questions. I'm not a scientist.
No, but see, all I'm asking for is the reports that CSIRO has provided.
And you've asked for them on notice, and we'll try and one more time try and satisfy you again.
Senator Roberts, the minister's agreed to take it on notice and ask you to continue your questions.
Second one is along the same vein. Where is the cost-benefit analysis for developing and assessing policy alternatives? So on notice, could you please provide that, the cost-benefit analysis that's been done to justify the climate and related energy policies?
At this late stage, I think the Chair will be very grateful if I don't offer any commentary.
Okay. Third question, but I take it that you're going to take that on notice?
Sure.
Thank you. Third question, same thing on notice. Please, what is the specific quantified effect of carbon dioxide from human activity on climate? This is essential, Minister, for measuring progress implementing policy and tracking policy impacts and effectiveness. So on notice, could you please provide that?
We'll do our best, Senator.
Thank you. Now I turn to CSIRO. How many minutes do I have left, Chair?
5.
Oh, thank you. This may have been covered by Senator McDonald in some parts. Energy primacy is fundamental for human progress. It's basic for human progress. Now, there's a huge budget effect on the climate and energy related energy policies that are going through, and that has a multiplier effect throughout the economy. So I'm very interested in your Gen Cost 22. Could you briefly explain the new build methodology referenced in Gen Cost 22 and exactly what this means?
So, Senator, when you're saying new build methodology, you're talking about the learning curves, or can you be a bit more specific?
Yes, how you put together Gen Cost 22. What are the fundamental basics, principles and the methodology you've used to assemble Gen Cost 22?
So I'll kick off and I'll ask Mr Graham to add some more. So we do a number of things with Gen Cost. The first one, we do levelised cost of electricity analyses, where you're just looking at each particular technology, understanding the inputs in terms of capital, operating costs, and we also try to include what are the firming costs that come with the renewable or the variable technologies, and then you can calculate a levelised cost of electricity. So it gives you a bit of one method of comparing each of these technologies as they go forward, and that's done for the benefit of AEMO, who use that as part of their integrated system planning work. So we do that analysis based on the best updates we can get on costs and from engineering companies and from the industry. The second part that we do is looking at some scenario work when you bring it together in the system and trying to understand how might that look as you do various projections forward. So it's the two pieces of work.
Okay, thank you. Gen Cost 22 assumes a future reduction in unit costs of large-scale solar and battery storage of 48% and 58% respectively. This compares with a predicted reduction for onshore wind of 8% and 3% for coal. What do you base this more than halving of unit costs for wind, solar and batteries, given lithium is over 10 times, I think it's 13 times, more expensive today than just 2 years ago?
So the methodology that's being used as you go through there is this learning curve methodology, and it looks at both the historical data that's actually occurring as people build things, and then uses the maturity level as well, understand will that curve continue or will it start to flatten out. So that's the underlying methodology that we're using. Mr Graham might want to elaborate on that.
Dr Mayfield. So what I'm understanding from your message is that onshore wind and coal are well down the learning curve, and so there's going to be little opportunity for improvement.
They're more mature, so the opportunities are less, and the learning occurs as you build out. So Mr Graham mentioned before, as you build out more and more capacity, you get the chance to learn, but as you get more mature, that does slow up.
It's also volume, Senator. There's been a lot of wind turbines made
economies of
around
scale.
the
Do you want to add?
Yeah, I could just add that, I mean, we had, when we were starting GenCost, we did think about lots of different forecasting approaches, and there are different ones. You can do expert surveys, you can extrapolate through time what you've seen historically. The learning curve approach appealed to us because it's more scientific based in the sense that you can point at historical data and observe technology learning rates as a physical fact. Not all of them, so new technologies don't have such an historical record, but even in that case, you can look at the learning curves that other new technologies went through, and it turns out they all go through kind of fairly similar stages. So it just suits us as a science organisation to have a basis of projection that you can look back in fact on the basis of that, of how the method's implemented.
Okay, thank you.
Senator Roberts, you're at time, but do you have one final
Just
question?
one final question. I've got many others, I'll put them on notice. GenCost 22 assumes capacity factors of 40% for wind and 26% for solar. For financial year 2022, the national electricity market capacity factors are actually 29% compared to your assumed 40% for wind, and for solar, 19% compared to your assumed 26%. And I understand that the peak time capacity factors for solar and wind are both less than 10%, and that's crucial for reliability at peak times. Now, those are significant differences. So your assumed capacity for wind is 50% higher than the actual history on the NEM. These are very big margins of error when we need very precise generation for our energy market. Why are you so optimistic about the capacity factors compared to real-world data?
So 2 points to note there. When AEMO, for example, does any modelling of the electricity markets, they don't use the GenCost capacity factors. They use their own renewable energy zone, half-hourly, detailed weather-based capacity factors for each renewable energy zone in the NEM. The purpose of the capacity factors in our report, in GenCost, is we're trying to give people a range of the future levelised cost of each of the technologies. And when we're doing that, we want to look at, for a new, relatively new technology, what's the range of potential capacity factors that it could achieve, keeping in mind that that's probably going to be a bit better than historical, because historical technologies just aren't as good. You know, technology gets better over time. So the range that we use in GenCost is about new technologies being deployed in the future, and they will be a bit better than the historical average.
So there's an assumption they will be better?
Yeah, based on observation that technologies do get better, yeah.
Okay. Thank you very much, Chair.
Thank you, Senator Roberts. Thank you for your answers as well. And Senator Cox, you have the call.
Thank you, Chair. I asked some questions in relation to comments made recently by Professor Andrew McIntosh in relation to a report from Jazeera in relation to the claims of the life cycle greenhouse gas emissions from the fracking industry in the Beetaloo Basin. Can you outline for me the peer review process in relation to this report?
So, Senator, I can kick that off for you. So, with the work that's been done there, so you're referring to the offsets report for Northern Territory?
Yes.
So we apply our normal peer review process on that work. So we have internal peer review, and we use specific experts where required as well. So that work has undertaken that process. The work that was done there also has been based on updated research that we've reported through to the Climate Change Authority recently on different sequestration techniques, and we're very comfortable with the peer review that's taken place and the quality of the work that's there. We understand Professor McIntosh disagrees, but we've been through a full peer review process.
Professor McIntosh claims that this report should be rewritten. What's CSIRO's response to this?
We disagree with him.
Sorry, what was that?
We disagree with him.
Okay. What's CSIRO's response in the claims that Jazeera and this report was unduly influenced by the gas industry?
So the work that gets done through Jazeera, the whole governance model that we apply there is about making sure that the work that's commissioned is commissioned in an independent way. So the research advisory committees for each state determine what work gets done. They have a community representation that has a casting, or that has the majority vote in there, so it's actually done by community. CSIRO delivers that work and applies its peer review processes. So there is no opportunity for industry to influence that, either at the determining the scope of work that we do or for how we report it. They do contribute some money. In the Northern Territory case, it's about 3% of the budget that we use.
So, correct me if I'm wrong, so there's an internal peer review, not external? Is that correct?
It can be mixed, so I can, in terms of the specific peer review process that's applied, so I have Dr Barrett from our resources program here,
yes,
and he can talk you through the specifics of the
That'd be great.
peer review.
Thank you, Dr Mayfield.
Thank you, Damien Barrett, Research Director for Energy Resources in CSIRO. The particular research report that you're talking about, commonly called the Offsets Report, that report was brought together in a series of stages. A very important and key component of that work was the work done around the life cycle emissions for the development scenarios in the Beetaloo Basin. We took the scenarios for development from the Asil Allen report that was used in the Northern Territory Hydraulic Fracturing Inquiry, and we took the uppermost emissions level, so what was referred to as the GALE, which is a scenario which was about 1,000 terajoules a day gas production. Utilising that scenario for development, we then generated the emissions scenarios, and that was done through a third party in conjunction with CSIRO called Life Cycles Proprietary Limited. They specialise in these types of analyses. That component, the report that was generated out of that, was reviewed by 3 scientists, 2 from Curtin University in Western Australia and a third scientist involved in, he's a principal scientist in Life Cycle Works. That formed the core in terms of the emissions estimates that were generated in that particular, in the offset study. The abatement options were, in particular the land abatement options, were taken from a study that was done in 2020 by Roxburgh et al. It's a CSIRO piece of work, and the land abatement potential was dependent on the availability of land, the potential for carbon gain on that land, and the economic viability of those offsets. All of that information then came into the final offset report, which was then went through the standard CSIRO peer review process internally. It was reviewed in relation to another report that CSIRO produced for the Climate Change Authority, and then the final report was released last week. So that was the process of how it was all brought together and the review process that happened throughout that piece of work.
In relation to that, Dr Barrett, are any of the, say, financial contributors to development of this report, any of the proponents or title holders for Beetaloo Basin's licences currently exist or contracts?
So the contributors to the funding of that work include the Commonwealth Government, the Northern Territory Government, CSIRO and the industry who are operating in that region. because they are members of Jazeera. In that particular study,
well, I'm asking specifically about title holders and proponents that have an invested interest, commonly known as state capture, because people, you know, the claim has been made about the report being unduly influenced by gas companies that are operating in the Beetaloo Basin. So you know, giving me a blanket statement like it's industry doesn't allow me to see who's contributing financially and may have a level of influence on the outcome of a very important report talking about the life cycle of greenhouse gas emissions, particularly in the Beetaloo Basin.
So the most important aspect in terms of the governance model there is that the contributions from all the parties, be it the gas industry, be it the state government or territory government in that case, the Commonwealth and CSIRO, all of those contributions essentially go into a pot, they're combined. And it's the Community-Dominated Research Advisory Committee that determine whether or not a project is funded. And if that committee does decide that the project is funded, then under the terms of the Jazeera Alliance Agreement, that project must go through to its finish and it must be 100% transparent. And there is no opportunity for any of the other members other than the researchers to make edits or review or change any of the contents of the reports that are produced.
Okay. Thank you for clarifying that. Can I ask some questions quickly just about the Airbus Avalon Air Show? Maybe to the Minister. You want to answer this? I'd like to ask some questions about CSIRO's involvement in the Avalon Air Show, noting that CSIRO is scheduled to make several presentations at this event. The topics, which seem pretty tame compared to the rest of the program, is CSIRO aware of the links of this event to the defence and military?
It sounds like a question for the CSIRO.
Sorry, Minister.
It sounds like a question that the CSIRO can answer. I'm unaware of either the air show or the program.
Well, it's, you know, are you aware of the program and the links that it has to defence and military?
I think CSIRO is in a position to fill you in.
You know, it's pretty much classed as an arms fair if you have a look into the detail of what's actually being showcased at the Avalon Air Show.
I'll let the CEO answer the question.
Senator, our primary work with companies like Boeing, it goes back to, I think, to the 60s when there was a concern that supersonic or high altitude aircraft would be damaging the ozone layer. And CSIRO did some of the first research in the world to determine whether that was the case or not. And fortunately, it's not. So we're able to fly between countries now. And since that time, we've worked on environmental aspects of Boeing's manufacture to make them more environmentally sustainable. We worked on safety equipment. And today, every single Boeing aircraft has a unique Australian material called top coat that makes the manufacturing process more sustainable and more efficient. So that's generally we work with companies to achieve basically national benefit for Australia. Boeing today, because of the relationship with CSIRO, employs over 4,000 engineers in Australia rather than having their own in the US where they're headquartered. So it's a great example of attracting a big company to come in and create jobs and economic growth in the country.
Okay. But given this is, you know, looking at the detail of quite clearly what is, you know, trying to justify CSIRO's involvement, do you think that fits with the purpose of what our National Science Agency should be attached to, is an arms fair?
Well, Senator,
do you think that then now in the evolution of that relationship actually represents that?
So, Senator, I think I mentioned that one thing out of the opening statement about the net zero mission. As you're probably aware, emissions from aviation are in that hardest to abate category. And Boeing and Qantas very kindly supported us to come up with a roadmap for getting to net zero in aviation that involves biofuels and hydrogen production, which we think, hydrogen production, for example, we think could be a $50 billion export industry for Australia, which is really important given the world is sort of slowly but surely stopping buying our coal and gas. We'd like to create some export industry to replace that so that those jobs aren't lost and that economic value isn't lost. So again, I'm aware that the Avalon Air Show has a military presence. It also has a very strong civilian presence. Our interest is in how aerospace can help create jobs and economic growth in Australia.
Okay, thank you. One final question?
Yep, you're at time, but one final question.
Yes. Just in relation to the enhanced oil recovery projects, hard to say at this hour of the night. Have public servants employed by CSIRO been working on the enhanced, EOR projects?
Can you specify which EOR projects you're talking about? Like we work on CCS,
yep.
Which in the US they use carbon dioxide injection for EOR, but we don't do that in Australia as a rule. So I'm not quite sure which projects you're referring to.
Okay. I believe that there was a link there that that there was some money spent on research in enhanced oil recovery projects. Is that correct?
Enhanced
oil
recovery.
I would have to check on that for you, Senator.
Okay. I'm happy for you to take these on notice and get back to me about those.
It could be related to our CCS work, which is all about emissions reduction.
Okay, that's probably what it's in relation to then. I'm happy to put them on notice, given the time of the night. Thank you, Chair.
That would be appreciated. Thank you very much, Senator Cox. And that concludes the questions. It doesn't conclude the questions that we have.
Sorry, I've been waiting patiently.
We didn't catch each other's eyes. Senator McDonald, you have the call.
I will be very brief. I just wanted to ask you, the CSIRO had an investment with V2 Foods, and you know that there's been an article today in Beef Central confirming that the factory at Wodonga has been closed. What's been the exposure to CSIRO of that investment? Is that something that... tell me about what that means for CSIRO.
Oh, Senator, as far as I'm aware, and I haven't looked at the numbers in the last month, but as far as I'm aware, the value of V2 Foods is well over $500 million. So we have a small equity investment because we actually created that company to create jobs in Australia. So it's been a really positive thing for us, but I'm not aware of the closing of the factory in Wodonga, so I'd have to get back to you on that.
Okay, thank you. That was, yes, is breaking news just today that they have made the decision to close the Wodonga plant, and I guess, perhaps your investment arm hasn't had an opportunity to brief you, but given that CSIRO put money into it, they will no doubt give you an update of what's happened to that.
Yes, so, Senator, we actually built the pilot manufacturing line in Werribee, and that was one of the reasons we were able to so quickly create the entity. But as it grew bigger and bigger, because Woolworths and Hungry Jack's now distribute those products, it's been a great Australian agriculture innovation success story.
Well, you know that after doing a meat definitions inquiry, I probably have, though I have to say V2 never held itself out to use meat terminology, so it was perhaps others. Can I also just ask you, you're doing some research into cow-free milk. Could you talk to me about that?
There's another company we created, Senator, called Eden Brew, and it's also a plant-based milk alternative for people who are lactose intolerant. So in the same way, and we've tried to be very careful, if I can go back to V2, one of the things that we really dug into before we started was to ensure that it would be additive to agriculture. We've a mission to try and get Australian ag exports well over 100 billion by the end of the decade. And so we only sort of want to do things that are going to be additive, not competitive. And the data that Hungry Jack's and Woolworths shared with us was the percentage of vegetarians and vegans that wanted to buy some sort of meat alternative was growing. So we served into that market, and it was them that actually led us to the milk alternative as well. Because there's a number of alternatives, almond milk and soy milk.
They're not juice. They're not milk.
Australia has a really interesting advantage because we can grow very, very reliably high quality, safe, healthy plant-based material that we can then use to get into the market in Asia, where there's a lot of lactose intolerance. But again, we want it to be additive to Australia's exports because we have this 100 billion export goal.
All right, well, if on notice you'd give me a response to what's the impact to CSIRO, thank you, V2 Food, and and perhaps an update on where you're up to with the cow-free milk investment. And I also just want to make a comment on how patient you've been, Chair. It has been a pleasure at sometimes a very trying day. So thank you. Good job.
Thank you for the feedback, Senator McDonald.
Thanks, Chair.
That's very totally respectful and polite.
Thank you, Senator O'Neill. That appears to conclude our questions and does indeed conclude our questions. So, Dr Marshall, thank you very much, as always. Thank you to your team for coming and answering our questions, and also for all of the work that you do. We appreciate it, and you go with our thanks. And I will now adjourn the hearing. There being no further questions at this time, the committee's consideration of the 22-23 supplementary budget estimates will conclude. I thank Minister Ayres and officers of the Department of Industry, Science, Energy and Resources portfolio and related agencies who've given evidence to the committee today. Thank you also to Hansard, to Broadcasting, to the excellent committee secretariat. I declare the hearing adjourned.
Well done, Chair. Thank you.